Welcome to the second public hearing for the further inquiry into the regulation of building standards. Before I commence, I'd like to acknowledge the Gadigal people, who are the traditional owners and custodians of the land upon which the Parliament sits, and pay our collective respects to elders past, present and emerging, and extend that respect to other Aboriginal peoples present or on the webcast. Today we'll be hearing from a number of panels of important stakeholders to this inquiry. First, the Strata Community Association New South Wales and Owners Corporation Network. Second, the Australian Institute of Architects, the National Fire Industry Association, the Design Institute of Australia and Network Architectural. Third, the Urban Development Institute of Australia, New South Wales Division and the Property Council of Australia. Fourth, key unions, the Plumbing Trades Employees Union, the Fire Brigade Employees Union. And finally, we'll be hearing from the very busy New South Wales Building Commissioner and Better Regulation Division of the Department of Customer Service, as well as Fire and Rescue. I'd like to thank everyone for taking the time to give their evidence to this important inquiry today. Before we commence the witnesses, I'd like to make some brief comments about the procedures for today's hearing. Today's hearing is being broadcast live via the Parliament's website. A transcript of the hearing will be placed on the committee's website when it becomes available. In accordance with broadcasting guidelines, media representatives are reminded they must take responsibility for what they publish about today's proceedings. While parliamentary privilege applies to what witnesses say in evidence today, it does not apply to what is said outside their evidence at the hearing. I therefore urge witnesses to be careful about comments you make to the media or others after you complete your evidence. I note that committee hearings are not intended to be a forum to make adverse reflections on individuals, so if we could please, wherever possible, stick to the issues and the terms of reference. All witnesses have a right to procedural fairness in accordance with the resolution adopted by the House in 2018. There may be some questions that you can only answer with some further materials to hand, in which case please indicate you'd like to take the question on notice, in which case you have 21 days to provide a written answer. If witnesses wish to hand up documents, please do so through the committee staff who are here to help and assist throughout the day. In terms of audibility of today's hearing, I'd remind committee members and witnesses to speak into the long microphone. And if we have witnesses appearing on video conference, to be careful about toggling on and off the mute. Finally, could everybody please turn their mobile phones to silent for the duration of the hearing. I'd now like to welcome our first witnesses from the Strata Community Association of New South Wales and the Owners Corporation Network. Could each witness, perhaps starting from my left with you, Ms. Stiles, please state your name, position, title, and then take either an oath or affirmation.
Karen Stiles, Executive Director, Owners Corporation Network of Australia. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thanks, Ms. Stiles. Mr. Duggan.
Chris Duggan, President, Strata Community Association, New South Wales. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth. So help me God.
Thanks, Mr. Duggan. Mr. Burrell.
Thank you. Stephen Burrell, Vice President of Strata Community Association, New South Wales. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thanks, Mr. Burrell. Mr. Stanton.
Thank you. Banjo Stanton, Solicitor assisting the Owners Corporation Network. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thanks very much. Could I thank you all for your time today and for your submissions that you've provided. We have digested the submissions, but now is an opportunity, if you'd like, to provide a brief opening statement. I might look to you first, Ms. Stiles.
I think it's important to note that building defects don't just cause damage to the building and its fabric. They can destroy people's lives. The damage doesn't just stop the day people are evacuated. It is merely the beginning of years and years and years of enormous suffering. It is incredibly important that we address these building defects. Thank you.
Thanks very much, Ms. Stiles.
Just referencing our application, on behalf of SCA New South Wales, the continual liaison with the Minister for Better Regulation, the Office of the Building Commissioner of Fair Trading on matters concerning the construction and strata sector have proven to date productive, resulting in a program of reforms from both the Minister and industry to improve building regulation. The establishment of Project Remediate with the aim of effectively rectifying flammable cladding where it is discovered on strata title buildings is one such example of this drive for reform undertaken by the government towards the benefit of owners and occupiers in strata communities. SCA New South Wales, represented by Stephen and myself today, have been heavily involved and engaged with many constructive meetings and discussions with the program's development, and we're happy to talk to our experiences with the panel today.
Thanks, Mr. Duggan. And I'm assuming that is the
That's my position
opening
as well.
for you too,
Yeah.
Mr. Burrell. And Mr.
Thank you.
Stanton, did you have anything to add on behalf of the Owners Corporation?
Thank you. The Owners Corporation Network submission essentially says that there's been a lot of good work done in the last 2 years, and we acknowledge that there's a lot of good reform that's still underway and heading in the right direction. Our submission highlights some aspects of the reforms already implemented or being implemented that need improvement, and also some aspects that are significant that haven't been addressed yet. In relation to the Design and Building Practitioners Act, essentially covers transparency issues, the aspects of the building services and other building elements not covered by the Act currently, and a particular problem for the design of waterproofing repair works that's emerged more recently and is causing a lot of angst as we speak. There's also, in relation to the Residential Apartment Buildings Act, some problems with the provisions for building works repair orders. There's a real life example that's recently emerged of the exact issues that are referred to in our submission. In relation to the Home Building Act, there are a number of issues pointed out. Probably the most important current one is the lack of a fit-for-purpose licence for builders building over 3 stories.
Yeah, well, I think all of this we'll explore in the next hour, but I might just hand over to the opposition to kick questioning off.
Thanks very much, Mr. Chair, and can I thank you, all of you, for your time this morning, and particularly for your submissions as well, which have been really informative for us. I wanted to start really where Ms. Stiles began, which is the question of defects. Obviously, this is our second hearing, and we're looking our second inquiry, and we're looking more focused on cladding. But the broader question of defects is one that is really something that is confronting our apartment owners. Can you just explain a little bit, Ms. Stiles, and then also Mr. Duggan, about the scale of the defects issues that are being faced by apartment owners?
It's a tsunami of building defects that people have been suffering through for the past 2 decades. A variety of those, but with waterproofing and fire safety being the most prevalent and also the most expensive and difficult to fix, and clearly life-threatening when you add that to flammable cladding.
And what are some of the issues with waterproofing? I mean, Mr. Stanton referenced the real-life example that illustrated your submission. Can you speak about some of those issues that are being faced by waterproofing issues first?
I can think of an elderly couple who had to build a moat in their living room to keep the water in so that they could hoover it up when it rained so that it didn't flood the building. People are living with black mould. There are enormous problems. There are bathrooms, there are building fabrics, it's balcony falls, you name it, it's a problem.
And in terms of the fire safety, what are the most common challenges that you hear from your members?
That's more tricky because it's not as obvious. A lot of the issues are actually covered up and may not be found until the developer appointed fire inspectors have been replaced by new people who are perhaps more diligent. But fire separation is a big one. I've got evidence of the water not being hooked up to the fire hydrants. Again, it's a gamut of things. I have to say, in the last few years, the government has worked hard on an accreditation system for fire safety practitioners, and that is to be welcomed. And waterproofing is something that is in the Building Commissioner's sights, and that is also to be applauded. It's an incredible problem for people, and it just goes on for decades. In fact, I've got a building now where they're still negotiating with the builder 10 years after occupation to repair waterproofing issues into their building.
Yeah, and obviously these are, like you say, these are the issues that are often behind the walls that are more difficult to see, and then obviously once they actually do become apparent, are much more serious to actually address. So
bathroom waterproofing can become apparent when the ceiling below collapses with the weight of the water.
Thanks very much, Ms. Stiles. Mr. Duggan, so I'll just take you back to the beginning, which is, what's the sort of scale of defects and what are the most common defects that you...
It's an interesting question on the scale. So SCA, in conjunction with the Office of Building Commissioner, interviewed and surveyed the majority of our members to determine their experience and also the experience on behalf of their clients. As a result of that, it identified that 39% of buildings had identified a serious defect. The survey then went into much more detail around the experience of consumer through the lens of a strata manager who is managing that process and the success or otherwise of the legal process. And that's been used as a benchmark by the Building Commissioner and certainly by SCA to hopefully see an improvement in the process of defects, particularly as they're experienced by owners. We also conducted a similar research project with University of New South Wales City Futures, and a similar number came back. So what we all understand to be the case is now proven with data, and we're hoping that that data, particularly as the reform agenda of the Building Commissioner continues, gets played out with obviously a reduction in that amount of defects.
And how did you classify the serious defects?
Excellent question. I've just got a copy of it here, only because it was quite a detailed survey. So serious defects went into, and further to what Karen has said, waterproofing was the most prevalent of those, occurring in 23% of the instances reported, followed by fire safety, so two themes obviously of this commission, and then external enclosures, so the building fabric and structure. So they're major elements of the building that, if unrectified, impact the habitability and the livability of those apartments.
Yeah, absolutely. So you said that, obviously this question of historic defects is going to be a key one going forward. Have you had any discussions, or do you have any solutions for how we could rectify those historical defects?
Yeah, historical defects are more challenging. I note the last time we were before this committee, we obviously had a list or a wish list of items that we wanted the government to implement. Pleasingly, and I think as echoed by what Karen said, the appointment of the Building Commissioner kicked off the vast majority of those reforms. And reflecting back on our SCA's checklist, we've seen most, if not all, of those commence. Regrettably, not a lot of those are applicable for existing buildings. And besides being able to clean up the legal process by education and also by facilitating some sort of a streamlined approach, most of those reforms are going to impact buildings yet to be complete.
Yeah, and that's the question, I guess, that we come to, which is these solutions about even requirements around cladding, requirements around certification going forward, decennial insurance, rating systems. These are all great initiatives, but they're for buildings that are either being built or yet to be built. What are we doing about all of those buildings that have been built over the last 10 years, 20 years, and the defects that are, and as Ms. Stiles said, are very serious, that are bubbling to the surface? So
cladding is a classic example of its retrospective activity. So obviously all of those buildings that are impacted are part of the Project Remediate plan, and we can talk about that one in detail. The Design and Building Practitioners Act opens up further recourse for litigation against different parties. Probably more a legal technical aspect, and I'll let Mr. Stanton refer to exactly how that opens it up, but it expands effectively the ability to pursue a party outside of the Home Building Act statutory warranties on occasion, depending on applicability. I'm just trying to think of what else. Anything else do you think?
There's the fair trading process that's open now for schemes.
Lodging defects, yeah. So a beefed up fair trading review process and also their staffing to enable buildings to be able to get quick, easy, low-cost access to whether they be building certifiers or fair trading is another avenue available for existing buildings.
Mr. Duggan, you talk about Project Remediate dealing with, the historical issues about cladding, and your submission, brief as it is on this point, is supportive of Project Remediate. The position adopted by Ms. Stiles and Mr. Stanton, though, is, and it's consistent with a lot of submissions we've had, is that Project Remediate deals with only a tiny fraction of the historic cladding problems. Do you agree with that?
It deals with the high-risk buildings, so I'll have to trust that the experts who identified those buildings as requiring it to come off have captured those, but it's 220-odd buildings that are so far applicable for the scheme.
Yeah, but there are thousands of buildings with flammable cladding on them. Many homeowners, commercial owners, still dealing and grappling with getting their flammable cladding removed, but they're not in Project Remediate. Do you talk to any of them?
I can't talk to buildings that are not deemed high risk because I think the majority of the buildings that we've seen through our membership so far that are on that register have applicability for Project Remediate. Whether they've proceeded with it is a matter of timing in some cases, or they're in the process of having Project Remediate apply to them.
Have any of them actually been remediated under Project Remediate? That you're aware
Not
of?
complete, no.
You say not complete?
No.
Have any of them had the cladding removed, the flammable cladding removed?
No, apart from the first project, which more recently had its first panels removed, I don't believe so.
That happened during the press conference?
A couple of weeks ago, so if that was during the press conference, yeah.
Apart from the 2 panels that removed during a press conference, you're not aware of any actual flammable cladding being removed?
Not via Project Remediate. There are instances of buildings that have removed their own cladding because they commenced prior to the project's commencement, but not through Remediate.
Are you aware of a program of further press conferences to get this sorted out throughout New South Wales?
Not that I could answer.
Yeah.
Can I just
Stiles?
ask one follow-up question to that, which is, you said that there are a number of buildings who have already started.
Yes.
Do you have any sense of how many of those buildings have started? We received a submission from a Strata committee that had already signed contracts and started the process before Project Remediate began, and in order to access Project Remediate, they'd have to lose that $100,000 that they've already spent to opt into the system. Are you aware of how many of those buildings are out there?
I couldn't tell you the exact number. We're aware through our membership of a number of them, but I don't know the exact number. We can come back if you'd like with further information.
Yeah, that would be really helpful. Any kind of, a number of buildings who have started.
Who have commenced prior to Project Remediate.
Yep.
Absolutely.
Thanks very much. Sorry, David.
Now, either Ms. Stiles or Ms. Stanton, do you have any observations on those buildings that aren't captured by Project Remediate and are having to remediate flammable cladding?
I know in one particular building, it's a very small building, and all of the people are retirees on fixed incomes, but it's 4 stories. They're very, very stressed. These are elderly people who don't understand the process, who are frightened for their lives because they're reading in the paper all the day about, the building could burn down in the middle of the night.
Ms. Cusack? Catherine, can you hear us? You're not coming through.
Yes, my apologies, David.
That's all right.
Thank you very much. I just wanted to ask a question about strata committees and how well equipped they are to deal with problems of this scale. I note the building collapse in Florida because the strata committee deeply divided over many years about what to do, and I just wondered if the witnesses would mind commenting on that governance issue. Thank you.
Who wants to kick that off? Ms. Stiles.
I would say that the expertise and capacity of strata committees varies wildly, from very competent in some buildings to completely dysfunctional. And these are issues that people don't buy a home to be dealing with. So they shouldn't have to be experts in building quality and building remediation.
Yes. Mr. Duggan, do you have any views about that?
No, I agree and I concur. I think the challenge with collective decision making is that it allows the full democracy to prevail. Therefore, you get people making decisions. They may not be best equipped to do so, but what we need to ensure is that they have access to professionals, that they have access to education, and obviously, ideally limiting their exposure to defects would be ideal. But when they do occur, having a robust process that's easily accessible.
We can also, and we've heard examples of it, where you have basically the oppression of the minority. If the defects are only being really felt by a minority of strata holders, they can find it extremely difficult to persuade the strata scheme to collectively contribute tens of thousands of dollars to fix defects. I suppose I might go to you, Mr. Stanton. In your practice, have you come across that at all?
Yes, there are buildings that there are large groups of owners that simply don't want to spend any money, and they don't understand that if they don't spend the money, it'll cost more money. Sometimes, particularly in some buildings, there are builders and developers who still own units, and their agendas get in the way of the decision making, or at least try to, and that cause a lot more angst. But it's really a case, as Ms Stiles said, that the range of expertise and understanding within the strata committees, and by extension the owners, varies widely.
Can I just
Can I ask?
a question to that?
Well, I'll go to Trevor and then you, Anthony.
Okay.
Is that okay?
Mr. Stanton and Ms Stiles, I suppose, being both a freestanding homeowner and also a unit owner, and my unit relatively recently having gone through an exercise of considerable expenditure on the replacement of the lifts on a 15-storey building, I'm left with the view that whilst Mr. Shoebridge paints one picture, you can get in a body corporate circumstance where there is just an honest difference of opinion, do you not, as to whether the gold-plated option is the best option or a lesser one. It doesn't mean necessarily one's right and one's wrong. Expending lots of money may not necessarily be an appropriate way forward. Would you not agree?
It depends what you're talking about. The example that you've raised, replacing a lift, is an example where there are gold-plated options and there are more economical options, and definitely room for disagreement on options that are both of which would be appropriate. When you're dealing with defects, there can be disagreement upon whether you go with a gold-plated approach or just an approach that will rectify the defect and not go further than that. But that's generally not what's occurring. And generally, it's unusual that an owners corporation is looking at a gold-plated approach for rectifying defects. They just want to get to what they have to do to meet their obligations and what it should have been in the first place. So usually the angst within a scheme about raising funds to repair defects or to chase culprits who might be liable for them if they're still around, it's not about the gold-plated option, or it's just about being able to fix defects at all.
Right, sorry, can I just ask something else? I heard reference to thousands of buildings in the context of cladding. I was just having a look at the New South Wales Cladding Task Force website. Do you agree with this, that there were some 185,000 building records audited and 4,182 buildings inspected, but in terms of those that are, in a sense, in the gun, there's some 380. Is that your understanding, Mr. Duggan?
There's 220 odd buildings that are participating or eligible to participate in Project Remediate. Right. I'm not sure of that other number you referenced there.
Well, what I've got here is there are 380 buildings in progress to be cleared. Now, I'm not quite certain what the term to be cleared means the buildings are at 4 different stages in the process, 4 awaiting update or assessment by the consent authority, 168 an expert assessment is in progress, 42 detailed remediation action plan requested from the building owner, 166 remediation is underway or has been ordered or approved by the consent authority. Do those numbers seem right?
They do, and I believe buildings which are not deemed high risk are still able to register and have their building assessed for Project Remediate. So perhaps that larger number is a combination of the high risk buildings identified by the government and other buildings which have voluntarily opted in to be assessed by the program.
So, Mr. Duggan, sorry, just one question on this. In terms of what's the classification of the other buildings that have been assessed then? So you've got the high risk buildings. Are there further classifications of risk that are attached?
Yeah, there are. I believe the numbers you're referring to there may relate to the original cladding register. So when the cladding register was first formed, these buildings were put into 3 categories, which is high risk, medium and low. And so the buildings that are deemed high risk, which Chris referenced, which is the 220, they relate to the buildings that are eligible for Remediate. Through the Remediate registration process, the Office of Building Commissioner has encouraged any building that might believe they have cladding to register and then be assessed as part of the process.
So that gets you to the 380?
Yep.
Okay.
Yep.
Well, the 380, my understanding is that there were, the government determined only would be class 2 residential buildings, so that winnowed it down straight away. And then there's an inspection process for those class 2 buildings that is to be undertaken. And the data that I think Mr. Khan's referring to is the data that says there was some 4,180 of those class 2 buildings to be assessed. And as of the 31st of August...
182.
Yes, 4,000. Thank you, Trevor, for tidying that up. As of the 31st of August 2021, only 3,802 had been assessed. And so there's another 380 that are still to even be assessed for whether or not they fit the high risk. And I think that's that data.
Yep.
But we might be able to clear that up with Mr. Tansey this afternoon. Mr. Diadam.
Coming back to the question around governance of owners' corporations, I wanted to ask, is it correct that there's some legal ambiguity about expending owners' corporation funds on those kind of governance training or even advocacy? Is that am I correct in understanding that there may be some ambiguity about that? Perhaps Mr. Stanton might be able to.
I don't think I've been privy to discussions around that, but there's certainly restrictions upon payments to committee members. So if a committee member's wanting to do courses that aren't free, but to invest costs to educate themselves, or, then that's at their own risk. The legislation allows the opportunity for the general meeting to approve an ex gratia payment to a committee member at the next annual general meeting. But if a committee member wants to spend $2,000 to do something so they can do their job better, they'll be taking the risk that they can't get that money back.
There's a collective benefit if the committee members are, fully cognizant of their responsibilities and are able to better discharge. So obviously training of committee members, there's a collective benefit that accrues to the management of building. Is there the sufficient flexibility in the legislative arrangements to enable that kind of expenditure to be made to try and improve the governance arrangements within a owners corporation, or to better improve the capacity of the committee to operate?
I'd have to take that question on notice, but off the bat, what I can say is that there are courses that have been put together by various organisations, including Fair Trading, and I think the Owners Corporation Network and possibly the Strata Community Association, which aim to provide free education for committee members and some online sort of courses which assist committee members. A problem is that most committee members don't have the time to invest a lot of time to upskill themselves. So they're volunteering their time on the committee, and they're doing what they can, but they don't have capacity to do much more. But whether there's the provision within the legislation for the owners corporation or the committee to decide to spend money for a particular person or all the committee members to do a course, I'd have to get back to you on that. But I mentioned the problem if a committee member spends their own money to educate themselves. But
Brill, I think you look like you're okay.
Yeah, well, I think perhaps a better way to answer the question is at the moment there's no formal requirement for Strata committee members to be trained. And to your point about education, I think it'd be very beneficial for the collective that they are trained and understand the responsibilities that they're signing up for. Because as Mr. Stanton said, this is a voluntary position, and often at a Strata meeting, owners will stick their hand up and go, it's a good idea to get on a committee because they want to get involved, but they don't necessarily understand the legal requirements that go, or the liabilities that go to being a Strata committee member.
Ms. Stiles, you look like you wanted to add something to this. No?
I want to also just going a bit further around the advocacy question, because I understand that there is, obviously there's a overarching sector benefit from having advocacy, but are owners corporations, my understanding was that there was some grey area around whether they can even affiliate to use owners corporation funds to affiliate to an organisation like the Owners Corporation Network. Is that correct?
I think there's a question around making donations, around owners corporations making donations, but we've not been apprised of any concerns about joining an organisation that can assist them, in investing money in that.
So accessing professional expertise and advocacy, you don't believe that there's any impediments to that? No. Okay.
Ms. Cusack had a question.
Yes, I wanted to follow up my earlier question.
Oh, Catherine, you've just dropped out. Can you hear us? I think we've lost Ms. Cusack, but
Problem with virtual parliament.
Well, yeah. We can cross that bridge when we get to it. This is the problem with the NBN, I would suggest. I'm a fibre to the home person, not a fibre to the node person.
This is the Senate campaign writ large.
But anyhow, I think what we've just got there is fibre to the node. But I think Ms. Cusack had a question. Oh, Catherine, you're back. Yes.
I think Catherine might be on 4G.
I'm wondering what percentage of Strata committees could be described as dysfunctional. The issue of committees not able to reach any decision at all, or reaching a decision, spending money going down that track, have an election, investors group or the residents group win the election, and then that strategy gets reversed the next group and more money gets spent on a different option. And nothing gets done.
I'll answer that question. Without a strata register and data collection by government, it's impossible to know what is happening in the strata sector generally. I can only speak to concerns that have been raised with me or that I've seen, but there's a general... I don't believe that most owners understand that firstly they are running a small to large business, and this is a very responsible position, and I don't think they understand that they are individually, jointly and severally liable for any expenses.
So if there's no accountability over time, is the answer to actually ensure that best decisions are made up front? And surely that starts with some kind of compulsory training so that there are at least an understanding of your duties and an understanding of the nature of the role. Do your organisations have a view about mandatory training?
May I address the question from Ms Cusack just in relation to governance as well and dysfunction? I think it's, as Karen has stated, there are a number of buildings which could be slated as dysfunctional. It's very difficult and subjective to determine how many. Ultimately, if they're significantly dysfunctional, there is a process where a compulsory manager can be appointed through NCAT, and that's where you would be able to define, obviously, the dysfunction to such an extent that they can't make decisions. Outside of that, it's very grey as to whether dysfunction is apathy, whether it is poor decision-making, whether it is good governance, because decisions are made every day in Strata by volunteer bodies. So it's very difficult to give a data point on that. Education is critical and the key. Whether compulsory education is the solution may be problematic because we already struggle significantly to get volunteers on strata committees. To further restrict their suitability through compulsory training may be challenging, but voluntary modules, funding from the government to support that, education, I think the defects case in point is that people have a significant awareness now of defects, unfortunately as a result of high profile defect cases, but certainly in a new building, when Stephen or I speak to owners and raise defects and the process that needs to be undertaken, it's no longer an education piece around why defects are bad for your building and why you need to pursue them. So I think that bringing out those defects into the light has enabled owners to come on that journey. I think more can be done with broader governance in the same regard.
But if we're...
Can I just follow that up then, please? Because some of these decisions are really hard. For example, the water damage problems that you talk about. And it's not just about the committee making a recommendation. You then have every resident goes to a meeting and there has to be a vote on whether that recommendation is accepted or not. And I suppose in Florida, what the government there is, was a problem of this nature and complexity and expense beyond the Strata Committee, and maybe we need a different decision-making process for those sorts of issues that involve fundamental safety of the building. Is there some cut-off point where it doesn't matter how much training you give people, they don't understand the issues of, the window, is the window falling out? How do you get that assessed? How much money do we spend investigating problems versus solving? I mean, these are 3-hour training modules. And then you've got to get the whole committee, old lady, everybody has to vote whether they like that solution or not. Is that appropriate?
I believe that there are a number of mechanisms that owners can rely on without having to be trained themselves, and that is obviously access to professionals, whether they be legal advisors, engineers, managers, and other advisors, depending on what the issue is. There are a couple of stopgaps which would potentially bring those issues to a head so that they don't continue beyond, in this instance, a year. For example, the ongoing obligation to achieve an annual fire safety statement may well pick up any of those issues of a fire nature and certainly at least facilitate a conversation. We've also found in New South Wales that the insurance companies have been hypersensitive to ensuring that these issues are resolved, and they will often dictate terms of resolution prior to offering terms or penalise an owners corporation. So some of these things cannot be allowed to extend beyond multiple years so long as there is an awareness of those issues.
But if you've got the Florida case is a case in point, although not under New South Wales strata laws, quite obviously. But a major structural defect was identified, and then it appears that the strata equivalent dithered, and it just wasn't addressed, and then the tragedy ensued. Are there adequate mechanisms in the law in New South Wales if you're living in a strata building, the strata committee is dithering on a structural defect issue, for you to bounce it up to some kind of independent third party who can just take action? Are you satisfied, Mr. Duggan, that there are sufficient checks and balances in the New South Wales system?
Yes, and from experience as well. So we have a couple of current cases of buildings which neglected their maintenance and couldn't come to consensus amongst the owners, and any individual owner was able to take an application for compulsory management under 267 of the Strata Schemes Management Act for effectively an administrator to be appointed with full authority.
But then that owner has to go down and take on the entire Strata Corporation in NCAT proceedings, which is a zero-cost jurisdiction, and they can be facing 10, 20, 30,000 of legals in order just to get the Strata Committee to start taking a step. Are you saying that's an adequate remedy, Mr. Duggan? Because it doesn't strike me as an adequate remedy.
It's a remedy for those buildings, and it's used in what I consider extreme circumstances. I think potentially there is room for more application on other areas, so lower impact areas, which don't necessarily require the appointment of a compulsory manager.
Mr. Stanton, in your experience, do you reckon that's an adequate remedy? You've got some poor homeowner who's anxious about perhaps the water damage continuing, Strata's doing nothing, or there's a structural defect that they're not properly addressing in the basement substratum. Do you think it's an adequate remedy to say they should drop 10, 20 grand of their expenses on legals in NCAT to try and get that resolved?
Where it's a problem affecting just one or two units, you have that particular situation and unfairness arise, and it's hard to say that that's an adequate remedy, but it's also hard to identify another alternative other than perhaps an avenue for an owner to be able to approach the regulator to say, well, can you review this without me having to go to NCAT, and perhaps the regulator can get involved and have powers that I think that'd be new powers to deal with that situation. Often if it's like a structural defect that is affecting a number of units in the building, what would often happen, a group of owners would approach a lawyer collectively, and they'd collectively fund the NCAT application, so they share the $20,000, $30,000 to make it more feasible. It's a difficult issue because it is a very serious matter to take away the ability of owners to be able to decide for themselves.
And that's why the Owners Corporation Network has called consistently for a Strata Commissioner whose role it would be to educate and adjudicate on behalf of these issues. It's one thing to take something to NCAT. It's another thing to spend, and I'm thinking of one of our members, $500,000 to prosecute their case because of water ingress that's been, I think, going on now for 7 years. And others who, Mr. Shoebridge, you've met from Charlestown and other areas. I'm thinking of another one where it's a 4-lot building. One has been flooded 3 times, the last time with raw sewage. However, the developer owns a lot and is in control of that strata to the point of briefing legal counsel, despite that being illegal, because the mechanisms that are in place at the moment look good on paper but do not function for individuals who are being victimised.
Possible the developer controls the strata. Can you explain that?
The developer has managed to get proxies of 2 of the 3 other lot owners and is leading the conversation to the point of briefing, as I said, legal counsel, which is illegal under the 2015 Act. The developer must not vote on building defects, and yet.
But in a number of buildings, developers will try and hold on to a majority vote on the Strata Committee until the initial defect period has concluded as well.
If they don't do that, they're usually in a relationship with the real estate agent who is acting on behalf of the investors and will often use their proxies.
Yeah. And has that rule that the Parliament legislated for a couple of years ago, whereby the initial strata manager can only be appointed for a maximum of 12 months, has that made a difference in practice, Ms. Stiles?
Again, without a strata register and data collection, it's impossible to know unequivocally. It's a year is a very short time in a new building for owners to get together, understand what they're dealing with, and uncover perhaps the related entities that might be obstructing them in looking towards building defects and other things.
Ms. Stiles, sorry, you referred to a strata register. Can you just
Anthony,
explain for the record what exactly you mean by that?
There is one being developed at the moment, and it will be a register of every strata scheme in New South Wales, which will be pre-populated by Land Registry Services, and it will collect core data, things like strata manager if there is one, building management company if there is one, the last annual general meeting, 2 committee contacts so that government can communicate and educate direct with strata communities.
When is that due to be developed by? Do you know?
We were hoping that that would be in play this year. However, it has expanded in its remit to include a lot of extra information with regard to building defects and the lodgement of as-built documents. So I'm not entirely sure when that's likely to be delivered.
Mr. Khan had a question, and then I'm going to go. Yeah, I'll go to Ms. Cusack, then Mr. Khan, then Ms. Husos, in that order.
Thanks.
I just want to continue on that issue of developers versus owners. Isn't it also true that there's a big issue with investors? The building that I was involved in was a majority of investors, and many of the Strata committee members didn't even live in the building or own any property. They were just family members of one powerful investor, and because the investors didn't live there, they didn't have the familiarity with the problem. So do you think that Strata members should have a financial interest in the property, and if they're on the board? And secondly, should this sort of information be captured on a register?
I think we might go to you on the register point first, Ms. Stiles. Is that part of your understanding of what the register would include?
Not at this point. We're looking at a minimum viable product, but that's certainly a very interesting a set of data points to know owner-occupiers versus investors, and certainly overseas investors.
And you would have thought that an owner-occupier understanding the number of unit holders who are actually living there as opposed to investors might be a good indication if, for example, a defect is not being addressed and there's concerns, might be an actual useful indication for a regulator as to whether or not they need to intervene. Mr. Duggan, do you have a view about that?
Undoubtedly, an owner-occupier would have a different perspective of the common property and its maintenance, and they live there, correct. Whether it warrants legislating different entitlements for an owner-occupier to an investor is obviously a broader discussion, but undoubtedly we benefit, certainly as managers, from on-site owner-occupiers because of the intimacy they have with the building and their awareness of things as and when they occur.
Mr. Stanton?
Can I just clarify? I'm talking about people with no financial interest in the building. So the investor's son-in-law, daughter, cousin being elected to the Strata committee. That's what I'm saying. They don't personally have any ownership of the building.
I mean, that can occur, and it can occur where if an owner with a particular interest is able to rally proxies of people who aren't owners in the building, whether owner-occupier or owner-investor, yes, they can be appointed to the Strata committee. I'd have to say it's a reasonably rare event in my experience that actually occurs. It does occur, yes, I agree. However, it's rare.
But Mr. Bell, it would actually occur quite often because the actual owner of the building may actually be a corporate entity.
Mm-hmm.
So if you were to, for instance, exclude non-owners, then you might well be excluding essentially a nominee of a corporate entity that owns one or more units. You couldn't really exclude those people, surely.
Well, the corporate entity normally has a nominee that they put forward themselves. I think what Ms. Cusack is talking about is where an entity, whether it be a company or an owner, rallies a number of different proxies, and they appoint different proxy holders to then be nominated to the committee.
Are they often real estate agents?
In my experience, it can be real estate agents, it can be family members, it can be a variety of different people.
Can I just ask, coming back to the question about the Strata Register, does that have statutory basis? Is it a legislative requirement that the government establish this register?
It's not a legislative requirement, but I believe there's heads of power being drawn up such that the data collection will be mandatory. There'll be an annual return required of strata schemes in New South Wales.
Right.
Ms. Yusos, who has been extremely patient throughout.
Let it be noted that I was extremely patient.
What's
Thanks
happened?
very much, Mr. Chair. Can I just wanted to come back to this question of fire protection. We do have a recommendation from the Plumbing Trades Union, which talks about the different standards in different states. Now, I don't appreciate that you would be familiar with the different standards, but I am interested to know whether you think that the fire maintenance should be a licensed position as well. That's one of the things that they've talked about specifically. The initial installation of the fire systems does require licensed tradespeople, but the ongoing maintenance, which we all know is so important, actually doesn't require licensing. Ms. Stiles, do you have a view, or Mr. Duggan, in your experience, whether that would be a useful step forward? Or Mr. Brell, I'm happy. I should just pose it to the two different organisations. I'm sorry, and then Mr. Brell.
Yeah, I was actually going to say, in July last year, the competent fire safety practitioners regime came into effect in New South Wales, and that's actually put a requirement on all fire safety practitioners to be licensed in the particular category of fire safety measure that they are signing off. So that regime's been in place just over 12 months, and what we've found is the compliance in fire has what's the word I'm looking for? It's very, very rare that a fire practitioner will sign off a measure unless it is 100% absolutely safe. So little things like prior to the 1st of July last year, prior to the 1st of July last year, the requirements to inspect all properties wasn't in vogue. So many contractors would go through and only inspect a small percentage of the property and then sign it off. Whereas now, although this is not legislated, what we're finding is that practitioners are requiring 100% access to all properties before they sign off a building. So the compliance there has increased significantly since the 1st of July last year.
This is the annual fire inspection?
This is the annual fire inspection.
I thought I was being picked on.
No, no, not at all. Yeah. So that licensing requirement came in on the 1st of July last year.
Is it a licensing or is it an accreditation?
It's an accreditation.
Okay.
Yep.
So in terms of the accreditation, what's the actual accreditation that's required? Apologies for my...
No, that's okay. So there are 30-odd fire measures in a building.
Yep.
Okay, there are 30-odd fire measures that may be in a building, and the fire safety practitioner must be accredited per measure, and that's signed off by the FPA, which is the Fire Practitioners Australia.
The last of which is knocking on Mr. Khan's door and checking his fire alarm is
That's
actually
right.
functioning and working.
Over again.
Yeah,
But before that, there's all the other structural matters.
that's right.
I'm very careful.
Ms. Yusos.
So that is very, very helpful because obviously when we're talking about cladding, the measures that are in place to if one of these fires does occur, like we saw in La Crosse, where we didn't see the same kind of tragic consequences as we did in Grenfell because of the fire, the word's escaping me, but the fire protection systems actually kicked in and did what they were supposed to do, which was excellent. They specifically, actually, it's all right, that's quite a technical question, which I can pose to them. I'm then interested to know...
Well, sorry, before we go off this point.
Oh, sure.
So we've got the 30 elements being ticked off, but are you satisfied that the people doing that, the maintenance and inspection, have the appropriate accreditation and skills and knowledge to actually be, the right people to sign off on that without a formal accreditation system?
What we've found on the ground is often... It's an extraordinarily costly regime to get into because each fire safety measure costs the practitioner around $1,000 to become accredited for that particular measure. So for one individual to be signed off as accredited for 30 different measures, they need to spend $30,000 to become accredited for each particular measure. What we've found is in some fire companies is that there is one person who's accredited, but then the inspectors beneath may not necessarily be. And so that is an issue. I know FPA have actually struck off a number of their members because they are not compliant in that regard. But this is also followed up. The local councils have become very, very involved in this as well, and they are checking to make sure that the accreditation process, is robust and it is signed off. However, it's getting there. It's not 100% safe at the moment, or not 100% compliant at the moment. However, it is far superior than what it was prior to the 1st of July.
It doesn't seem to me to be unreasonable to say the person doing the inspection, going from unit to unit, going down into the basement, checking the sprinkler system, that person should have to have accreditation on what they're checking.
That's right.
Each element of it. And that's not the system at the moment, is it?
That's how the system is designed. How it's working in practice is a different question, which I'm not going to go into because I don't really know enough about it. This is just, what we're hearing on the ground from practitioners is often that there is only one person in the fire company who may be accredited.
Yeah, and they're not necessarily the person on the ground knocking on Mr. Khan's door.
That's correct.
Yeah.
I didn't ask for their accreditation.
Next time you should.
But just to be clear, so this is actually, we're actually talking about two separate things, which is the fire inspection regime and then the people who are actually doing the maintenance work to ensure that it is ready for the inspection process. So in terms of the maintenance work itself, those people aren't required to be
No, that's right.
licensed.
Not at present.
That's right.
Yes, that's right. So while we've seen some improvement in the compliance, we also want to see an improvement in the actual quality of the work that's being undertaken. That's really important, isn't it?
Yes.
Well, if the long and the short of it is, if a defect is found, anybody can rock up and do the maintenance on it.
Yes, exactly.
And then this is a life and death measure. The sprinkler system, the fire safety. Mr. Stanton or Ms. Stiles, do you have a view about the need to licence the people doing the maintenance work on fire safety?
It's, if I can just address that, it's undoubtedly there needs to be licence categories for anyone who's able to do repair or maintenance work on a fire safety measure in a building. I don't think anyone could reasonably dispute that. While I'm not across the detail, I'm aware from my involvement in the Pillar 1 working group that Mr Chandler's put in place that there's a subcommittee with the Fire Protection Associations leading it that are working out a good regime to make sure that every different category of fire safety work to be done on a building has a particular licence subcategory and what the criteria for being eligible for that licence should be. So my understanding is there's recognition that needs to be put in place and there's a lot of work being done to create a regime that is fit for purpose.
So has there been any time frame given to the completion of this body of work?
I could find out, but I can't tell you offhand.
No, but it's you can take it on notice.
Yes.
And
that would be great.
would you mind both of you taking on notice as well the issue? Some people have raised concerns about the fact that there's a kind of grandfathering in fire safety, and that if you actually touch your fire safety systems under the new regime, you're suddenly brought into the new compliance regime, and that can be extremely costly. If you could take on notice whether or not those concerns have been raised with you, or if you have a response to it. Ms. Usos?
I think that was all. Just any reflections that you, again, if you wanted to take it on notice, just in terms of the interstate comparisons, if you have any experience in that. I understand that if that's beyond your remit, then that's fine. But the way that it's been put to us is that Victoria seems to have the higher standard. We have a slightly less, and so there are things that we can be doing to improve our standards to actually get it up to the Victorian standard. That would be helpful.
We
if
had
there's
on
no
various committees this comparison with Victoria. I think one of them was COVID, and then everyone's still talking about Victoria.
I just wanted to come back to the question of Project Remediate and just to hear whether you had any anecdotal feedback as to why we have seen quite a low take-up rate. There is a low, there is clearly a number of buildings that are out there that are eligible for Project Remediate, but for some reason or another are choosing not to operate or not to opt in. Have you heard any feedback as to why this is the case?
we've engaged pretty extensively with a number of buildings, both that have signed up for Remediate and some that haven't, particularly via our membership. And some of the feedback is that the timing of the scheme didn't suit those buildings. So for whatever reason, whether it be a pressing need for certification, compliance or insurance renewal, they've proceeded with the works prior to being applicable for the scheme.
Sorry, Mr. Duggan, stopping you there. In other words, Project Remediate was too slow for them.
They would progress.
Is that how I'm to interpret that?
Well,
Project
I don't think
Remediate was too slow and they needed to get things sorted.
They had other pressing matters, yes, whether it be insurance or like, so they did proceed.
Is it the case that some are choosing not to opt in because either through legal advice or other consultants' advice, they've chosen a different route of recovery? That is, they've gone, in a sense, the litigation route.
That's true, and some have also had the finances available to proceed without the low-cost loan or the no-interest loan facility. So some had missed the boat in terms of timing. Others chose because they had the funds available and the cost, obviously, they could fund off their own balance sheet and went ahead with those works. Some were pursuing developers or different litigation parties, so it's a complicated scenario for those that haven't proceeded. We're confident that through our network of strata managers that all the buildings that are applicable have at least had the opportunity to sign up. Whether they have or have not, we don't have a direct insight into, but we're hoping that all the buildings that are significantly high risk are currently being remediated either through Project Remediate or independently.
Mr. Duggan, had you completed your answer to Ms. Husos? You were still talking about two elements in your answer, and I rudely interrupted you halfway through. I might ask Ms. Husos to remind you of the question.
Would you please?
Any anecdotal evidence as to why strata schemes or why buildings are not opting into Project Remediate?
Thank you, Mr. Tribute. I think Mr. Khan's question elicited the second response, which was some have already got the funds available and therefore went ahead with it because they didn't require the funding.
Ms. Stiles, did you have anything on that?
And some were pressured by fire orders as to timing or insurers refusing to insure them if the works were not done. I think it's fair to say that Project Remediate has had an enormous amount of thought go into it, and I believe that will deliver a very good result. I'm not sure about the Victorian process, that perhaps was much faster off the blocks, but that there might have been. They might find that there's overruns with regard to the defects that are found under the, obviously, when the cladding's removed.
Oh, that's an excellent point.
Um,
Well, in Victoria, they've completed 40 buildings and they have 117 underway, and we're aware of one building having some cladding removed under the New South Wales system. So
during the press conference.
During the press conference.
Yep.
It's interesting. The witnesses are saying one thing, you're saying another. It's
Well, are you?
the evidence?
Well, Mr. Duggan, my understanding was, and Ms. Stiles, there's a number of buildings that because Project Remediate was so slow, they had insurance pressures and other pressures, they just had to get on outside of Project Remediate. Am I misunderstanding your evidence, or is that the nature of your evidence?
That's correct.
Yep. And there are some that are in Project Remediate and have commenced it, but you're aware of only one building that's had some cladding removed. Is that your evidence?
Correct.
Yep. That seems fairly straightforward, Mr. Khan. Could I ask about a different issue? Had you finished on?
I'm done, thank you.
And it comes from your submission, Mr. Stanton and Ms. Stiles, and it's about one of the most meaningful ways to try and stop building defects in multi-storey residential buildings is ensuring that the builder is appropriately qualified to do multi-storey residential buildings. The government's reforms so far have required that the builder have a minimum 5 years experience before they can undertake multi-storey buildings. Your submission takes issues with that. Did you want to speak to that issue at all?
Yes, thank you. It's the recent amendment intended to address our concern, simply says 5 years relevant experience. Starting point is, what does that mean? Is it 5 years experience on a site, which you might gain while you're doing your plumbing apprenticeship before you then get a building licence? obviously it could mean something else, but it's very ambiguous. But building over 3 stories, it's the most complex. The higher you go, the more complex it is and the more risky it is. 5 years relevant experience, it's nowhere close. There's no assessment there that they actually know what they're doing, or that they've got the financial capacity to do it.
So I had perhaps generously interpreted it as 5 years practical experience as a builder and a licensed builder on multi-storey apartment blocks. That's not your understanding, Mr. Standen?
It would be helpful if it's 5 years experience as a head or within a head contractor building multi-storey buildings, but it doesn't say that, and relevant experience is much broader than that. But even if it was 5 years experience as a licensed builder, from my discussions with licensed builders and people in the industry, that's not enough for someone to have the knowledge and expertise and project management skills and supervision skills for all the different trades to really be able to properly run a multi-storey build.
But to be clear, is it your...
Can we just unpack
yeah.
what those relevant criteria would be? Because I accept I can become a partner in a legal firm if I've had 5 years experience as a lawyer, but you wouldn't...
But 5 years experience taking tea into the meeting room and being an article clerk wouldn't be sufficient.
I've always been pleased to be the tea.
Wouldn't be sufficient.
But have you got a list of criteria that you would say would be appropriate?
A plum.
Yes and no.
Well, you don't have to actually answer it now. You could actually take it away and think about it. But.
We've suggested some approaches to it previously in submissions, not wholly in the submission that we've submitted for this inquiry. One approach is that the government government agency since 2010 has been the underwriter behind the home warranty insurance scheme. So there's underwriting experience for 11 years now in assessing what's needed to trust a builder enough to issue insurance to build a 3-storey building, which is the ambit of how high you can go while still having to require insurance. So we've suggested that whatever those underwriting criteria are, that would be a good starting point to transplant that to the licensing regime and says, okay, if you tick those boxes, that's a starting point to be allowed to build above 4 storeys, because if you can't trust them to build 3 storeys, you certainly can't trust them to build higher. Another approach that...
just with regards to the 3 storeys, to build a 4-storey or a 5-storey building is one thing. To build a 10 or a 20 I would have thought, is an entirely different exercise. Is it simply enough to draw the line at 3 storeys because of the insurance issues, or should one have subcategories above the 3-storey level?
Yeah, my personal view is there should be tiers of categories, as you've suggested, and it needs someone with better technical knowledge to say whether it's one tier would be 4 to 6, and then 6 to 12, and 13 plus. But I could imagine that being the kind of answer that the industry and government might come up with, as to assessing where the knowledge and expertise and financial stability categories can merge.
Mr. Standen, who's signing off on the practical experience? Who makes the determination that a builder has satisfied the threshold of 5 years practical experience? Is that fair trading? Who's doing that?
It is fair trading who's issuing the licence, so it's doing the assessment of what the 5-year experience is. It's a very recent introduction, the 5-year requirement, so I'm not sure who within fair trading is making those assessments or what they're basing it upon, whether it's just a form that's filled out with a reference from someone.
But as you understand it, you could have 3 years as an apprentice a year 2 years as an employed builder, and you'd be permitted to fill out the form and assert you had 5 years practical experience.
Yes, I don't see why not. Under the regime that under the wording of what's there, that's certainly it.
And that's no check on quality, is it?
It's not. And while it's an attempt to improve what's there, there needs to be a lot more done.
Mr. Duggan, Mr. Burrell, do you have any view about whether or not that's an adequate quality check before you let a builder take on a complex multi-storey residential building?
I don't have the background on the issue, but I would reinforce that the competency of the builder and their qualification and experience is critical.
Did you want to take it on notice and review that?
Absolutely.
Yeah. Ms. Hughes? And then, Anthony?
Can I just ask, I mean, there's sort of a supposition about competence, and then there's the alternative supposition about, I suppose, taking shortcuts. In terms of the 39% of buildings with defects, can you give us perhaps a rough guess about how many of those do you think are as a result of builders deliberately taking shortcuts to minimise costs, and how much is it about the technical competence, like genuine mistakes that have been made because of the incompetence of the builders? Would you hazard a guess in terms of the balance?
Yeah, you can have that one.
You can't answer that objectively with objective data, because no one can really say after the fact whether that leak over there where the waterproof membrane wasn't thick enough or didn't go up the wall far enough, or so on, was due to someone cutting a corner and they just wanted to get off the job, or if they didn't know what they're doing. My sort of impression from living and breathing building defect matters for many years is that if they're in equal measures, the lack of competence within trades and also the lack of care, basically, if they know that they're not going to be accountable down the line because they're trading through a company, or warranty periods are going to be missed before this becomes a problem. So my personal opinion is that it's large part corner cutting and large part not knowing what they're doing to the extent needed.
And all in a system of basically self-certification or a private certifier paid for by the developer. That's the other that allows this to happen, doesn't it? There's no independent inspector on the beat checking the work.
I think there's no one independent checking all this work like a clerk of works used to several decades ago, and I'm not suggesting that kind of approach can suddenly be brought back now. It couldn't happen overnight, but a private certifier, many consumers think that their role is to check that all the work's been done properly. It's not. My personal view is the certifier word is not the word that describes their role under the legislation. But what they do check is a small proportion. So yeah.
We're going to be very quickly, Mr. Khan and then Ms. Hughes, and then we're going to have to wrap this session up.
I think I'm looking at the regulation that deals with what the building practitioner must have, and I think what I've got is must have a supervisor's certificate authorising the holder to do general building work. Experience must be 5 years. 3, must know and understand the relevant acts and regulations. I'm cutting it short. Must know the building codes volume 1 and 2, including documents. Building design and construction skills must be able to interpret and apply and assess compliance with the relevant requirements. It seems that whilst the 5 years is one of the components, there seems to be a number of other categories of capacities that the builder has to tick off. Would you agree with that?
Yes, but that is being ticked off. It's a matter of filling in forms, is my understanding. And
Well,
it's
if the regulation is wrong, I'm fine, but it just seems to me to say it's simply 5 years is to
Sell it short in a way.
is to sell short the number of criteria that the builder has to nominate to meet the criteria. That's fair, isn't it? You're a lawyer. I'm only a traffic law one, but you're a lawyer. You know, you got to.
Yeah, certainly. Like 5 years has been
One of the criteria.
Yes, of course. And the 5 years is what's been put forward as the criteria that elevates the building above 4-storey licence as above the entrance level criteria for a building licence at all.
Yeah, but we can explore, I think we might, how that's actually tested or accredited with the Mr. Tansey this afternoon. Ms. Hughes.
I just have one final question on a slightly unrelated matter, which was around this question of building manuals. So that is a manual to be presented to the owners at the completion of the building. I know this is being pursued through the National Construction Code. I'm just interested in your thoughts, and if I'm happy for you to come back to us on notice if you prefer to provide us with some more detail, but whether you support this particular proposal and why, or why you don't.
We're definitely in support of it. It's been a consistent recommendation through many investigations into why owners are not given information, why things aren't documented properly, and why proper decision-making around defects and preventative maintenance isn't at the hands of the owners. So, no, we're fully supportive of it. We've been working as one of the pillars of reform with the Building Commissioner to ensure that that's a document that's passed over in easy-to-read language for the owners.
I like that. I'm going to use
Has
that
to be easy to read.
Easy to read, yes, that's right.
Can't be technical.
No.
Ms. Stiles, Mr. Standard, did you want to take that on notice?
No, absolutely support a building manual.
Okay. Could I ask you to just take one final thing on notice? We explored whether or not mandatory education would be appropriate or not, and you indicated the impact that would have on having volunteers put their hand up to be on the Strata committee. Would you take on notice whether or not a combination of mandatory education together with a regulated, reasonable fee or remuneration for undertaking that might be a useful mix? So if you put your hand up, you are on the Strata committee, you're required to do 3 or 4 hours of training, that you're also paid a fair statutory remuneration for that time, whether or not that might be a mix, a policy mix that would be of assistance. Thank you all for your evidence today. You've taken a number of questions on notice, and the Secretariat will help you with identifying with precision what those questions are. And again, I remind you, 21 days, if you can, to provide those answers. Thanks again for your assistance.
Thank you.
Thank you.
We're going to have a short recess and return at 11:15. Welcome back to the second panel of the Building Standards Inquiry of the Public Accountability Committee. We have a series of witnesses from, amongst others, the Australian Institute of Architects, the National Fire Industry Association, the Design Institute of Australia, and Network Architectural. I'd like to welcome all the witnesses, and because it'll take us a little while to get sworn in, we may get that process started immediately. So I'll work our way through, and could each witness please give their name, their position title, and take either an oath or an affirmation, and we'll commence with you, Mr. Gavin.
My name's Clint Gavin, National Sales Manager from Network Architectural. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thanks, Mr. Gavin. Mr. Regler.
Kim Regler. I'm one of the owners of Network Architectural. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thanks, Mr. Regler. Mr. Schott.
My name is Bradley Schott. I'm the New South Wales Chair of the Design Institute of Australia. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
And we'll stick with the Design Institute. Ms. Ryan.
I'm sorry.
Oh, sorry. Ms. Ryan.
I'll just need a moment.
Well, we'll come back to you, Ms. Ryan. We'll go to you, Mr. Smith.
Joe Smith, Acting CEO of the National Fire Industry Association. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
And sorry for misidentifying you there, Ms. Cockburn. We'll go to you now.
I'm Miss Laura Coburn. I am the New South Wales Chapter President of the Institute of Architects. I solemnly and sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thanks, Ms. Coburn. Ms. King.
My name is Lisa King. I'm the Policy and Advocacy Manager, New South Wales, for the Australian Institute of Architects. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. Ms. Ryan?
Sorry, I'm just getting it up now. I do apologise. Denise Strong from the Design Institute of Australia. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth.
Thanks, Ms. Ryan. You're spotting in and out a bit there with the connection, so we might just play that by ear and hope it clarifies. The opportunity now is for each organisation to give a brief opening, and we might just go in the reverse order and start with the Institute of Architects.
Thank you very much. Thank you for providing us the opportunity to speak with you today. We commend the committee for continuing to dedicate its time to the reform agenda, which aims to ensure that quality and safety are re-embedded into the value system of the design and construction process for consumers in New South Wales. The Australian Institute of Architects has been working constructively with the New South Wales Government to support the implementation of the Design and Building Practitioners Act and Regulation, and has been impressed with the high level of engagement of all members of the New South Wales Government, the Office of the Building Commissioner and the Department of Customer Service in the development and rollout of this important suite of legislation and regulation. We would like to take this opportunity to urge the committee to support the adequate funding to be provided to assist these teams, particularly in the area of technological requirements. It is critical that the digital systems so central to the success of the legislation are budgeted for and implemented in a timely manner. Our submission to this inquiry outlined 3 areas of the current legislation which we believe, if adjusted, would not undermine the reform as intended for the benefit of consumers. They were: architects must be supported to access adequate and affordable insurance products by ensuring joint accountability of building and design practitioners in the New South Wales legislation and regulation. Part 4, Duty of Care in the Design and Building Practitioners Act, states that there should be no contracting out of part. However, the Act also states this part is subject to the New South Wales Civil Liabilities Act 2002. The Civil Liabilities Act does allow contracting out of proportionate liability. The Act needs to simply be amended to exclude the proportionate liability provisions of the Civil Liabilities Act. This will allow for a fair allocation of responsibility and liability. Item 2, the current legislation should require both building practitioners and design practitioners to take reasonable steps to ensure compliance with the Building Code of Australia. Currently, a registered design practitioner must ensure that design compliance declarations are issued by registered practitioners. This places a strict liability on the registered design practitioner and removes the common law test of reasonableness. The building practitioner is only required to take reasonable steps to ensure compliance with the declaration obligations. If the purpose of the legislation is to achieve better building outcomes, then all members of the building chain should be held to the same standard as the designer. The Institute did not support the requirement for architects to have recent and relevant practical experience in the specific building classes of Class 2, 3, 9A and 9C in order to be eligible to be registered. This requirement has caused adverse outcomes, and we have worked constructively with the policy team in government to reach a position which both protects consumers but does not restrict the trade of registered architects. Architects already operate within a highly regulated profession, nationally standardised and internationally benchmarked. Registration to be an architect involves 5 years tertiary study, along with documented and supervised professional experience and a robust and independent registration process. Our members have told us the current eligibility requirements have been excluding some very knowledgeable and experienced practitioners. In our recent member survey, 68% of respondents indicated that the current requirement was prohibitive or limiting. We do also understand and support the intent of the reforms in delivering consumer confidence and protection, and have been able to work constructively with the government policy team to enable members who may not meet current criteria an alternative pathway to a restricted registration for low-rise buildings. These practitioners must still be registered architects, however, can have gained the required experience across broader cross-section of building classes. We believe that this is a fair and equitable result from our members and also for consumers. We maintain our commitment to continuing to work with the New South Wales Government as the reform agenda progresses, and we would like to thank you once again for the opportunity to speak with you today.
Thanks very much, Ms. Coburn. And during the course of that, we've now opened up our viewpoint of view. So
there's a lot going on.
I'd like to thank for that, and we might just get that chair in the middle removed so as we can see Ms. Ms. King, or both the chairs removed.
Or do they want to just come and sit at the table?
No, we've got COVID requirements that require the separation. Right. We've achieved a good outcome.
Excellent.
Thanks, Ms. Coburn. Thank you for that. And could I now might go to you, Mr. Gavin and Mr. Regler, in your all-new angle to give us a brief opening.
Thank you. Network Architectural is an importer of high-quality architectural products. This includes Mitsubishi Alpolic NC cladding. Our product is an inert mineral core composite developed by Mitsubishi in Japan. It was developed to be the safest, most fire-resistant cladding product in the world. It consistently outperforms all other cladding in highest standard fire safety. We are rightly proud of Alpolic. We refuse to import or sell inferior products like solid aluminium. We will not put profit before safety. Solid aluminium melts in common fire conditions, causing large molten lumps to shed. This is potentially catastrophic for both firefighters and occupants. The Cladding Product Safety Panel was tasked to recommend the safest and most suitable cladding products. So far, the panel has not revealed whether the products recommended in Phase 1 have been subjected to Australian standard fire safety or combustion testing, and it has delayed recommending safer composites that do meet that testing. At an industry briefing last Wednesday, the panel took a step in the right direction by clarifying further testing for composites, but it remains unclear whether both composites and solid aluminium will be assessed and recommended based on the same fire safety standard and other criteria like durability, environmental performance and warranty. The proposed process still will not ensure all products are comprehensively assessed against the same criteria to give owners the safest result. We urge the committee to consider the following 2 recommendations. First, that the panel assess all products including solid aluminium, to the same Australian standard, AS 5113. It is the only Australian standard test that simulates real fire conditions. The test has already been conducted by the CSIRO and independent fire testing lab Ignis. This standard test shows that our Pollock NC is the safest cladding product in the world. Secondly, that the panel published the results of testing in a further report, perhaps by the end of January 2022, with guidance on how all products, both solid aluminium and safe composites, perform against both fire and non-fire criteria. We thank the committee for its ongoing interest in Project Remediate. We look forward to continuing to work with you and all stakeholders.
Thanks very much, Mr. Regler.
Thank you.
Mr. Smith. And again, thank you for cooperating with the move. We appreciate it.
NFI is very supportive of the committee's inquiry. We have a view around regulatory frameworks that they should protect the safety of the community and property, that they should recognise industry standards, and that the registration of practitioners should be linked to ASQA recognised appropriate qualifications. Over the years, many lives have been lost in Australia to fire. There's the Bankstown Apartments in New South Wales, Childers Backpack in Queensland, Kew Cottage in Victoria. More recently, there was the cladding fire at La Crosse in Melbourne, and as everyone knows, the Grenfell Tower tragedy, where 72 lives were lost in the UK. The view of the NFIA is that fire protection is more than the sum of its parts. So that we would advise that the inquiry does not look just at flammable cladding in isolation, but considers the totality of the life-critical fire protection system of the building. To date, in Australia, we have not lost a single life in a sprinklered building. That's something we're very proud of, and it's a fantastic statistic, but what we have to do is to build on that success and use that model and apply it to other areas of fire protection. What that shows us is that the underpinning apprenticeship, Certificate 3 of fire protection, and the government-regulated licence model works. So our view is that this model should be used across the wider spectrum of fire protection in a nationally consistent way. The introduction of any certification, which we've talked about, should be linked to an approved ASQA qualification, which we would argue is the Certificate 4. And this builds on the Building Competence Report Recommendation 19. In New South Wales at the moment, there is a privately run accreditation scheme, which came in 1st of July 2020 with the Building Environment Certifiers Act. At the moment, on the ground, that's had a fair few teething issues. I'll be frank and say that it's not my association that runs it. So, you know, what I hear a lot of from my members is not positive. It's led, if you look at the transitional pathway that they're offering, to the opportunity for some of the biggest, most important buildings in New South Wales having somebody with a Certificate 2 qualification signing off on the fire protection system or elements of the fire protection system. It's our view, as I say, that the fire protection system interacts with each other, so the importance of having a more appropriate, higher bar for the certification for us is, we believe, critical. We'd also advocate for the commissioning of a certificate, for a commissioning certificate that the certifier could do for any new installation and any major refits. This provides an opportunity to have one person doing a job instead of two, which obviously cuts a bit of red tape. But it also means that that gap between the installation and the design, the installation, and then that first year where we have people going in and doing their annual fire safety checks and all the runs there, we find there's a huge issue there between what's been installed and what was planned. We would consider that a best practice framework for New South Wales would include design, install and maintain, inspect and test, and certification, and that it should cover all streams of fire protection, which would be the active wet, the sprinklers, passive, electrical, portables, and special hazards. Thank you.
Thank you, Mr. Smith. Mr. Schott or Ms. Ryan, who is going to give the opening statement. Ms. Ryan?
Yes, I was going to thank you, Chair, and thank you to the committee for the opportunity to appear and to represent professionals. The Design Institute of Australia is the professional association of design businesses in Australia, run and funded by designers and project owners. We've been representing design professionals in all design disciplines for nearly 70 years. As advocates for good design, the aim of the building reforms to improve the quality of construction in New South Wales. And on behalf of our interior design members, we've been engaging with customers of New South Wales and other key clients. The role of interior design and construction is not always well understood. So we welcome the opportunity to collaborate work and form. Following the introduction of interior designers trade as previously, the projects are restricted to moving non-structural or removing existing kitchens and bathrooms within single apartment. However, if the brief is designed for the kitchens and bathrooms in a new building, or it's a heritage restriction does not apply. It is not uncommon for interior design and architecture services to be contracted separately on a multi-residential development. On these projects, interior designers coordinate teams of consultants who may be designing changes to building elements, including by reconfiguring internal layouts and floor plans. However, as there is no register of design practitioners, they are now not able to manage compliance declarations. In the transition period, they may be able to pay a registered practitioner to declare the designs on it, but thereafter, they will be permitted to be removed for the specific work they are qualified for. Interior designers are not to undertake work outside their area of expertise and have completed advanced or bachelor degrees specialising in the areas of buildings that you typically need and experience on dozens of projects. No systemic problem with interior designers has been identified in any projects undertaken at state or national level. The inability to reflect design practitioners will necessarily restrict interior designers and performing work that is qualified and experienced once the transition period closes, unless they can currently architecture, building, and wages qualifications. We have already had reports of losing work due to the independent register. This is particularly acute for businesses that specialise in Class 2. The impact of the building is that highly skilled and experienced practitioners are being removed from the industry after 2010, simply because the different qualifications do not include the profession. We believe that the new education framework needs to be urgently updated to address the old assumptions about practice and construction, to ensure that all relevant groups are appropriately covered.
Look, thank you all for your evidence. We have a lot of ground to cover over the next hour, so we'll all try and be focused if we can. It might be useful to start where we ended there, and Ms. Ryan or Mr. Schott, whoever wants to answer it. Are you asking for effectively some legislative clarification to exclude interior designers from the registration aspects of the legislation? And if so, how would that work in practice?
I think. Oh, I'll get that. Sorry, Denise. I think we're actually asking for legislative or regulatory clarification to include interior design within the scope of the disciplines that can be a registered building design practitioner. It appears that Section 13, I think it is, of the regulations has been written in a way to try and exclude interior design, but that may be based on a misapprehension of what interior designers can affect within the built environment. Probably the simplest way for me to put it would be that decorators move the curtains and designers move the walls. So we do have a fairly significant impact on the built environment within the envelope of a building, and that doesn't seem to have been allowed for in either the legislation or the regulation.
So what would be...
Sorry, can you just pull your microphone a little bit closer?
Yeah. Thank you, Courtney. You could pull it significantly closer, Mr. Schott, might be useful. So what is the impediment to getting that certification?
There is no category for interior designers in the regulation, so we effectively don't exist. We have explored with our members in quite a bit of detail what other categories we could become registered under. To become architects effectively requires doing a whole architecture degree, which is for an interior designer in the Hall of Fame who has been practicing for 50 years, that's not realistic. Looking at the building designer category, that will cover some work, but many interior designers do a lot of work in high-rise buildings, renovating some fairly flash apartments in high-rise buildings. And the building design category won't cover high-rise. So it appears to us that there needs to be a category that will cover high-rise buildings as well, but only within the building scope.
So if there was to be a regulatory change to include that as a category, what would be the qualifications upon which someone could rely to get certification as an interior designer? And would there be a different category qualification for Class 2 buildings, or what would be the the minimum standards?
So the minimum standard we have for full membership of the Design Institute of Australia is an AQF7 level qualification, which is, I think, an advanced diploma or a degree qualification. Most of those are degrees now.
Ms. Ryan?
Yes, yeah, that's correct.
So this seems a very soluble problem. Is it just a question of getting the Institute and the government and the Minister to sit down and work through a certification process? What's the barrier here?
I'm not sure what the barrier is. It probably is a simple matter of just ensuring that the people who are responsible for drafting the regulations or the Act actually know what it is that interior designers can do.
One of the issues that comes to my mind is working out the boundaries, if you like, between interior design work and architecture work. I suppose, Ms. Coburn, Ms. King, do you have any view about policing that boundary?
So I think I guess the difference with regard to an architectural education is the 5 years, 2 degrees, plus more than likely 3 years postgraduate before you are then registered, and ostensibly somewhere between 9 or 10 years before you actually call yourself an architect and a registered architect. And there's an intensive process to actually become an architect. And then after that, there is a continuous yearly requirement for ongoing education that covers all areas of practice, and that is administered independently. So it's quite a process involved to once getting your registration and then maintaining your registration. And I think that's probably ostensibly maybe one of the differences that comes in there. As far as the broad scoping of work, then there is a critical aspect to architectural work that is effectively we are the great generalists of the construction trade, and that our role is ostensibly more often than not as the principal consultant that is actually bringing everybody's specialty together, and we have an overview of how things actually do go together. So that's a very specific role, which I think it would be fair to say interior designers don't necessarily always have that level of involvement, particularly in high-rise buildings.
Yeah, I think I would agree. Architects have a much deeper level of education than interior designers, and also architects are responsible for the external environment as well. So architects can have a very large impact on the surrounding urban landscape, whereas interior designers will really only affect the internal landscape, I guess, of a building. Quite often, interior designers do work in interior design teams in an architecture practice, and I think that may be part of the reason that our work is not necessarily that visible. Interior designers, I'm thinking particularly in commercial buildings, which is what my background is, can have very significant impacts on a building. I've personally led projects that have included carving a staircase through 5 floors of a commercial building, stripping out a building to the shell and reinstalling all of the services in a way that they were exposed, and coordinating across all of the different engineering disciplines for that. So it can be a large impact, but it is entirely inside the building and given a building envelope. So I guess the limitation would be it's inside the building only. There is probably a requirement for CPD, which the Design Institute of Australia does have, but it probably needs more development.
Well, I mean, it strikes me that there's an urgency if interior designers are unable to do their work, and there's a solution, and it should just be urgently actioned. And perhaps both architects and interior designers should be part of that designing the certification, so as it's kept within scope of interior design and doesn't bleed into architectural work.
I think of it as a symbiotic relationship that interior designers and architects work better together.
Ms. Usos?
I had different questions
Yep.
on a different matter because I think that we've come to a very practical solution there, which was very helpful. Thank you to both. I just wanted to ask a specific question, first of the Institute of Architects. So you talked about your increases in insurance and obviously the importance, particularly in PI insurance. How much on average are you finding that your members their insurance is increasing by?
Do we have the answer on that one in particular?
At the moment, we are hearing...
Ms. King, if you just get the microphone in front of you.
We did a recent member survey which showed that a number of members felt that they believed the insurance premiums would rise. We have had a couple of cases where I've been contacted and insurance has risen to a certain extent. We haven't at the moment got evidence that it has risen as much as it has for certifiers, but we do know that the advice we have from insurers is that there are some concerns at the moment that it could rise.
Okay. And I wanted to just ask you about the point you made about the majority of architectural practices, specifically medium and large ones, they don't practice just in one sector or one building type, and that this is a challenge. Obviously, we've seen a lot of regulation going into Class 2 buildings because that's the ones that have had the focus. But your view is that it shouldn't just stop there, that it needs to actually extend to the whole industry. Is that correct?
I guess the point that we were making specifically was, and I guess it touches on the previous point, that at the moment registered architects who have experience outside of the particular classes noted actually are prevented from working in this area. So in a similar sense to interior designers, at the moment architects who have Class 1 experience, for example, can't work in Class 2. And so we have seen that has been an issue for a number of our members, and we've been working very closely with the government and the policy team to come to I guess, a position that both protects consumers and allows architects to work, in the areas that they have traditionally done. In terms of rolling it out to other classes, look, we fully support the intent of the reforms and believe that, we want to see consumers protected, and certainly that is the case in other building classes as well. I would say sort of more urgently, boarding houses, aged care, health would be the priorities. But certainly I think there are cases to answer in any of the building classes.
Yeah, and we would certainly applaud any reform within construction that talks about bringing the quality question back into play. And that's what this evokes, and we would certainly applaud it across all classifications to enable quality to be part of the equation.
But, I mean, if you had to say where the immediate extension of the design reforms should be focusing on, boarding houses, aged care facilities, and...
Well, there's an awful lot of government expenditure currently in healthcare and education. And these are buildings that, previously, and particularly in education, hasn't been touched for 30 years prior. There's a massive spend there. Now, if you want to have good quality spend, then I would suggest that also looking at where government is expending money to get good quality outcomes would be a reasonable suggestion. So I appreciate that the focus has particularly been on where people are sleeping, because unconscious inhabitants obviously are at greater risk than those that are able-bodied, but we're talking about people who are in obviously aged care and health, so there are usually infirm people there, and similarly in education there are younger children who en masse need to egress the building.
And there's some anecdotal evidence that developers are using boarding house classification to avoid some of the Class 2 regulations as well.
Anecdotally, I believe there's possibly, yes, some of that.
Yep. So aged care, boarding houses, education and health,
Yep.
they would be, we're going to digest the next series of classes, that's where you would say the urgency is?
Yes, I'd focus your attention in that direction.
Okay, thanks very much. Just because we've got limited time, I'm going to move.
One more question to the architect.
Yeah, of course.
No,
You'll take it anyways.
No, I think the proportionate liability issue and the contract and the legislative test, they're probably beyond the remit for us to deal with today because they were dealt with in detail in the debate about the legislation. But I think we all understand your position on those. One of the issues that is within scope is the practical experience, the 5 years experience that is limiting the ability of architects to move from one class of building to another. What's set against your position is it's a very different thing to do a Class 1 building to a Class 2 building. Class 2 building's much more complex, and we had some discussion earlier today.
Agreed.
Yeah, so persuade us about that point.
And look, the position that that we have been working constructively with the policy team is to then provide a restricted class so that Class 1 architects, because we're talking about potentially one apartment in a high-rise building or a couple of townhouses, and so an architect who is working in some large homes is probably has the experience to be able to work in that area. So by restricting their ability to work in a low-rise setting, so that's sort of up to 3 stories, then we're protecting consumers, but we're also maintaining that a registered architect who has got experience in Class 1 is certainly capable of performing in a professional manner in that area.
So you'd have an architect could do Class 1 buildings and then a subset of work within Class 2 buildings.
Correct.
Is that
So
the
low
intent?
rise, equivalent to a building design.
Yeah, look, I think at the moment the legislation allows for a low and medium rise restricted classes for building designers. We would maintain that an architect's registration process is certainly very robust in comparison with any other design practitioner group, and that as a registered architect having a master's degree in addition to supervised professional experience and then a registration process as well, that's certainly more than enough. But we do understand the government's intent to ensure that, consumers are protected. So we're trying to sort of work within the legislation to find a solution that does not restrict the trade of registered architects.
Your case, in short, is architects have layers and layers of quality control and professional
Correct.
controls,
Absolutely.
which should be sufficient for your role in low to medium rise.
It should be able to enable us to actually practice unrestricted. However, we appreciate that currently the issue we're facing with members is that because of the specificity around classifications, that it is actually restricting practice of some incredibly experienced people in doing the odd apartment or the refurb here or there. They practice in multi-million-dollar individual residential buildings. They occasionally get asked by their same clients to go and do an apartment here or an investment here. And at the moment, they can't do that, and they've been practicing for 50 years or 40 years. So what we've been doing is working with the Office of the Building Commissioner to try and find an amenable middle ground, which is to enable that restricted up to medium rise practice for them at this moment, at this juncture.
Do you think you're near a resolution on that?
We believe we are.
I believe we are.
Yeah.
Well, we might clarify that this afternoon, but I think we all understand the issue. Ms. Useless?
Okay. Mr. Smith, sorry, that was not perfect timing.
Ms. Useless waits for that.
Pounces.
I totally agree with your comments about needing to look at the totality of the building. But can you just take me through slowly what you said quite quickly at the end of your statement, which was, so there should be a Cert 4 training for... Actually, why don't I just hand over to you to take us through slowly that?
I suppose it comes back mostly to the Building Confidence Report, where recommendation 19 says, and I'll read it for you, registered fire safety practitioners to design, install and certify.
Yeah.
We have a view that that is correct, but you need to look at maintenance at the same time as installation, because that's just as important. And then there is as well inspect and test. The other thing that people often forget about with fire protection, and we have a lot of people that work with sprinklers, so people come and talk to me about sprinklers, and that's very valuable, but there's also a lot of other elements of the fire protection system. So that's what we'd call the active wet system. There's also the passive system, which I think most people are aware of. That's your fire doors and that sort of thing. There's the electrical system, which is a whole range of things around alarms and that element, as well as portables, which would be your hoses, hydrants, that sort of thing. And then there's special hazards, which are for different sorts of buildings that can't have that simple active wet system. So our view would be that there should be classification and a framework around design, install and maintain, inspect and test, certification against each of those different streams as well. And that each of those should be marked an appropriate ASQA qualification. And I think that just builds on the success that we've seen over so many years of the sprinkler fitting apprenticeship, and the fact that we've had no deaths in a sprinklered building in Australia, and that the apprenticeship teaches more than just the individual units, which is what we're finding with some of the accreditation schemes and that sort of thing, is that they cherry pick units, and that if you just do those units, that doesn't mean you understand the system. It means you understand a very finite part of it. So the value of that broader approach has really paid off. It was interesting, I was chatting to one of our trainers at one of the training colleges, and at one point they tried putting all the inspect and test units and teaching them all in one go in the first year, but what they found was that the success was very low compared to when they spread them across the 3 years, because the people doing the inspect and test units within the apprenticeship had a much better understanding when they'd done other elements of the apprenticeship and understood the wider system.
Yeah, absolutely. And that's certainly, I mean, something that I raised earlier this morning, which is from the Plumbing Trade Employees Union, which is talking about the need to then licence the maintenance. So the installation is licensed, but the maintenance, which can be just as important. So you would obviously support that?
Entirely, yes.
That recommendation, okay. And
sorry, that would be a Cert 4 recommendation?
No, the maintenance, our view would be that would be in line with the installation, which would be a Certificate 3.
Yeah, okay, that's a specific.
And fundamentally, probably the same qualification, which is that apprenticeship.
Yeah, absolutely. Okay. That is very, very helpful. Thank you very much. And so then I'll move on to...
oh, sorry, before we go off,
sorry, yeah.
We just go, the testing on, we have 35 minutes, Courtney.
Oh, I'm trying to be very disciplined.
No, that's good. You've been very good, Ms. Eustace. In terms of the commissioning, the role of... So you need certification to install, and then you'd want certification to maintain. What's unique about commissioning? Is that turning it on?
You don't have certification to install per se at the moment. What we're finding, the design work is now very well regulated through the Design Building Practitioners Regulation, which we're very happy with because it follows that same model of an appropriate qualification regulation. So design work's happening fine. Then the install is being done predominantly to the design, but not always, but closely to the design, hopefully. Then there's an installation statement made, and the certifier will look at the statement and sign off. And this is just the experience we're finding on the ground, is that our members are going in a year later to do the annual fire safety statement and going, that doesn't match standards. So that's the feedback we're getting from our members at the moment, is that they're going a year after somebody's paid to have a rather expensive fire system installed and saying, this doesn't meet X or Y or Z, you're going to have to do this much work to correct that. So what we would advocate for is that a certifier sign off and a certifier classification within fire protection licensing, a Cert 4 qualification would go in and certify that it had been installed as per the designs and installed correctly. And they would then be responsible for that if a year later there was an issue.
So at the moment, whoever installs it, who may not have accreditation, basically writes the documentation, which is then signed off by the private certifier.
It's then signed off by a private certifier, yes.
Who may not have the expertise or may not be on ground to check.
They would be required to have the accreditation now under the most recent thing in the last year, and this has only been in the last year this has come in. But we're still finding that there's some issues when people actually get to their first annual inspection, which we're now past, and we found this in the last few months particularly.
And so
How many times has it been found, to your knowledge?
I'd have to say that what I'm giving here is anecdotal, in that I've had members mention it to me. It's come up at members' meeting, and there was a fair chorus of support. I couldn't give you a specific number.
So what would be the additional checks and balances in the commissioning certification as opposed to the installation, whatever the private certifier is currently signed off on now? What's the distinction?
If you have a certifier with the appropriate certificate for qualification, they would be able to go and look at the system in its totality. They'd understand it in its full installation process and its implications further on. They'd have a wider remit. At the moment, as I say, if you're looking at the private accreditation scheme, you'd have people who have, well, at the moment they'd be under the transitional pathway, so they would have undertaken some private assessment and been granted that. Moving forward, they potentially have some Cert 2 qualifications and a mix of different qualifications depending on which element they were certifying, whereas it could be much cleaner, much simpler if you had somebody who was one person who was certified with the appropriate qualification, understood the entirety of the system, and looked at it and said, yes, that is correctly installed as per the design. I'm happy to sign my name, and you can come back to me in a year's time if there's a problem.
Right. And that's somebody who understands there's a system in place and they all interact and they have the skills to sign off on
Absolutely that, yeah, and an appropriate level to understand that.
So working on the basis that it's anecdotal, but what are the sort of problems that are being identified as making it, in a sense, non-compliant?
That things haven't been installed as per the design. So there is a design that meets compliance and that the installation does not match that design. So, and that could be a range of any different things, but that fundamentally is the issue. There's a approved design and that's not being met.
And you're saying that it's not being picked up by the certifiers?
There are...
Sorry, I should just say that it's just also, like, I think during our last inquiry we established that the role of the certifier is essentially to rely on the certificates that are provided to them. Yeah. You're saying that certification that's being provided to them, there needs to be more rigour around that.
Yeah, so at the moment that's fundamentally an installation statement saying, I've installed this as per the designs, and what we're finding is a year later that they haven't.
Yeah, okay.
All right.
That's very helpful.
Mr. Fowler?
I was just going to ask, in terms of, do you see this additional requirement required on all levels of building, or do you see it as something to apply to a certain class?
I think you'd be looking probably alongside the Class 2 and above. I mean, Class 1 systems are next to nothing for fire systems. So, yeah,
but multi-storey buildings, and perhaps what about large industrial, commercial?
Yes.
So so not class 1s is what you're saying?
Yes, not class 1s is what I'm saying, not the smaller residential, but everything else.
Now, Ms. Husos is keeping us to time, so I'm going to hand back to Ms. Husos.
I'm only the acting deputy chair.
Okay.
Mr. Gavin, Mr. Regler, thank you very much for your time. Can I just say, Mr. Gavin, I am fascinated by you brought some samples. So can I ask you?
Oh, here's something I prepared earlier.
Didn't bring them on. I left them in the car and I ran back to get them.
Well, I can see them laid out. So perhaps before I start my questions, you might want to talk about those.
Yeah, well, the samples I brought in.
You're not going to set them alight, are you?
No.
It's not a lump.
Not all of them burnt.
All right. Mr. Gavin, you have the floor.
The samples I brought in are just to demonstrate the products that are compliant in New South Wales or in Australia at the moment. So the product that's been chosen by the CPSP, the Cladding Product Safety Panel, is this one here, which is solid aluminium. Such as 3 mm thick aluminium, no core whatsoever. The heat goes straight through it. And aluminium as a product melts at 660 degrees. It doesn't matter if it's 3 mm thick or 20 mm thick, it still melts at 660 degrees. Then we go on to the product that we're distributors for, which is Mitsubishi, our poly. And it's got aluminium skin either side of a non-combustible inert mineral core. And I guess with aluminium composite panels, the issue that everyone sort of, the question marks come up about is the fact that it's an aluminium composite panel, and that's the media say that they're all dodgy, as they say in the media. But it's like a sandwich, really. Like you've got 2 aluminium panels, and it's what's in the middle that does all the work. So I know Lacrosse and Grenfell were brought up earlier, and that is 100% polyethylene. That was 100% polyethylene in those panels, and polyethylene melts. So what we have here is a mineral core that doesn't melt. It's non-combustible. The whole product's been tested, and it's deemed to satisfy and compliant in Australia. And would you like me to go into the third one?
Please.
Yeah, okay.
I'm enjoying this.
So the third one is a product, it's a corrugated core panel that's actually being considered at the moment as a bonded laminate. So this is once again two pieces of aluminium either side of a corrugated aluminium core that's held together with glue. So what happens with this one is that once the fire gets to it, you've got oxygen and glue going through the middle of the panel and the fire spreads. So that's being considered at the moment. So the Apollic MC and the corrugated core panels are just recently, last week, been called for further testing to test to a fairly low standard called AS 1530.3, whereas the solid aluminium, that just gets a green light anywhere for some reason.
So that's a very effective way of showing that there is a clear difference between solid aluminium, the product that you're talking about them with the mineral core and the corrugated core as well, and clear differences in terms of what the fire safety is of each.
Well, the suppliers of the solid aluminium and the panel, I'll call them the panel, the CPSP, they haven't called for any fire testing really on solid aluminium. It's a product that goes back to the 80s where people used solid aluminium and it got outdated because of the heat transfer, because the energy efficiency of buildings dropped because the heat just goes straight into the building. But they haven't been asked to do any of the highest possible tests within Australia. So there's no evidence whatsoever to say that solid aluminium is a safe product. The Apollic NC has been tested to those higher safety standards, and we as a supplier, we wanted to see how the Apollic NC performed against solid aluminium. So we tested the highest possible standard, which is building a 9-metre wall and burning it.
That's the AS 5113.
Yeah, AS 5113, yep. That's correct. And the Apollic passed, it was head and shoulders above the performance of solid aluminium. But because the NCC doesn't call for solid aluminium to be tested to that standard, it just gets passed through with an easy standard.
So what's that standard? Is that, you were talking about the corrugated one being the AS 50.3, I think. What's the standard that the solid aluminium's tested against?
The standard, well, it doesn't necessarily have to be tested. It's just classified. It gets a clear pathway through NCC. Most of them...
National Construction Code.
Oh, yeah. Most of them... Sorry?
National Construction Code.
Yes, yep. National Construction Code. So a lot of them have been tested to AS 1530.1, which is a non-combustibility chamber you drop it into. They don't combust. It's like a radiator. Basically, it comes together at 750 degrees to see if the mineral actually ignites. And if it ignites, then it's combustible. If it doesn't ignite, it's non-combustible. In numerous reports that we've seen on the solid aluminium, it doesn't actually last the journey because it drips out of the bottom. It melts and drips out of the bottom. But this is the product that has been classified as good to go, on any building, Class 2, high-rise building, through Project Remediate.
Mr. Gavin, is it as simple as this, that your position is if you're going to put a bunch of cladding up on a building, it should satisfy the highest standard of AS 5113? If it satisfies that, good to go. If it doesn't satisfy that, shouldn't be put up on a building.
Absolutely. From day one, we've been asking for apples to apples testing, test the product side by side, so we can actually prove that the Apollic MC outperforms this solid aluminium. The test is expensive, and none of the suppliers will spend $70,000 to show their product fail dismally. So
we did. We spent the money at the start because I wasn't prepared to sell a product that I didn't believe in.
Sorry, can I just go back to the solid aluminium? So, solid aluminium is used in a variety of circumstances. For instance, it's used on ship superstructures, including naval vessels, that would be used in low-intensity warfare exercises as opposed to high-intensity. But it's known that it'll melt. But is melting the problem in terms of the buildings?
It certainly is one of the problems. I mean, there's numerous problems.
Well, Grenfell wasn't a melting problem.
Grenfell?
It was a combustibility problem.
Absolutely. Two totally different issues. And we're not saying for a second that solid aluminium will propagate fire the same as the polyethylene core material did.
Right.
What we're saying that under high temperature...
I'm just concerned that is differentiated because, I accept that there are limitations to whole range of materials. But if what we're interested in is the Grenfell situation, holding up a piece of solid aluminium and saying it'll melt at 600 odd degrees.
It really is. You've still got to be concerned about the safety of the occupants getting out of the building. And solid aluminium, it's been proven, solid aluminium, and documented in one of the supplier's own documents that was tabled at budget estimates, melts at 660 degrees. This test is 1,000 degrees for 30 minutes. So the solid aluminium forms chunks, melting, debris, falling down on people trying to exit the building. Now that's just as dangerous as, we're concerned about the safety of people. So you've got whether they're fixed mechanically or not, because that's one of the criteria that the CPSP put in place, is that they had to be fixed mechanically around the outside. But we've seen in a CSIRO NADA tested lab that the panel actually comes off the wall. The whole panel comes down because the heat that's generated in this test melts the aluminium and it melts away from the fixings and it comes crashing down. You're not going to get the propagation, we 100% agree with that. But it's about safety, it's about environmental issues. There's a whole range of durability, there's a whole range of separate topics where this product has not been tested to and is not suitable for.
So what happens to your product in similar circumstances?
The core, like I said before, the core in the sandwich does all the work. So the heat doesn't get through this core. So what happens is the aluminium will melt away and flake. This is 0.5 aluminium, so that actually would sort of melt away. And in a 5113 test...
So how does the aluminium adhere, what's the adhesive for the aluminium to the core?
It's bonded together with an adhesive. So it's got an adhesive. So the NCC, National Construction Code, says that you have to have a non-combustible either side and a non-combustible core, and the adhesive layer has to be less than 1 millimetre thickness per side to prove safety. So this product, the adhesive layer is 0.05 millimetre either side, so it's well below the threshold. And in the UK, it's actually been tested to Euroclass A1, tested through EN 13501-1, which is all products, all components need to be tested for flammability, for combustibility, and that's the only product in the world that has passed.
So let's just put that into perspective. It's been tested to the highest European standards. Yep. It's been tested to the highest standards here in Australia, but yet it's still not recommended by the Cladding Safety Product Panel here in New South Wales.
That's correct.
And yet the solid aluminium is, which does have risks. Now, I wanted to move on to the risks, the risks that are associated with the solid aluminium, because there was a brief, and I'll be frank, there's a briefing that the Chair and I and others participated in from the Product Safety Panel about the installation of solid aluminium panels. There are serious dangers in the way that it is installed then as well, aren't there?
There is. I mean, the installation and what's behind the panel is just as important as the panel itself.
Okay.
Like a lot of these panels originally were put up with polystyrene insulation. And all of a sudden, there was a flood of people who wanted to come in and be installers to make money out of doing this. And we won't sell it to anyone. They have to go through an accreditation process to make sure that they are installing it as per recommendations.
The rationale for the polystyrene was that at least it provided some insulation and provided a sort of outcome. It just so happened that it was a dreadful fire risk.
Absolutely.
You say that the issue isn't necessarily bonded products. The issue is having a bonded product that isn't a fire risk and produces some kind of thermal insulation.
Well, this provides some thermal insulation. We still recommend insulation in the cavities, but it should be rock wool. It should also be passing used in a high standard testing.
And the issue that was identified within Project Remediate's own documentation and testing was that when you have the aluminium clad wall, which is separated out some centimetres through the installation system, creates here a funnel or a chimney effect. And we saw in budget estimates, and we've seen in briefings, that chimney effect means the fire spreads rapidly and melts the aluminium.
Yep.
It's a system issue as well, isn't it?
Well, that is a system issue, and this is one of the areas where Project Remediate and the panel have recommended using cavity barriers in the systems, so when there's a fire, they expand and that blocks that cavity.
But I might go to the architects. If you're thinking about installing aluminium cladding as a design solution, are you aware of the concerns about condensation and the like from rapid heating and
Yeah, so I think if we just take it away from the product and we just talk about envelope, it's really important to understand that it is a system. It's a system that has to breathe, it has to seal, it has to protect, it has to perform acoustically. Sometimes it has to perform from a security basis. There are many aspects to an envelope. And within that, you have to have a whole of system approach. So there is a requirement upon us to have the knowledge and the information available to us that allows us to review how to build up that system. We rely on the expertise or the specialist advice from specific engineers that enable us to build that. And then we also need to have clear information, product information, that to the nth degree, and by that I mean it's not just that it covers the Australian standard, but it covers all parts of that Australian standard and is very clear about where it does not comply with that Australian standard. Part of the issue we have at this present moment is the lack of testing that has been taken out on materials in Australia, the long wait times that are at CSIRO for people to product test, and the expense. So it sort of falls short of innovation within construction, and it means that it's very difficult to actually make decisions on materiality when the information is not displayed clearly within the products. It also leads to substitution where things are put in place of the original documented item and it's not clear as to where things are compliant or not.
Has the issue of aluminium cladding not meeting the AS 5113 test, and then the system, if you like, which is the cladding and the fixtures, creating that chimney effect, has that been raised in your professional experience, Ms. Cobbin?
Yes, it has, absolutely.
Do you want to speak to it briefly?
Anecdotally, we certainly through PI and insurance, we won't touch aluminium coating. That is professionally speaking in my role as a director of a company.
Would it be fair to say that that system of aluminium cladding is the one that's most commonly being used, though?
Yes. Look, it's an interesting one. It's a very achievable system. The issue that came to ground often is the substitution by many different contractors across the board and historically, and a lack of ability to control that. But the need to actually understand it in a system perspective and from the face all the way through, the preventative piece of putting stops at each level to avoid the chimney effect also then has detrimental effects upon the need to actually make the skin breathe from a Part J perspective. So there are issues related to the two different ways in which an envelope needs to work within the same parts of the actual legislation.
Those issues in particular conflict because of the very poor insulating behaviour of aluminium. The rapid heating and cooling leads to a large moisture build-up.
Yeah.
So you're starting with the wrong product, really, aren't you?
Yeah. So, there's been, I guess, professionally probably a shift away to avoid some of those aspects.
Yet it's still...
the product in the alternative?
Well, normally you would have a non-combustible material that you put externally as a lightweight cladding, a sort of cementatious product. But you have extra weight with that as opposed to the aluminium one. Yeah. So there's an issue involved there.
Yeah, and both and under the current National Construction Code, though, it's compliant with the Construction Code to be building these large walls of aluminium cladding with the gap behind it and no barriers. Is that compliant with the National Construction Code at the moment?
So we haven't used aluminium for quite a while for that reason. So my understanding is we actually need to provide barriers at each floor. So that's what we do as a part of our practice. So the BCA is a minimum standard.
Yeah.
And we seek to achieve above that.
So who inspects for the cavity barriers?
So that's done as a part of, we document it, and then that's carried out, the construction is carried out in accordance with those documents.
So that your expectation would be that the certifier would then check that these cavity barriers are in place, or does it call on the fire accreditation person?
Well,
I'm happy for you to take it on notice. It's not a tricky
I think on notice, I think we probably come back with that on that.
Yeah, that would be very
Mr.
helpful.
Smith very sensibly doesn't touch cladding.
Yes.
Is that right, Mr. Smith? Yeah, okay.
So I think Mr. Gavin wanted to add something.
The cavity barriers are only a requirement under Project Remediate.
Yeah.
So Class 2 buildings, other Class 2 buildings all around the country, whether it's a hospital or anything like that, cavity barriers are not necessarily required. So the panel has now put in place that you must have vertical and horizontal cavity barriers for Project Remediate buildings, full stop. That's
Which
it.
is just 220 buildings. The rest of them can all go
buildings.
and...
The other 700 around the state, you can do what you like.
Plus all the other buildings that are currently being built now.
Exactly.
Absolutely. Yeah, new builds are the same. That's exactly. You can build a building. I mean, there are plenty of architects out there at the moment that are specifying solid aluminium cladding. There tends to be a shift away initially from ACM. That's what everyone was shifting away from because of this. All products were thrown into the same basket after Grenfell.
You're now going to tell us what the acronym ACM stands for.
Sorry, Dad?
You're going to break down the acronyms for Hansard.
We're trying to.
Yep.
Asbestos composite.
No.
ACM stands for aluminium composite
Aluminium.
material.
Thank you.
God, not asbestos.
Thanks, Mr. Gavin. Yep, carry on.
Where was I up to?
You were saying that there's buildings at the moment that they've stepped away from ACM, aluminium composite materials, and there are architects and large building projects just using solid aluminium.
And I mean, this is why we keep saying that 5113, the AS 5113, is such an important criteria in all of this to show what happens and get some integrity and safety back into the industry. I mean, we're starting with a product that generates heat, puts heat into the building and melts and drips all over the place versus a product that doesn't.
Ms. Coburn, do you see barrier is probably the wrong word to use, but do you see a problem with requiring all cladding material to meet the AS 5113 standard as a basic minimum?
I think as a basic minimum, it's probably a good standing point. But again, I stress that it's not just the material, but it's the system that needs to be tested holistically from outside to inside with all aspects of it to be considered.
Well, I think the 5113 is the wall. So you build a wall of it using the construction system and then you set fire to it. That is a kind of systems test, isn't it?
It is, yes. Yeah, but obviously that's for fire, and then you've got to appreciate what other things it needs to comply with as well. But yes, for the AS 5133, a minimum standard for all materials would be a good starting point.
Well, almost an essential starting point. Would you agree?
Yes.
So, Mr. Regler, I think you said in your opening statement that there was an assessment process for your product that is to happen next year, is it?
It's actually happening now, I think, with Project Remediate.
Okay.
So,
and what is that assessment process? What have you got to go through?
it's being assessed to 1530 Part 3.
They put out...
and is that the same standard that the aluminium cladding has gone through as well, or is that...
So we received a methodology. This was on last Tuesday. We received a Project Remediate methodology for testing bonded laminate materials. So bonded laminate materials are the next lot of materials that they're looking at after they've put their tranche 1 product through, which was solid aluminium. So the test that is required is AS 1530.3. So all that is putting the panel on a wall and having a radiator incrementally come closer to it to test the indice levels of smoke and flame, basically. So it's not exposed to any real heat or real flames or anything like that. The maximum temperature in the test is 600 degrees. So aluminium, there won't be a problem with any of them.
Because you said aluminium melts at 660, was it?
Yes, so it doesn't get to 660. So they've also asked for to cut out perforations in the panel to represent an air conditioning duct or a pipe that will actually expose the core material.
Yep.
And they've also asked for tests to be done with intersecting joints filled with silicon to see how that would perform on a building. But they've only asked it for the bonded laminate materials. This solid aluminium, the golden child here, that doesn't have to do anything. And what we're finding is a mass of this coming in from all different suppliers, different grades, different melting points, and none of it has to be tested. It can go straight onto a building.
So as part of that process, your product's being tested. Are there other products that are being tested as well, or?
To AS 15th, the one.
Well, it's part of this new project Remediate assessment.
This one here is being the corrugated core. So it's basically the corrugated core one and our Poly NC are the two products that they've called for further testing on.
Yep.
And that was at a meeting called last Tuesday.
So I'm not trying to be derogatory. So is your complaint that it's being required to be tested, that it's not being tested to a high enough standard?
That would be that's correct.
You want it tested to a higher standard?
Absolutely.
We want all products.
You want the other products tested to a higher
Absolutely.
standard as well.
Apples to apples testing. And then these poor people that are already in these buildings now have suffered enough. Why not go to the extent now of putting the best product forward for them to replace it?
What is the resistance to the AS5113 testing, the wall testing, the sort of best safe? What's the resistance that you're getting?
I think you're entitled to ask, what do they believe is the resistance?
Yeah.
Well, I think Ms Cockburn looks like she might want to contribute to this as well.
Coburn?
Coburn.
Sorry.
It's Scottish.
Apologies.
It's like the port. My understanding, anecdotally, is that it's to do with cost. We get flooded with products from overseas and elsewhere that say, here's the newest, biggest, brightest thing. There's a lot of pressure on architects and other design professionals to accept alternatives from contractors who are looking to save a buck here or there and who are on incentivised earnings. And therefore, there is... you're in a rock and a hard place. You've specified what you believe complies and does the right thing by the testing their standards, and you're presented with other material. And when you say it doesn't have an Australian standard certification, I can't see where this complies. You find out very quickly that they haven't gone through that rigour. They've flooded the market and they haven't done the right thing. And it's cost. It's cost-driven, and we've been told, anecdotally, it's also time. So obviously CSIRO has limited funding, and unfortunately, they're an extraordinary organisation, and it would be well invested money to actually expand their ability to get this testing done in a timely manner.
So, Mr. Gavin, what's the cost differential between aluminium cladding and your Pollock product?
Oh,
I guess it's hard to say a blanket, but
no. Well, I mean, the cost is comparative, really. I mean, we're no more expensive, but I mean, to us, the issue is not about costs. I mean, the cost is what got us into this issue in the first place. Everyone was looking for the cheapest option with the polyethylene filled. It was cheaper than a fire retardant material, but and that's what everyone substituted out for. They looked to save the dollar. But as far as the cost of our material versus solid aluminium, right at the moment, we're probably cheaper, actually, but normally we're right on par with them. But it is a system as well. It's actually quicker and easier to fabricate the Pollock because it's got the mineral core in it, and quicker to install. So the end result is a more price competitive solution as well. So it's not about the money though. It's about safety.
But I mean, the very real concern I see in this is if the safety concerns of the aluminium system with the chimney effect eventually become widely recognised in the insurance industry, building owners who may have spent tens of thousands or hundreds of thousands of dollars remediating to get rid of ACM material are going to have to do it all over again to get rid of yet another defective system. I mean, Scott, do you have any views about, the ensuring good design in the first place?
Well, the intent being that if we've got clarity in the testing regime and the material within that system, that we can then specify and document it clearly, then that should, ipso facto, through the construction process, ensure good design.
So the testing regime is fundamental, though. It's crucial, isn't it? And so, but this is something where the government requires it, but because this has kind of happened with the flammable cladding, there's a delay. So there's a need to have more more resources devoted to fire testing. Would you agree with that?
Agreed, yes.
And that, so there's this delay. Can you just explain a little bit more about you talked about there's long waits, and the CSIRO has for the CSIRO, there's only a few fire labs, is my understanding, that will actually provide that. Mr. Regler, you're nodding as well.
No, that's correct.
Perhaps, can I get your feedback and then Ms. Coburn's on the actual, what is the fire testing regime and why is there such a wait?
Oh, and who pays?
Yeah.
Well, if the manufacturer pays for an independent test, there's no problem. We've probably spent $700,000 in testing already on these products to make sure that the product we're putting out into the marketplace is the right product. So that's us as an individual company. With the likes of the CSIRO and Exova Warrington down in Victoria, the two NADA certified labs, you can get into these labs and book them now and have it done probably over a 3-month period. It takes a week to get the test sorted, Clint. That would be right.
Yes, that's right.
Isn't the issue here the manufacturer or the distributor saves $70,000 by not having it tested?
Yeah.
And that's, commercially important to them.
So
But at the end of the day, the homeowner,
Sorry, he wants to answer.
at the end of the day, the homeowner spends hundreds of thousands of dollars installing and maybe refitting. It's this risk.
Yeah.
It's shifting the risk onto homeowners, isn't it?
Well, it's right. These people have all been through the ringer already. So why not give them the right product right from the word go? Why not test to the highest standard possible? Otherwise, why do these tests? Why put them out there?
What interests me is this. Before you were born, I suspect, but one of the great controversies that developed over aluminium was allegedly over HMAS Sheffield, which was sunk during the Falklands War. There's a great argument about aluminium superstructures on that ship. So it turned out it wasn't aluminium, it was steel. But the problem that arose in terms of melting of the superstructure in half of the ship actually was what was in the ship. It was all the accumulated wiring, etc., that was in the building. It really goes back to this. It's not simply a melting point that's at issue, is it? No. It's everything else that makes up your structure that potentially changes the dynamic. In Sheffield, it was bedding, etc., that made the whole thing so highly combustible. It wasn't a question of whether it was 660 degrees. The ship was burning at far higher temperatures than that. That comes back to your point about looking at it as a system as opposed to just one element and
absolutely
setting on fire a bit of aluminium or whatever.
Well, and I think importantly, the testing needs to illustrate the clear conditions for the entire system. So if I, again, take it away from a material at the moment, there is a kind of a book that we almost call the Red Bible, which is the CSR Red Book, which has tested systems of particular cladding or brickwork or other within it. We know with clarity that if we build walls like they've put into that book, that we will comply with the certain standards that we need to for a particular given circumstance. And they are very clear as to where the testing regime stops. So there are certain issues to do with when walls meet roofs, how you encase structure, how you deal with movement joints. There's a whole lot of technical, the book's a good half an inch thick. That kind of clarity is needed across all sorts of materials. At the moment, it's a minefield as to whether or not you get that clarity with the information that's provided to you. So I agree, it's absolutely about a system. The melting point test of a particular product is only one piece of the puzzle. And where you place that particular product because of its intrinsic nature is really important when you go about the design.
But can I just ask one final question, which is the fire testing on each element is fundamental to you being able to assemble the system, isn't that correct?
Yes, it is, and I would, on that system, and I would also suggest that rather like an Australian made or a product that suggests it's got 100% Australian peaches in it, that it's really clear in the labelling, and that is something that is sometimes, one might suggest, purposely subdued within technical data. So, the asterisk down the bottom will say, we comply with all, it'll say in big writing, we comply with this standard, and then down here it'll say, oh, except for parts 1, 2 and 3, and you sit there and go, oh, hang on a minute, that's the one I need. So that really clear labelling from the testing regime is incredibly important.
And it sounds to me like aluminium cladding is in a kind of get-out-of-jail-free category under the current regime.
I personally can't comment on that. I think if we walk away from what currently is happening and we look to what we want to happen, if we have that as a minimum standard, and I think we probably take on notice whether it's just that standard or particular parts of that standard or other standards as well. But yeah.
Yep. And could you also take on notice whether or not the 1530.3 standard is an adequate test for the fire safety of cladding?
Sure. And I think also understanding architects being great generalists, we would also be relying on our specialist advice with regard to that as well.
Well, I might finish by going to Mr. Smith, sitting here with your fire industry perspective on. Do you have any views about this discussion?
I have views. The issue is the ACP, ACM, as we've spoken about. Anything that forces fire up is obviously something that's flammable itself is the biggest danger. That being taken out would be kind of our primary concern.
Getting rid of the chimney effect.
Getting rid of the chimney effect, but anything that propels fire further is what we'd like to see removed. So, yeah.
And this comes back to the point you raised, which is you need to have a system-based. Sorry, but you need to know how it operates as a system. In short,
always, and I think that probably builds on what was being said before by the architects, and that all of these things interact. So, how they work as a system is the most important factor.
All right. I think Mr. Khan's indicating that we should end this session now, and he's dead right. We covered a lot of ground. Can I thank you all for coming with us in the last hour and a bit, and all of your submissions and your assistance today. Thanks very much.
Thank you very much.
Thank you. Thanks.
Yeah.
I'm not sure how we table 3 bits of
Sort of.
I want to see how we put it up on the website.
That's right.
Oh, yeah, have they been? I don't think you can table them.
Yeah, take them with you, unless David wants to play with them in the office.
Why did you table them?
Get a Bunsen burner out.
You've got a special guest later coming in. So
actually, it might be useful if you wouldn't mind leaving them. Treat them as tabled. We're still on air, by the way, everybody, so.
thanks very much. Thanks for your time.
Pleasure.
I still remember the sinking of the Sheffield and all this argument about going up like a Roman candle.
Yeah, indeed.
Well, an Exocet though,
It was, but yes, the Exocet did one of...
This is the coalition coming back to blame the French again.
Yeah, no, the Exocet didn't actually explode. It was the fuel within it that set up a huge fire. But it turned out not actually to have an aluminium superstructure. It was just steel that cooked.
We might just ask the next witnesses to step forward, if you wouldn't mind. I think we've gone through the cleaning process.
COVID safe now.
Might swap these two around. Do we have a cleaning process?
We absolutely do, and the secretary are really good actually. They keep an eye on it.
Like the knob people, they come around and clean your knob.
Because time is short, we may just get started.
I better make my appropriate disclosures at the beginning of this.
Yeah,
so,
you should.
Lauren, can you please tell me how to pronounce your surname so I don't muck it up?
Yes, I would tell you, but I believe you probably still. It's Conceição.
Conceição.
Yeah.
Okay, lovely. Thanks, Ms. Conceição.
Well
then,
Ms.
Conceição.
Or an affirmation. Oath is on the Bible, affirmation is secular.
It's the Mookie.
And yourself?
I'll take an oath. When I went to Pakistan, I was told that my name was, I've been mispronouncing my name my whole life. It's Khan, I was told. Now, that might have been by some Afghan warrior, but Khan.
All right.
But you weren't going to argue with him.
I did not argue with him.
He was by definition right. So if the members could settle, we will start this session. And we might start with you, Ms. Conceição. If you could please give your name, your position, and then take either an oath or an affirmation.
Absolutely. Ms. Lauren Conceição, New South Wales Deputy Executive Director for the Property Council of Australia. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, or nothing but the truth.
Thanks. Mr. Mann?
Yes, Mr. Steve Mann. I'm the CEO of the Urban Development Institute of Australia, New South Wales Division. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
And Mr. Kekovich?
Yep, Charles Kekovich, New South Wales Senior Policy Advisor at the Property Council of Australia. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thanks very much for your attendance. And
Mr. Chair, I just have a disclosure to make at the beginning that Mr. Charles Kekovich used to be a former staff member of mine about 2 years ago, so please go your hardest on him.
Okay.
So it just completely means that he's...
Well, there goes the talking notes.
Well, I'll let you two sort out your issues later, and we'll get straight on to the opening statements. Who wants to kick us off? Mr. Mann.
Sure, I can. That's no problem. Well, thanks to the committee for the invitation to appear today on behalf of the UDA New South Wales and to present the views of the development industry. It's just over 2 years since my last appearance before this inquiry, and for the benefits of new committee members, UDA New South Wales is the leading industry body representing the interests of the urban development sector. We have over 500 member companies, and our members are involved in urban renewal projects in Sydney and include developers, builders, strata managers, planners, project managers, engineers and local councils. We've worked constructively with the New South Wales Building Commissioner, David Chandler OAM, since his appointment in August 2019. I'm impressed by David's tenacity to deal with poor construction issues and his leadership to pull together all the stakeholders and to create a better industry. On the whole, I believe David has found the right balance of action against developments with bad construction and the solutions to these problems. I sit on the Construct New South Wales Steering Committee with David. I also am on the forthcoming Minister's Industry Panel for Decennial Liability Insurance. In our original 2019 submission to this inquiry, we made 8 recommendations, 5 of which have been explicitly adopted or are currently underway. We've been involved in the consultation for the Design and Practitioner Building Act, as well as the industry rating system. To briefly recap where the industry has come since late 2019 through the 2020 focus was implementation of the OC audit regime, which has generated the most media coverage. In response, UDA moved to form a building industry advisory panel comprising of 15 practitioners who met early with the Building Commissioner for the trial occupation certificate audit process, and some of our members offered their sites as part of that trial. OBC require OC audits 6 months before OC to allow for any rectification work and use a traffic light system to guide compliance. Through 2021, the focus has been on OBC establishing the principles of what a trusted developer and builder looks like and the rollout of industry rating system, which is designed to give consumers greater confidence in selecting an apartment. The Building Commissioner is recommending developers and builders obtain certification for their business and their delivery structures. Currently, this independent rating is being offered by Equifax, and the Commissioner hopes there will be others. The vision for the rating tool system is to bring more of the industry through the process with the aim of attaining a rated status, which will give the consumer confidence when purchasing off-plan apartments. UDA has continually sought to highlight the excellence that lies within much of our industry, particularly the small and medium-sized developers, to deliver more than 50% of the apartment projects in New South Wales. A Key focus in 2022 will be on developer builder quality ratings and DLI insurance, and this is intended to return security and confidence to the insurance market. Restoring confidence to the apartment sector is crucial as New South Wales navigates an economic recovery. Approvals and, more importantly, commencements are down 49% from the peak in 2018. With some turnaround this year, we've had 6% growth. The apartments industry supports 90,000 jobs and a total value of $50 billion to the New South Wales economy. The supply of new apartments will be very important as borders reopen, particularly given the deep affordability challenge for housing. Reforms have increased the emphasis that the developer needs to have the correct team around them who are appropriately qualified and experienced, which has been realised in the Design and Building Practitioners Act. I'm working closely with the Commissioner where there are construction problems to deliver enforceable undertakings. We're working to educate and upskill our members. Thank you.
Thanks, Mr. Mayor. And then who is taking on? Yeah, it's Constance.
Thank you, and good afternoon to the members of the committee. On behalf of the Property Council of Australia, I would like to thank the members of the Public Accountability Committee for the opportunity to provide testimony and further inquiry into the regulation of building standards. At the Property Council, our members are the nation's major investors, owners, managers and developers of properties of all asset classes. They create landmark projects, environments and communities where people can live, work, shop and play. The property industry shapes the future of our cities and has a deep long-term interest in seeing them prosper as productive and sustainable places. The committee's investigation into the efficacy and adequacy of the government's regulation of building standards, as well as the costs, effectiveness and safety concerns arising from the use of flammable cladding, is essential to ensuring a safe, secure and transparent building and construction industry across New South Wales. The Office of the Building Commissioner and the Property Council have benefited from regular engagement through membership briefings, meetings and consistent feedback on changing regulatory and legal frameworks governing the New South Wales building and construction industry. We continue to work closely with the Building Commissioner, David Chandler, and the New South Wales Government more broadly to ensure the integrity and quality of built form in Class 2 buildings. We reiterate our support for the New South Wales Building Commissioner to remove rogue operators who constitute a small percentage of the market but who are responsible for a majority of the decline in consumer confidence. The New South Wales Government should also be commended on the work it has commenced in establishing industry-wide rating tools such as iCert, the introduction of the Design and Building Practitioners Act and the RAB Act, as well as implementing and modernising existing tools to better reflect the 21st century building and design functions. We, as a member-based organisation, are constantly investigating and identifying better ways of doing things here in New South Wales and understand that there is a constant requirement to implement and update effective and considered regulation. That's why the Property Council has recommended the New South Wales Government prioritises a housing-led recovery, especially placing emphasis on the recovery of a shortfall of 54,000 dwellings to keep up the pace of demand for housing across New South Wales. At the Property Council, we are passionate about ensuring the people of New South Wales have access to housing choice, diversity, affordability and security, which includes safe apartment living and confidence in doing so. We feel that our organisations and members play a vital role in achieving an equitable supply of housing that will drive investment and certainty throughout the building construction industry while putting downward pressure on the house prices. Our members take reform seriously and share the goal of renewed confidence in the building construction industry more broadly. In relation to this, we recommend permanently allowing the stage lodgement of regulated design and compliance declarations with a staged construction certificate application process. Recommend retail and commercial sections of the Class 2 developments which do not interfere with the occupation, operation, egress or functionality of a building be exempt from requirements to provide upfront regulated designs as required under the Design and Building Practitioners Act. Introduce and develop an Australian standard form licence for the installation of temporary ground anchors on neighbouring lands, therefore removing the requirement to register them as an easement. And amend the Environmental Planning and Assessment Act to establish which version of the Building Code of Australia applies throughout an entire building should be based upon construction certificate, which includes either the ground floor or podium, whichever element is higher. It is our sincere hope that we can today expand on our submission and provide valuable insights and feedback to the committee members. Thank you.
Thank you both for for your opening statements. I will look to the opposition to kick us off.
Thanks very much. Mr Chair, can I thank you both, or I should say both organisations, all of you for your time and for your submissions. And yes, Mr Mann, you are a bit of a frequent flyer at our building inquiry hearings, so thank you very much for your information over many years. I just wanted to touch on a couple of issues that you raised in your on your opening statement about the rating system. That's currently just applying to, and if as a member of the ministerial committee any of these questions aren't appropriate, just feel free to wave me off. But it is currently looking at being provided by Equifax, but just on Class 2 buildings. Is that correct?
Yes. So the ministerial panel hasn't started yet.
Oh, okay, yep.
So it's due to start. Its focus will be decennial liability insurance.
Sorry, I confused the two.
I don't believe it'll look at the ratings, but the ratings, it's still a worthy question in that the ratings will position parties to then obtain DLI.
And will form the basis of that.
Yeah, so it could well be studying that.
Okay. And in terms of the ratings, are you aware that they're just for Class 2 buildings at this stage?
Correct.
Okay. And that will be for... So my understanding is that it will be for the builders, for the developers and for the buildings themselves. Is that correct? Or is it just for the buildings?
Yeah, very good question. So the pilot has just finished about 3 weeks ago. The pilot was with one of our members, so I've been through the detail of that. And at the moment it's with one provider, which is Equifax, and that's the iCert product. I think, and I'm questioning the building commissioner, that it does need to be down to every SPV or the delivery vehicle of each project, but it would be concentrating on ensuring that the head body providing the contract has got that certification, and then the SPV has the appropriate see-through in terms of pursuing any legal issues.
And
that's not fully worked through yet, I've got to say.
Okay, and Hansard aren't here, but SPV would stand for?
Yes,
Special purpose vehicle.
Special purpose vehicle. Yeah.
Okay.
And I think you noted in your submission as well that you sort of join with the building commissioner in there's neither good nor bad, but thinking makes it so when it comes to special purpose vehicles. That
it's how we do life in terms of financing all sorts of projects, not just apartments. I think that in itself is not the issue. The real issue is the ability for a consumer to be able to pursue through that SPV to where the money is, and definitely support where the Commissioner's heading with all that work. And it's crucial to... It will be interesting, even that there will be some businesses that have very, very good ethics and experience in all of that, but still need to improve some of that legal look-through from the SPV.
And have you got any recommendations in how that can be done at all, or...?
I have several in front of the Commissioner at the moment in terms of that process, how he communicates the mandatory side of that, because we are expecting it to become mandatory, but that's still work in progress. Okay. Yeah. How a customer actually obtains that, what's the value of that, the difference between, say, a builder developer, and a developer and a builder being separate, different ratings there.
Mr. Mann, can we just follow through? Assuming the rating system comes in and is stacked up for Class 2 buildings, how do you envisage that working in practice? What would be the product of it? What would be the outcome?
Yeah. So the intention is that the rating has a score. It happens to be 3 stars, which is a pass mark, and then the highest mark is 5. It will be quite challenging to achieve 5, and there will be some processes that are unusual. For example, one of the ratings issues is if the directors are directors of a lot of companies. A company that wants to provide good look-through actually keeps SPVs alive to ensure that people have good look-through. Another way of managing that is to assign the liabilities and get rid of those companies. So there'll actually be procedures that are currently good that actually rate you poorly because you're directors across lots of companies, but it's just a procedural thing that needs some time. That'll need 6 or 9 months to work through and sort of change that approach. I believe the banks are starting to buy into that whole process as well, which will be very positive.
The final product will be some developers get 3 stars, some get 4 stars, some get 5 stars, some don't get 3 stars and therefore they can't conduct business. Is that your understanding? Or can they still conduct business but they just don't have a rating?
don't know the answer to that. I think that's a question for the Commissioner in terms of where we end up. I think the proposal is that it becomes mandatory, but that has not become a certain outcome yet.
Ms. Constantine, do you have a view about that product, the end part of this reform, the ratings?
No, nothing to add to what Steve's.
Well, and I assume that, therefore, if a development is produced by a 3-star developer, there'll be less guarantee about quality, and that might impact the price. Is that the intent?
Well, what we wanted to do is to be a message for consumers, to consider those issues. I mean, perhaps you've got a well-rated developer and a less well-rated builder, or vice versa. I don't think those will have to be marketed. Again, these are questions I've got in front of the Commissioner now. So how is a consumer going to know? Are they going to have to look it up?
But I suspect the 5-star developer wants to put on their thing, 5-star developer,
Yeah,
and the 4 and the 3 are not going to say anything.
And also, they'd be suffering from further scrutiny from the regulator if they were to achieve a lower than 3-star rating. That's the bare bone basic, according to Mr. Chandler.
But surely the purpose of it is to have transparency. There would be an odd process to go through to get ratings of 3, 4 and 5-star and not require it to be published. Are you suggesting that's on the table, Mr. Mann?
No, I'm just saying, think of the customer. So if the consumer is looking to buy said apartment, it's not going to be necessarily on the marketing material. It might be if you're 5, might not be if you're 3.
If you go and buy a fridge, the ratings. You got your ratings on the fridge door, and that's $1,000 or $2,000 purchase.
You're not
going to buy a unit for $1,000 or $2,000. You're going to buy a unit for $750 to $1 million, even for a small one. So why do you have, I think, an obligatory disclosure of star ratings on your fridge and not on your unit door?
Completed product would be part of that. So you won't be marketing a completed product. You'll be marketing off the plan. So may not even know the builder at the time. So it might be the developer putting that forward.
Well, who's going to get rated?
These are questions for the Commissioner because it's unfinished.
But I guess in a sense it goes back to pick up Mr. Khan's point that you're not rating on necessarily the project, you're rating on the history, in a sense. Is that correct?
Yeah, it's a good comment. You are. I guess a lot of the approach from the Commissioner has been to look at the history and look at the history of the team who are delivering the development. So the Design Practitioners Bill sort of Act covering off on that. So there is a line of sight that's going to help the certifier in their process. All of that is going to help the consumer.
So, Mr. Mann, are you suggesting the rating system is going to apply to the building, or is the rating system going to apply to the developer, or the other alternative is the rating system going to apply to the builder? Who's the rating system applying to?
You're right. It's not quite the right way to say the builder, but it will be the development team for that particular project. So it might be a different builder for different projects, different developer.
So it's the developer and the builder and the architect
just the first two. The designer practitioners gives the line of sight largely for the certifier on the history of all of those designers as part of that project.
So tell me in simple, plain terms, who's going to be the people or the entities that will be the subject of the rating?
Developer builder, one entity, whoever is going to be contracting. That may well be the SPV, but then backed by the head party. Developer builder, 2, I think.
All right.
But these are questions for the Building Commissioner.
But
they are, but
to
it's
be
interesting, isn't it?
But presumably they recombine, don't you? You don't necessarily have the same developer and the same builder working.
Yeah, correct. There might be 2 different apartments. It's 2 different teams.
How do you know over a period of time the rating is a combined rating of 2 entities that have combined for one specific purpose, and then they go their separate ways? What value does that information actually provide to the consumer then?
So a fair bit of it is then the value it's providing to the regulator to then ensure that these entities have passed through, and then the way that the OBC are using that process to then ensure up the rest of the development process, the banks and the other providers in that process.
I guess just to pick up on the point that Ms. Hussos made, a lot of these questions are more relevant for the building commissioner. But from your perspective to both organisations and what you can answer, how do you see this changing the practices of the industry? How's the industry going to adapt? And particularly to Mr. D. Adams' point, is it going to see more people coming together on one project, or is it going to continue sort of those associations because they know the ratings of that other partner, so we'll continue it on? How do you see the industry changing?
Yeah, it'll lift the bar in terms of quality, and if you know your counterpart and you're doing more business with them, it's likely that that would be more often the case. But different projects require different skills. So a developer who's using an external builder may well change the builder and enjoy the confidence of reviewing that star rating as well.
I think also you'll find, in the building and construction game, it's obviously like politics, a very small circle of people working in that field. This basically legitimises, word of mouth recommendation. You're going to know if a developer has good standing in the building and construction game by obviously their rating that they've achieved through iCert. That might encourage you, might not encourage you, depending on how they're rated, to partner with them on joint projects or what have you. So it in a way formalises something which is already informal in a lot of respect, but also allows the regulator to keep track of those developers who haven't demonstrated a certain level of efficacy in the building and construction industry, or those that might potentially have less than satisfactory background.
I think it goes beyond that as well. I think it goes to the heart of what the Building Commissioner is trying to do here, and that is to raise the bar in the industry. So by having levels of certification, you can have, is an aspirational target to have organisations aiming to increase their compliance in order to build their business relationships, increase the quality. It relates to the output and quality that is saleable, and therefore increased demand for hopefully a higher quality product, and collectively just goes to the heart of the role of the Building Commissioner, which is to raise the bar of the industry.
Do you see it entrenching current players at all?
I think that is one of the challenges. How does the industry reinvent itself when you don't have a track record? You might bring on, 30, 40-year experts into your new construction team or your new developer. There's some of the issues again in front of the Building Commission.
But isn't one of the other issues that the final product is some buildings will have 3-star, some buildings will have 4-star, some buildings will have 5-star. That'll play out in terms of what the purchase price is, and therefore the people who can least afford it are the ones most likely to have a defect-ridden building. And that creates that, just shifts down the risk again to the people who have the least capacity to afford it.
It wouldn't necessarily equate to a higher sale price if you had a higher rating. There's been no sort of evidence presented to us in that respect, unless I'm missing something that the committee's been privy to.
But but in terms of supply and demand in the market, that the market's going to be looking, people who want a 5-star building with less risk will be paying more for it, effectively.
My assumption is, if you had all things being equal, an apartment over here with similar views, similar facilities, it's done from a 3-star developer and builder. One next door is 5-star developer and builder. If that doesn't play out in the final price, I'd be surprised. So do you disagree with that, Mr. Kekovich? You're the property industry expert, I'm not.
Well, we have to see it play out first before I can comment on something along those lines.
That seems to me, though, to be one of the most obvious conclusions in this.
I think it's a fair
don't accept the
proposition.
obvious conclusion in it?
Let's run with it. Therefore, what's the question, I guess?
Well, the question is, does that then shift the risk of defects, a building with less guarantees in it, shifts the risks of defects down to those people who can least afford it, the ones who are...
But what's the alternative?
Yeah,
the alternative is you insist on a higher standard for all buildings. But I'm asking you about the shifting of risk.
Well, I think already is looking for a higher standard. 3-star is a high standard, and that's the pass mark as far as the Building Commissioner is concerned. And as I explained, there's some complicated reasons why you don't get the higher star rating that don't necessarily go to the capabilities or the history of how that developer has performed.
But
Can I ask-
just
can
on
I
this
just ask
point,
a question?
is it on this point?
What I'm interested in is, And it arises out of evidence that we received on a previous inquiry, and don't ask me which, because I've been on so many, it's all become a blur. But it was that the primary area of insurance claims was waterproofing.
Yes.
And let's just supposing that's external waterproofing rather than bathrooms. That's a problem that arises or becomes evident not in year 1 or 2, but maybe in year 10 or later. It seems to me that a lot of the buildings that are being built now have a high aesthetic quality to them. It's either in
You're walking
garden
around.
beds, etc., are all hanging off the side of the building, coupled with aluminium cladding down the sides of them and the like. So how does your star rating deal with the fact that potentially what we're doing is building buildings that may be really well built, but the problem isn't the build quality, the problem is the design, and that problem comes out in year 10 or 20, not in year 2.
Yeah. The Design and Practitioners Act has done a fair bit towards looking to achieve that in terms of lodging the construction, the as-built drawings much more quickly, and looking at the question of how variations are dealt with. I think your proposition is a fair comment. We build more complicated buildings. There's more complicated systems in managing those buildings as well, and that's also been a focus for the Commissioner.
Well,
that's right, but how is that built in? How is a warning given to the consumer that you get it in cars? Like you're buying something that the ongoing maintenance cost is going to be very high, or potentially on an upward curve as these complex systems start to develop problems? Or do we just ignore that as just one of those things? Like you can go to Rome or Paris, you'll see lots of buildings that are sort of walk-ups. All look fairly the same. Been there for 100 years or 200 years, they seem to work. We build apartment blocks in Sydney where you really wonder what they're going to be like in 25 years. We seem to be building almost, it's unfair to call them prefabs, but like real problems waiting to happen. It seems to be, to me, we're not building for longevity nowadays. Am I wrong?
So the premise of the work of the Building Commissioner is to increase the quality of the apartment buildings and the way in which our practitioners work together. So the whole premise of the work of this Commissioner is to address these issues. Now, rightly, we should have systems in place to address defects that happen down the line, and I think that falls into the detail of the work that sits under that of the Building Commissioner. But we're in furious agreement that those that purchase into apartment buildings should have a guarantee or some sort of support to ensure that when defects occur, that they are adequately and safely addressed. So I don't think we're in any level of disagreement with you there.
I suspect not. But the problem is, sorry, Mr. Mann,
I was just going to add, as we look at things like green roofs to combat, heat gain and the like, they're going to stay complex. They're not going to lessen in complexity. I think it's a reasonable question. I'm not sure it's as simple as complex building means you're going to have problems. It needs to be very well designed and then constructed, which I think there have been strong steps towards improving that. Most of what we're looking at the moment is problems that have occurred prior, not looking forward.
But the part of the answer to this going forward, put forward by the Building Commissioner, is we have this rating system. That's going to be one check. I've raised potential concerns about how that will play out in terms of the economic fairness. The other big part of it is 10-year insurance.
Yes.
Like you have a 10-year insurance product, which will be voluntary. Is that your understanding? It won't be mandatory. It'll be an option available for some buildings.
I believe that's still to be decided as to whether it's voluntary or mandatory, and may be managed through the rating system.
Constable, Mr. Kekovich, do you know where we're going in terms of voluntary or mandatory on 10-year insurance product?
No, sorry, I don't have any further information on that one.
Kekovich? No, neither. Well, my understanding from the Building Commissioner is that this will be an option available and can be taken up by some buildings. That's the government policy. Again, we get this point that people who can afford to pay for it will get a 5-star building with 10-year insurance. They'll be all right. Everybody else who can't afford to pay for it will get a slightly cheaper unit, which doesn't have any of those protections. Are we just entrenching the problems, but downshifting it to those who can least afford it? Mr. Mann?
I think we need to make sure that's not the outcome. Absolutely agree. And I think the intention is that we're lifting the quality across the industry, definitely.
But if you can avoid the integrity measures by getting 3 stars and not getting the insurance, how does that lift it across the industry?
It lifts it because the buildings that may be in production or have previously been in production that have had issues are those that would otherwise be rated 1 and 2 stars. Through this process, they won't be able to be developed. Now, I understand and register your concerns about the variability between 3 stars and 5 stars, but what we know is 3 star is a passing mark, 3 star is a safe building to operate in. Now, whether the design is as vibrant as need be, or the history of the developer goes back the length of other developers, may impact on the rating difference or differential between 3 and 5 stars. But it is the intention that if 3 stars is a passing mark, then 3 stars is a safe product to purchase into and live within. And I think that is the ultimate aim of this legislation and this work, is to ensure that when you buy into an apartment, you have that safety and that guarantee in that work, and that is the aim. Now, if we set a competency achieved mark and anything over 3 stars was considered fine, that may have differentials in pricing or other elements down the track. But does it give aspiration to those that building at levels, that's 3-star levels, aspiration to increase the quality further? It wouldn't, no. So I think...
Well, insurance will potentially be cheaper if you've got that higher star rating, so that's going to be a goal. And then, of course, there are other protections, which is the OC audits. So the intention is you're still building a quality building, and an OC audit that 6 months before any of those issues will be detected.
But if we go down this path of 3, 4, 5, there will be a difference in build quality, and then some buildings will get the 10-year insurance and some won't. I assume that will impact, Mr. Kekovich may disagree with me, but I assume that would impact upon purchase price. And so the cheaper building will be 3 stars without insurance, and we get to that point where the people who can least afford it are going to be having the highest risk of defect-ridden buildings. And that just
but
doesn't
how's that
seem...
different to what's happening
That doesn't
now?
seem right, and I'm interested in the witnesses' response, and then...
Is it the position, as you anticipate, that the lower rated buildings will be the one that the building commissioner spends more time inspecting and pursuing?
The intention is those developers are not in New South Wales. And I think it'll be quite untenable if they're having to have a lot more cost, they're potentially getting lower prices, they've got bigger focus under OC audits, don't work in New South Wales.
So effectively, those players have run out of the market.
Yeah.
But through what measure?
Well, access to finance.
Yeah.
Well,
pursued by
Mr.
the
Khan,
building commissioner.
you haven't been sworn in, Mr. Khan, so
Well,
I'm going to ask the witnesses. Could I ask the witnesses?
what
Could I
he
ask?
said, David.
I might just ask the witnesses.
It's what he said.
I might just ask the witnesses.
Yeah, that's what I'm explaining, that I think it will be untenable to do business at below 3 stars.
Right, but nothing mandatory. There'll be market forces that will drive them out.
I believe that's the intent of the government.
Do you think market forces have been working well to date?
I think market forces have changed dramatically since the work under these 2 acts, absolutely.
Well, how has that played out?
That's playing out with developers who have got problems going into enforceable undertakings to fix those, with a real focus from the industry around quality and working with the Commissioner with more training. Yeah, it really is quite a comprehensive...
That's a response to the activity of the Building Commissioner, not a response to the market. That's actually regulation that's doing enforceable undertakings. The market doesn't put in enforce. I'm asking you how the market's going in terms of ensuring quality in buildings.
How the market is going?
You say that's the
Well,
that's
the
what will drive
market's
bad developers
depressed,
out.
but
How's
that's
it
for a
going?
whole heap of reasons. It's down by about 50%. But the market is still trading, and backing quality developments, buying apartments. Absolutely.
How is the market backing quality developments? How does the market tell if it's a quality development or not a quality development at the moment? There's some mystery of the market that identifies build quality?
Well, the market is still active. That's how I was answering. You're asking how is it responding? Well, it's still trading at 50% below
I think
where
Mr.
it was.
Shoebridge's question was how was the market responding to these issues, not necessarily how the market was going generally.
Well, you said the market will drive out bad builders in the future. I'm asking, and you said it's already having that impact now. I'm asking you how it's having that impact.
I think I suggested the regulation will drive out bad builders, not the market.
Well, maybe we'll
yes,
go
the
back
market will respond to that and be warned and as you say, not pay as much or not trade.
Mr. Kekovich doesn't seem to think that there's any sort of inherent market-driven indicator from 3, 4 and 5 stars. Is it? I just don't understand how your evidence is sitting together here.
Just to clarify Mr. Kekovich's statement is that we haven't yet to see the evidence of these star markers because they have yet to be rolled out. And I understand the position of Mr. Mann, and we would reiterate that the work of the Building Commissioner to set these regulations and these acts make it a market decision as to where to build. And our members, our developers work right across the world, right across Australia, and they inherently look at the very specific market factors through regulation, through planning, through cost of delivery when making decisions on where to build. Through this work here in New South Wales, we are making it harder for developers who don't seek to meet those standards and easier and more credible for those that do. So that is the role of the work that we do with the Building Commissioner.
And look, I've got to say, I take the presumption that, a 5-star developer would be able to market that and be able to make more money off their development by doing so. But I imagine there's a whole range of things that go into a development and marketing a development. And you could be a 3-star developer who says that they've got Miller appliances, for instance, compared to a 5-star developer who has just generic AEG or something. There's a whole lot of...
Generic Electrolux.
Electrolux, sorry. AEG is higher end, sorry. There's a whole range of factors that go in terms of pricing. Yes. Is that correct? Like in terms of how developers market their products?
And there's different products in every building as well in terms of, each apartment. So there would be a value proposition in many apartments.
One matter that's raised in the Property Council's submission is being able to lodge design and compliance declarations through the staged development process rather than having to put it all up front, doing the sort of design work as you work your way through a development. You suggest that would actually provide a better outcome in terms of good design. Do you want to talk to that?
Yeah, absolutely. So the premise for that position is... the premise for that position is that as a development is built, if there is a change to the regulations, then the work that has been done to reinforce those buildings at a ground level or sub-ground level needs to be able to support the building as it goes up. If the work that needs to go into that building changes throughout the development stages, then it may not have the right footings and groundings to be able to support the change development that happens at different stages of development. So we think it's really important that once you've built the ground floor and the floor, the solid base for that building, that you then build the building that is expected upon it, so that it provides a safer outcome.
It does also provide further surety to the market who perhaps may have purchased off the plan for that particular development. For instance, it may be marketed with a 3-metre ceiling height. If there was a change to BCA code during the development of that particular Class 2 building, that might have impacted, say, the height of the ceilings, and the end consumer may be receiving a 2.5-metre ceiling or a 2-metre ceiling as a result of that. So it does also create a bit of certainty to market, and really does reinforce the need for sort of clarity moving forwards for developers.
I thought they were different issues, changes in building code and staged lodgement from reading your submission, but perhaps I misread it. Unfortunately, we have run out of time. Thank you for your submissions and your assistance today. I'm not sure any questions were taken on notice. And we will go into recess until 2 o'clock.
Thanks very much.
Thank you.
Very good.
Welcome to this afternoon's session of the Public Accountability Committee's review of building safety and building compliance in New South Wales. Our next panel will have two representatives from the union movement, the Compliance Officer from the Public Trades Employees Union and the State Secretary of the Fire Brigade Employees Union. Mr Drury, Mr Tsoukalos, thanks very much for coming this afternoon. If I could ask each of you to take either an oath or an affirmation and state your position title, and we'll proceed. Starting with you, Mr Drury. Name, position, title, oath or affirmation.
Leighton Drew, State Secretary of the Fire Brigade Employees Union. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Mr Tsoukalos.
I, Tsoukalos, Organised Compliance Officer for the Plumbing Trades Employees Union of New South Wales. I'll take the oath. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Now, Mr Tsoukalos, thank you very much for your submission. We have read and digested that. I might ask you both if you wish to give a short opening statement. We might do the same order we swore you in, Mr Drew.
I do, Mr Shoebridge, and with somewhat leave of the Chair or the Deputy Chair, I do have a couple of pages here. It won't be too onerous, perhaps 3 to 4 minutes, if that's all right.
Well, yeah, we'll get started.
No worries. Yeah. Good afternoon, and thank you for the opportunity to address this committee. As stated, I'm Leighton Drew, the State Secretary of the Fire Brigade Employees Union. The FBU represents 6,500 professional firefighters across New South Wales, with over 95% of those firefighters being members of our union. As you would know, Fire Rescue New South Wales protects 95% of the population of New South Wales. I've been a firefighter for 21 years. I'm here today to address, I suppose, several other related matters as outlined in the committee's terms of reference. And one of the things that I'm asking today in my evidence is for the committee to take into account the following, if any recommendations are made. Now, one of the main reasons this inquiry is being held into flammable cladding is the tragic loss of life at the Grenfell Tower, which I think highlights the problem that this committee is here to discuss. I'm also here to talk about the systemic lack of fire service and the increasing risk to the community. So when playing, I suppose, in the firefighting world and the lack of resources that we're receiving as professional firefighters, I'd like to address a couple of different topics. One of those is aerials and no new fire stations. New South Wales has seen extreme population growth and urban sprawl, particularly in the west and southwest areas of Sydney. Oran Park, Marsden Pass are examples. This growth has outpaced emergency services infrastructure and support. Now, these I make no qualm about this. These communities are at risk as we speak. We've also seen an explosion in high-rise buildings becoming more and more commonplace, and therefore our density of aerial ladder fire appliances, these are the ones that deal with these high-rise fires, certainly have not kept pace. And it's certainly not there to address the risk that is being put in place by this building work. Now, certainly what we've seen in Europe and overseas is that the lessons from Grenfell are being taken seriously. We're having appliances that are taller and more equipped to deal with the complex fires that are occurring, put into service to manage that risk. And what we see as the union is that fire rescue need an increase in its funding to maintain those adequate resources in that context. Another disturbing fact that we're seeing out of this government is closures of stations. Now, the members on this committee may not be aware, but we're seeing the proposal of Redfern Fire Station being closed. Now, obviously, Redfern's in the city. Fire Rescue New South Wales, due to budget cuts, looking to amalgamate Redfern Fire Station with Alexandria and rebadging it. This is obviously a reduction in services and not an improvement nor an increase. Redfern attended 2,326 incidents in the last financial year alone. On Regent Street, we're seeing exponential growth in high-rise buildings. Building owners are reaching out to our union, something that generally doesn't happen, interesting, with our union. Building owners reaching out to us with their concerns. So it seems quite remarkable that a government would think it appropriate to allow this fire station to be shut down with the growth that is happening in that area. Another thing that's in dispute at the moment with the union and fire rescue, and obviously the government, is a proposal, and if you read the papers recently, fire rescue and the minister plan to take offline a large number of our retained stations across New South Wales. These stations rely upon the availability of on-call firefighters. Now, due to the lack of extra on-call firefighters and budget cuts, we're seeing stations being added to the list of already too many stations that can be taken offline. Stations under this proposal are stations like Rhodes Fire Station, Marylands Fire Station adjacent to Parramatta, Mortdale Fire Station, Bundina, Helensburgh, Scarborough. These are stations in well built up areas, and those communities deserve the response that they obviously deserve to make sure that it keeps them safe. Depriving the community of a fire response is not the answer, and we've spoken to some of those impacted communities recently, and they expect better services. Another problem that we have within fire rescue that we see is a lack of resourcing in training. Specifically, I suppose, to this committee is a lack of training in complex high-rise fires. As you can imagine, a cladding fire is a complex fire. They're dangerous and can be overwhelming. Now, firefighters must reflect these conditions and combat them. Currently it does not, and compounded by a lack of increases in aerial resources and stations being shut, this will be a recipe for disaster. Because not only does it put firefighters in unnecessary danger, it increases the potential for the loss of life in extreme high-rise buildings. Going on to, probably not to cut into my comrade over on my left, but we do have a lack of staff in our fire safety and building regulation section in fire rescue. Firefighters are the subject matter experts when it comes to fire. They must be involved in the decision-making process from start to finish to ensure compliance with regulatory and legislative obligations that provides fire safety within the built environment. Fire Rescue New South Wales Fire Safety Branch is charged with minimising the potential consequences of fire and other emergencies on firefighters and the people that they're there to protect. They are a relatively small team compared to the enormous tasks before them, and without appropriate funding, it becomes an impossible task. Having projects come to Fire Rescue New South Wales Fire Safety Team at the brief and design stage will lead to better outcomes for everybody. We're seeing these too far down the line and then not being able to pick them up before we can make those changes. Again, reducing services is not the answer here. In addition to the Fire Safety Team, the local knowledge of fire stations crews is very important. In conclusion, everything that I've just described there leads into what happens from the start of a building to the end where we have an emergency. And what we're seeing is this systemic watering down or reduction of resources to make sure that our communities are safe and firefighters are safe. And we've been seeing this now for 10 years. I think this committee has heard me say this before, but I will say it again. We have less professional firefighters now in 2021 than we do in 2011. We've seen, over 1 million people moved to New South Wales, and I couldn't even tell you how many buildings have been put up in that time. It is time for this government to act, and we certainly call for more funding to address that situation.
Thanks, Mr. Drury. Do you have any of that in writing there? Could you provide a copy to the Secretariat? We'll get it to
all except the conclusion.
Circulate. Mr. Sakoulis.
Hi. Hello, everyone. Thank you very much for the opportunity to contribute today to the Upper House Committee inquiry. We believe that the quality and level of regulatory oversight in New South Wales can improve significantly and must improve if public safety is to be maintained and public confidence in the system is preserved. Our context, our background is that the PTEU strongly support the committees which is aimed at improving the efficiency and adequacy of the government's regulation of the built environments in New South Wales. Unfortunately, in New South Wales, the regulatory regime is non-existent at the moment in certain sectors of the importance of fire protection and also in the plumbing sector. We believe now moving forward that these issues that aren't identified and our key issues are to improve fire protection licensing and registration will obviously improve community safety. From these frameworks, we believe to better protect the community and property in the event of a building fire. We also want to see the reduced risks of fire deaths and fire injuries and property harm and destruction. We also want to improve training and safety for fire protection workers, improve the compliance with building fire safety regulation, leading to reduced costs for owners, occupiers, government, emergency services and local government, increase community confidence that the work being performed is performed by appropriately skilled workers to prescribed standards, and also with that to reduce risk for firefighters responding to fire emergencies. Examples of this where they reduce the risk of fire deaths and fire injuries is property harm and destruction. Cast our minds back 12 years to the Quakers Hill nursing home disaster. We believe that if anyone sleeps and puts their head on a pillow, that there should be the person installing that work, maintaining that work and servicing those systems has to be a licensed and competent person. In New South Wales, that is not the case. These lead to these catastrophes that happen. As was mentioned by my counterpart, my comrade to the right, in regards to the La Crosse Tower in Melbourne and also the Grenfell Tower in London, the Grenfell disaster was an extremely tragic example where the use of inappropriate materials with inadequate fire protection systems resulted in catastrophe. In Melbourne, the La Crosse Tower was clad in the Grenfell type flammable aluminium cladding and the fire spread 13 stories in 13 minutes. If it wasn't for the well-functioning and properly installed and maintained fire protection system, the La Crosse fire would have been a major catastrophe. A further fire broke out in Melbourne at the Neo 200 apartment building in Spencer Street in Melbourne CBD in February 2009. Again, it was the effectiveness of the fire protection systems which prevented a large-scale tragedy. In New South Wales, the state's cladding task force has audited over 185,000 building records and conducted over 4,000 inspections. As a result, 225 buildings in the state have been deemed high risk. The fire risks posed by flammable cladding are clearly unacceptable. There are two main ways we can address and reduce those risks, both of which are important. One is to remove the non-compliant cladding, and another is to make the occupants of those buildings safer. The current policy approach is to focus on the removal and replacement of non-compliant cladding. We support the intent to remove all non-compliant material from New South Wales building stock. However, we're increasingly uncertain about the extent of which is this practically achievable. We also believe this, accompanied with the strong licensing regime for testing and maintenance, will help get to across, because as we know, all these necessary funds that are required to do all this thing may have a huge impact on cost on Strata and on building funds. We believe the effective, we need and also believe that the effective fire protection that requires a minimum higher level training that's currently in place. Thank you.
Thank you both for your opening. Mrs. Tsakoulis, do you also have that in writing, your opening statement? Could you provide a copy to the Secretariat? Thank you. I'll hand over to the opposition to commence questioning.
Thanks very much, Chair, and can I thank you both for your time, for your opening statements, and in particular to the plumbers for your submission. I have been using that as the basis for a number of my questions this morning. So,
this is true.
I don't expect that you've been watching it closely, Mr. Tsakoulis, but I can tell you that your recommendation to licensed fire maintenance workers has certainly received endorsement from a number of stakeholders this morning. We heard from the national fire industry that it should actually be, they recommend a Cert 3 for maintenance, but then they also have a recommendation that they spoke to us about Cert 4 for actually the commissioning of the work. Yep. Do you have a view on that?
Well, this is the level at the moment, looking at what's there at the moment. Obviously the Cert 4 involves the design and then the ongoing certification, the ongoing maintenance. Therefore, there are a lot more things that identify in different types of systems that you have to also be aware of, and you know. So obviously the Cert 4 in design, I think that they're advocating, I believe, is what we would support as well, because it's obviously we're trying to create a level. They're obviously going that level higher, which is good. We're talking about the installers, so we represent more the guys that are actually doing the installations, the guys on the ground. They're actually working for fire protection companies, so therefore that back end that would be required in that company to complement the Cert 3 practitioner or tradespersons that we represent as well is a good thing, obviously, because they need that extra technical as they're doing their work, that back end support. So yes, we would support it. So
we heard that there's been a fire accreditation scheme, I should say, that's been in place for just 12 months. One of the things that the National Fire Industry Association told us about was that, well, I think the quote was, there's been lots of teething problems, and one of the problems has been that the checks that are required under the accreditation scheme are actually then uncovering issues that should have been done at that installation stage. Do you have any feedback on that?
Yeah, we see that
we
see that a lot in the passive fire space as well, where at a major shopping centre just recently, one of our fire contractors, this is a project that was finished 5 years ago, and they had 500 passive fire jobs. So passive fire is the protection so the fire doesn't spread from one part of a building to another. So they'll, through ductwork, through penetrations and stuff like that. So this major shopping centre now had 500 defects that had to get rectified. Now that wasn't picked, so at construction it wasn't picked up, so it wasn't picked up to the 5-yearly test after. So this is a main thing that a lot of these defects don't get picked up until the 5-year test. So that's a big concern as well. So
Or a fire.
Huh?
Or a fire.
Or a fire, yeah, again, or a fire. So we're waiting 5 years. So these accreditations that they speak of, because the people actually doing that, they're entry level, let's call them entry level practitioners who are do a Cert 2 for 10 days and all of a sudden go around doing an inspect and test. They didn't actually build the building. They didn't design it. They didn't work on it. So therefore, they don't know what they're looking for. They're just ticking and flicking. It says, I've got to do a monthly test, and I've ticked that, the door works and the hydrant's got a bit of water, the hose roll's got a bit of water, and they move on. The license, the Cert 4 equivalent, Cert 3, equivalent tradesman that actually worked on the tradesperson, please excuse me for that, that actually worked on the building actually knows the difference. So when they're actually doing their inspection, they can identify, they would have picked that up in their first monthly or their 6 monthly or their yearly test because they would have seen it's not there. There's examples, which I should have brought in, where fire protection, there's 2 levels of fire protection. There's the one that you can see, the sprinklers, and there's a ceiling space one, because obviously if there's a ceiling space on the fire, you can't see it if you're in the building and it spreads. That there's buildings, numerous buildings, that they didn't actually put it in at all because it's a cost cut, because you can't see it. So these examples should have got picked up at a test. They're not getting picked up till the 5-yearly test, which is actually, you need to be a licensed and a registered tradesman to do those tests. That's why these things get picked up at the 5-year test. That's a long time to wait. So, minimum entry level, Cert 2, 10-day course, no experience, go around, tick and flick. These examples that got picked up at the shopping centre down south, got picked up at the 5-year. So for 4 years, what happened?
So, Mr. Scholes, I assume that you support the idea of
Yeah,
having
I do.
a Cert 4,
the examples why we support it. Yeah.
Cert 4 qualified fire engineer, basically, sign off on the commissioning.
Yes, 100%.
And that's that it's been constructed as per the designs and that it meets Australian standards.
Yeah, yes.
Because this isn't the case in other states. For example, in Victoria, they actually have a more rigorous system. Is that correct?
Yeah, well, they do, because it's from early on, because your licensing and for your annuals, and see, because there's different types of different levels of testing. So there's monthly, 6 monthly, yearly, 5 yearly, 10 year, 25. So when you have that the more stringent level early on, these things don't fester and get left behind. So the problem is that they might have, say the Cert 4, like it wasn't installed correctly, which we've had examples of. Then you move forward to the person that's doing that first, even in his monthly, he would pick up those things. But if you're only doing the test says, I have to just tick this, that the light works, you're not looking for the other faults because you never worked on it, you've never seen it, you've never got the experience on it, and that's where these issues then only get picked up when an actual licensed and registered person that's a Cert 3 equivalent then goes and does the testing to confirm that what the building was as installed. That's, again, the issue, that it doesn't happen so much because you've got licensed and registered tradesmen doing those tests earlier. So we're not waiting for that 5 years for these things to get picked up.
Yeah, I mean, it's consistently come back to us this morning that it's how the system works. It's not just the individual components. It's actually how it all works together. That's with a range of things. So that's Thank you very much, Mr. Tsoukalos. Can I just ask Mr. Drury just a couple of quick questions? I saw you nodding in agreement about a couple of the points there. So would you like to respond to those?
Yeah,
Mr.
look,
Drury?
I absolutely agree. The way that firefighters work, we look at a building, we obviously understand the class of the building and what fire protection levels it should have. We then have a pretty good idea of what sprinklers it'll have, what mechanical air handling systems it'll have, whether stairwells are pressurised or not, what fire ratings of walls. And if those things aren't in place or put in by somebody who's shoddy, then we're setting up systems and operations of attack or defence based on that information. And the reality is, if in these cases where these things fail, that it ends up being catastrophic, because you end up putting crews into places where they shouldn't be. You send, evacuees into places that they shouldn't be. And that's one of the biggest problems that I think you'll find coming out of Grenfell, is that there was a building that wasn't compliant. I mean, there was a litany of failures around, services and council approvals and all that stuff with Grenfell. But if someone had checked something back then that had the proper licence, and certainly the FBU supports licensed people to install this work because it keeps my members safe, you're just not going to see that level of tragedy at the end. There's always going to be problems. There's always going to be accidents. I mean, my industry wouldn't exist without accidents. But how you minimise those, that I think is where it comes down to with regulation and obviously, having licensed people installing these sorts of things. I'll just make one example. Like, there's difference between the amount, like the type of glass that you put into a sprinkler head. That matters, because it opens at a different temperature. Now, some people don't know the difference between that. There's nine different sprinkler heads you can put in. And I've been in places where, the highest rated temperature shouldn't be, should be one of the lowest, because it's in a residential place, which means the temperature needs to hit, 30 degrees higher than what it does. That's the difference. And it's a very, very little difference that no one can pick up on unless you look at the colour of that glass and go, oh, that's black and it should be red.
Yeah. Mr. you were talking about the staffing numbers to review fire safety issues for new development, particularly with multi-storey development. We've seen a surge in multi-storey development in the last few decades, and you were indicating the staffing numbers have not kept up. Do you want to take us to that?
Yeah, look, certainly what we saw a few years ago was a decrease in our fire safety sections. We've got a number of them: alarm reduction, building compliance, building surveying, doing fire safety certification. One of the regulations that's changed, which I still disagree that shouldn't be changed, was around the must to may in delivering a fire safety certificate. There's now an algorithm that chooses which buildings we have a look at, compared to we used to look at every single one of them. My understanding is that fire rescue have started to implement more staffing, but it's nowhere near going to play catch up to what we've seen happen in the last decade. There are a lot of buildings out there that would nowhere near be compliant, and certainly we're not seeing a slowing down in building works anywhere. I mean, you go anywhere, a kilometre anywhere, and you'll see a crane in the air. And they're the buildings that are the more complex fires, where we do have probably a greater life risk. And I suppose, again, if we're not having the right regulation, the right design, the right regulator, and then the right response when we do have a problem, we're going to have a worse result.
And this is in the context of there being a default approval if matters aren't addressed within 42 days. Is that right, for
That's
these
correct.
concurrents? So a lot of multi-storey buildings, as I understand it, are being ticked off on a fire safety standard simply because the resources aren't there to check.
Correct.
Mr. Tsoukalos, are you aware of this issue?
Yeah, yes. Unfortunately, we are.
In your words, what's happening?
Well, again, sometimes it just comes down to cost. The one fire practitioner will knock it back, and then they'll just go shopping to get the desired result that they need to get something approved. And that guy disappears, and he signs off, and the company goes away, shelf companies, and they just keep working for in that same sector, keep doing the same thing over and over again. because they're not licensed, you can't look on fair trading to see who they are. So we've got a system of fair trading where at the moment, someone knocks on your door and they're an electrician, they're a plumber, they're a builder. You can look up their name to see if they've actually got an accreditation. Well, for fire protection, you don't know what you're getting. So people know that loophole, people use it. There's a network there of people that, you know, when they get stuck, they'll ring each other. I know someone that will sign it off for you. And it's just a never-ending story, unfortunately. So with no regulator, no strict licensing regime, these situations just fester, and it's not until we get to a 5-year or a 10-year test that we actually then start seeing these faults getting picked up that were signed off 5 years previously. Until we know at the 5-year mark, we're guaranteed to get someone that's a Cert 3 trained in fire protection that will do that work to be compliant.
You are very critical in your submission about the current regulatory framework, and you call for, as I understand it, some kind of specialised regulator for, at least for plumbing work. Did you want to speak to that briefly?
Yeah, I'll give you a classic example. We in New South Wales currently we have major infrastructure projects, and we have these, let's call them, they're a joint venture, that these projects are won by a joint venture, and they believe that, you know, the fair trading is not applicable to them. Right now on a project, one of the major infrastructure projects just up the road here, they don't believe that plumbers should be installing the deluge mains, which is for fire protection on the hydrants. They think they can self-deliver that with unskilled labour. So right now on 3 projects, as we see here, one a kilometre away, one 3 kilometres away, I've put in a request for both. They're just using unskilled labour to install deluge mains. Now, the deluge main in a tunnel is the most important critical aspect, because if there's a fire that's in a tunnel, it's a fire protection system. Now, the main feeding those sprinklers, let's call them, they believe they don't have to do it. Now, when you speak to the regulator, they say, send us an email, you'll get an email, you'll get a response in 2 days. Now, that 2 days could vary. They're not going to go out there. You know, it's a big infrastructure project. It doesn't happen.
Is this the Metro project?
The Metro, we had an issue at the Metro. There was a first example where they had, they're installing from Chatswood to Crow's Nest, and they had unskilled labour installing the pipe. We pulled it up on them now. So then they've now, after installing the first 3 kilometres in each tunnel, so 6 Ks, they got stuck because they couldn't test it properly. They didn't know when you test a lineal pipe, for example, it expands. So they got their testing wrong. So they've stopped doing the testing. They're going to contract that out to a plumber, and now they're going to do the installation. They're going to hire plumbers to do it.
What is this safety system that
the fire hydrant system? This is the water that feeds.
This is the fire hydrant system.
Yeah, so they don't believe they had to have a license. Even though fair trading on their website, before any plumbing is given out, you have to have a license.
So there are 6 kilometres
that were installed by guys that weren't plumbers, yes.
And on which project are we talking about?
On the Metro from Chatswood to Crow's Nest.
So 6 kilometres of the Metro line from Chatswood to Crow's Nest has the fire hydrant system.
Main, yeah.
Yep, installed by anybody.
It was just there was a crane driver, a rigger, a TA, and I think let's call him someone else.
And who signed off on that?
They have, because we stopped them. We went in there and said, this is a licensing issue, you're doing the wrong thing. So they've stopped that work. They're going to contract out a little bit more, and away you go. So now they're going to stop the guys, because this is happening as we speak.
Yeah.
So they're going to engage, they're going to hire some plumbers. And I said, well, you can't actually do that, because fair trading actually say that before you do any plumbing work in New South Wales, you've got to do an application. They don't have a license to self-deliver. So this is a big issue.
But what's going to happen to the 6 kilometres of non-compliant plumbing that they've got in the Metro project? Well, that's a lot of plumbing, by the way, 6 kilometres.
Yeah, that's right. So we're working on it at the moment. We're hoping the regulator steps in. But unfortunately, our history like it, it started when I started the union out at Leppington Rail Link. They used a civil company again, and it cost them an extra $2 million to get it all inspected. WestConnex 1A from the tunnel from Concord to Haberfield, when they tested it because they had unskilled labour again, it weren't plumbers, the Jersey curb blew out when they did the test. So this is a systemic problem in the infrastructure space where they believe they don't have to comply with New South Wales regulations for the deluge main installation.
Yeah, and when you say deluge, that's the chunk of water that the sprinklers deliver to put out a fire, which is what you want in a tunnel.
It is absolutely key, Mr Shoebridge, in tunnel fires.
So right now on 3B WestConnex, they've got a contractor there. They told me who the contractor was. I went to Fair Trading and I looked up, as you do, which is just public information, and they don't have a plumber's licence, the company.
And when you contacted Fair Trading about 6 kilometres of non-compliant
Send an email.
Hydrants on a major infrastructure project, when did you contact Fair Trading?
I'll have to take that on notice on that date, sir. I can't remember the date, but it's
What
an
was
email.
the response?
Yeah, the email.
Timed over or?
It's just an email. You can't speak to the inspectors and the regulators. You have to send an email, and they will action it within 2 days.
And just finally on here, what action has happened from Fair Trading about this?
We're doing the action. We're the one pushing what we're doing. I can't comment on Fair Trading because I can't wait.
Mr. Khan, did you have any further questions?
No. I was just taking a bet as to how many there was.
Well, I think 6 kilometres of
that's
Mar and Par kettle hydrants on a major infrastructure project is worth a couple of minutes of questions.
Yeah, so I can.
Once.
So what happened?
I'd be quite comfortable, but.
So the issue was there that we had a safety concern, so we had to walk from Chatswood to Crow's Nest in the tunnel, and as we're walking through, because they believe that if there was a fire, again, the emergency evacuation plan said that the only exit out was back at Chatswood, so if you were 3 k's in the tunnel, the only way you could get out. So we went for a walk, and I was seeing the pipe, and I go, who's installing? And this is how it started. But again, at that time, when we were doing the safety concern, we couldn't talk about that because it's a different permanent, different issue. You're not allowed to overlap that through the WHS Act. You know, we had a safety concern, which was justified because why would you walk 3 k's back through a tunnel in a fire instead of trying to get out at Crow's Nest? So that was a separate issue. Yeah. And then that's where we were able to see the pipes installed.
Mr. Drew, Mr. Tsoukalos, unfortunately, I think we've run out of time. Yes, we have run out of time. So, indeed. I'd blame the chair for that. Thanks very much. I don't think you took any questions on notice.
Mr. Tsoukalos just took one at the end.
Oh,
just for the date for the Fair Trading.
Yeah. Indeed.
I'll
Thank
get
you.
that. Yeah.
And if in answering that you've got any more details, photographs or other about that issue, feel free to expand on their non-compliant.
I can give the Metro. I can give 3A, 3B, 1A,
provide what
1B.
you can. Provide what you can, Mrs. Tsoukalos.
No problem.
Thank you very much. We'll now have to ask you to step out, and we will apply the COVID-19 cleanse. Not to you, to the desks, Mrs. Tsoukalos.
Sorry.
Yeah.
Sean thought he was going to
We're not going to put you through we're not going to put you through the COVID shower today, Mrs. Tsoukalos.
Thank you very much.
Thank you. Thanks very much, guys.
These are most useful if we get them during the currency of the questioning. Yeah. That's okay. I understand. Yeah. So if we can get it copied and circulated, because then we can. Are we ready now? Ready? Mr. Chandler, Mr. Tansey, please come forward. Mr. Curtin too, and Mr. Visnes. Thank you all for your attendance this afternoon. Is everyone settled? We might just do the name, position, title, oath or affirmation. Starting with you, Mr. Curtin, we'll just work our way across.
Yeah, Trent Curtin, Acting Deputy Commissioner of Field Operations for Fire and Rescue New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thanks, Mr. Curtin. Mr. Visnes?
Jamie Visnes, Manager of the Fire Safety Policy Unit at Fire and Rescue New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Mr. Chandler?
David Chandler, New South Wales Building Commissioner. I swear that the evidence now about to be given by me shall be the truth, the whole truth, nothing but the truth, so help me God.
And Mr. Tansey?
John Tansey, I'm Executive Director of Policy and Strategy in the Better Regulation Division of the Department of Customer Service, and I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much for your attendance this afternoon and for the government's submission to this inquiry. Do any of you wish to give a brief opening statement? And we might go in reverse order. Mr. Tansey?
No, thank you.
Mr. Chandler? Mr. Curtin or Mr. Visnes?
Just a quick one on behalf of Fire Rescue New South Wales. We thank the committee for the opportunity to participate today. For context, I'm currently the Acting Deputy Commissioner of Field Operations. My substantive role is Assistant Commissioner.
Pull the mic a bit closer, Mr.
Assistant Commissioner for Community Safety. Having previously held a similar role in Victoria and having had responded to a cladding building fire in Victoria 2 years ago. I have with me Mr. Jamie Visnes, who's our Manager for Fire Safety Policy. He's a highly respected fire engineer and is responsible for developing policy and advocating for improvements in regulation of the built environment, both in New South Wales and across Australia. In addition to our better-known role responding to calls for assistance for fires and other emergencies, Fire and Rescue New South Wales performs a really important role in improving safety and resilience in the built environment in New South Wales. Through our Community Safety Directorate, we provide subject matter expertise and advice to industry on various matters relating to safe evacuation, fire brigade intervention, and fire and life safety matters in the built environment. We've recently been engaging in several forums advocating for an enhancement of the role of Fire and Rescue New South Wales. We've also been working to improve our efficiency and our resourcing to better support the building industry. We've got an important role to play alongside other government departments in improving the safety and confidence in the built environment in New South Wales, and we welcome the opportunity to take any questions today.
Thanks very much, Mr. Curtin. I'll hand over to the opposition to commence questioning.
Thanks very much, Mr. Shoebridge. Thanks very much for your time, everyone, this afternoon. Mr. Chandler, you would be aware that Privium Group stopped work on their building sites on Friday, the 4th of November, and has now appointed administrators.
Yes.
When were you made aware of this?
Well, it's not something that I have particular coverage of, so that was handled through fair trading, but it's I was aware of it, but it's not a matter that I directly deal with.
Sorry, can you explain why you don't directly deal with that, Mr.
Well,
Chandler?
it's a Class 1 building, and my remit is principally on Class 2 buildings. So that was a matter that was handled and responded to directly by BRD. I was aware of the response.
BRD being?
The Building Regulation Division.
Okay. So, Mr. Tansey, are you better placed then to be answering questions?
I haven't been directly involved in it either. I'm aware of the events and became aware, I think it was in last week, or it might have been end of the week before. And I'm aware, I think, of responses to, I think, by CIRA and iCare in terms of impacted homeowners who might be covered by the Home Building Compensation Fund.
So, Mr. Chandler, are you aware of how many homes they are currently building in New South Wales?
No, I haven't been handling this matter directly, but I'm happy to take the questions on notice and come back to you.
Mr. Tansey, are you aware of how many buildings?
No, similarly.
Okay. CIRA has said that home buyers may have access to home building compensation. What would stop them? What would stop home buyers having access to home building compensation? Mr. Chandler?
Look, I think it'd be best directed to CIRA, that question. They've written a statement. I'm not directly involved in the matter. I'm not trying to be difficult, but I really can't add anything more to your question. I can take a question on notice and refer it and get somebody to get back to you with the answer, but it's not something that is in my direct remit.
I understand that, but Mr. Chandler, I'm asking you a question about home building compensation. You are the Building Commissioner of New South Wales. What would be the situation where home buyers would not have access to home building compensation?
This is really outside his expertise. We know what Mr. Chandler does. Asking him
Trevor,
about
do you have a point of order?
Yeah, I do. This is
really
outside the terms of reference.
Well, to the point of order, it's not outside the terms of reference. This is an inquiry into building regulation and standards.
Well, I think it's within the terms of reference. I don't think there's any question it's within the terms of reference. But Mr. Chandler, I think, is in a position to indicate whether he has something he can add to it or it's within his remit. So
and he's already indicated what the answer
So
is.
I will. I think there was a separate question asked by Ms. Hughes, but Mr. Chandler's able to handle himself. Mr. Chandler.
It's not a subject that's in my direct remit, the Class 1 buildings or the Home Building Act. I'm really looking after the reforms in Class 2 buildings as the priority of the work that I've been set. I'm very happy to take a question on notice from you and get the right answer put back to you.
We're here for several hours this afternoon. Perhaps, Mr. Tansey, you could make some inquiries and find out how many complaints have been lodged with fair trading to date?
Yeah, I'm happy to endeavour to do that.
Okay, so can you tell me...
They have 21 days in which to provide answers, as I understand.
Yes, but I'm asking whether this afternoon we can ascertain...
So, look, if you're going to take a point of order, Trevor, that's probably better. What's the point of order? Yep.
We know what the rules of engagement are. We go through exercises each time of saying witnesses have 21 days. They're entitled to know that. This exercise of get back before the end of the day is outside what we agree as the standing practice.
Well, I'll just rule on that. You're all aware that the procedural fairness rules and indeed the resolution of the committee entitle you to take a question on notice and answer within 21 days. But I think you're also aware that we would appreciate wherever possible for you to be able to cooperate with the committee, and if information can be found to assist with the committee, then we would all be grateful for it, and it's well within a member's entitlement to ask for that assistance, and Ms. Hughes has done so. So if you can, Mr. Tansey, that would be gratefully
I can
helped.
ask. If it helps the committee, just in the interest of being clear, the Home Building Compensation Fund and that part of the Home Building Act is not within the allocation of the ministers the Minister for Better Regulation. So it's honestly outside of our portfolio's administration now, because responsibility is shared between CIRA and the Minister responsible for CIRA, and iCare and the Minister responsible for iCare. So just so nobody thinks we're trying to be unhelpful, it's honestly not something that Fair Trading directly
and
deals
Mr. Tansey,
Treasurer and Customer Service.
And Mr. Tansey, I'm asking you specifically about which complaints have been lodged with Fair Trading, which I understand someone who works under Mr. Chandler, Mr. Whitten, gave comments to Channel 7 last week and said encourage people to lodge a complaint with Fair Trading. I'm interested to know how many of those complaints have been lodged, how many home buyers in New South Wales are currently affected by this collapse. Mr. Tansey or Mr. Chandler, how are you coordinating with CIRA? How is Fair Trading coordinating with CIRA? Because you've just outlined that there could be some bureaucratic issues here.
Look, I'm sorry, I can take that on notice. I'm candid, I wasn't expecting this nature of issue to come up this afternoon, so I'm not across those issues. Happy to take questions on notice and find out about how it's being balanced between our complaints intake and CIRA, who actually oversees the insurance scheme. And of course there might be a distinction between people that would come to Fair Trading with a complaint generally about building or the completeness of building or incompleteness of building, but once there is a trigger event like this and the builder goes into some form of administration, as your question rightly points out, it will trigger
the potential for coverage by the compensation fund, which, as I said, is not something that we administer or are close up to. So there is a distinction there between how we would or wouldn't become directly involved in
Which goes to the heart of my question, Mr. Tansey, which is how are the two agencies coordinating? How are you making sure that people aren't falling through the cracks? Last week, they were being told to lodge a complaint with Fair Trading. This week, now that a trigger event happened on Friday, they are likely to be going to CIRA. We need to make sure that these people are not falling through the cracks and are being actually assisted by the New South Wales government. Can you tell us how that is occurring?
Point of order. I think that Mr Tansey indicated pretty much to the same question to the Honourable Courtney Hughes before that he would take the answer on notice, and he didn't have the information on hand.
Well, I think, to be fair to Ms Hughes, this question is about the coordination between the two agencies, and
which was the previous
Mr Tansey may be able to speak to it, and then Mr Chandler may be able to add something.
No, sorry, I'm trying to make some urgent inquiries, but I don't have information on
Mr
hand.
Chandler?
I've just sent a message to Mr Whitten asking me exactly the answer to your question, so hopefully that'll come back quickly. But we do have some discussions between CIRA and my office, mainly with interest looking at some of the work that we're doing in terms of risk management. But they're different ministers, and so therefore there would be no normal role for me in the dealings with CIRA.
And I've just, with the beauty of the interweb, clarified that there is a statement on the CIRA website directly dealing with Privium and providing very simple advice to affected homeowners about some basic facts of the matter, and providing both a 1300 number and direct emails and even direct claim forms for people who are wanting to be able to easily access assistance.
And that was actually where my original question came from, Mr Tansey, which was in that statement, it says they may have access to the Home Building Compensation Fund, and I'm interested to know whether they do or not, and what would be the reasons why they would not.
And that's a matter not for this witness.
And they have taken that on notice, and so I'm just making it clear. Mr Chandler, can I ask you then, in a letter provided to by the administrators to people who were affected by this collapse last week, they said they are, this is from the administrators, and I quote, working closely with the applicable building regulators in Queensland, New South Wales and Victoria. What contact has your office had with the administrators for Privium Proprietary Limited?
None.
None. Nothing?
None.
You're the Building Commissioner for New South Wales and you're not the regulator for this, is that correct?
Correct.
You said before, it's a Class 1.
So, Mr. I appreciate that we can get into technicalities about different classes of buildings, but for the average person out there, they would expect that the Building Commissioner would be able to provide some assistance. I just want to be clear, you have no assistance to provide to the people affected by the Privium Homes collapse.
Look, I'll take the point of order again. This witness has already answered these questions. The nature of this really, if it's intended to embarrass these witnesses, that's fine, but Mr Chandler has come along repeatedly to these inquiries, and given evidence with regards to a whole variety of complex matters.
I get the flavour of the point of order.
Well, to the point of order, this is not designed to embarrass these witnesses. This is on behalf of hundreds of families who have lost their homes, who expected to be there before Christmas. These are legitimate questions.
Order. Come to. Mr Chandler has now been asked 3 times about his role, and he's indicated very clearly that his role is restricted to Class 2 buildings and that the Privium homes are Class 1, single residences. I don't know if there's much further assistance we can get by putting that to Mr Chandler a 3rd time. Of course, the time is your own, Ms Hughes, to use. But Mr Chandler, did you have anything to add to your earlier statements?
Nothing. I can do whatever I can to help come back to you, but as I say, it's not my direct remit, and while I'm very disappointed to hear about this particular collapse, as I am with any collapse, this is not one that I'm directly handling.
So, Mr. Chandler, I'd like to turn to a slightly different part of the collapse. Privium Group had conditions placed on its licence. Now, we've established in previous inquiries that you do have responsibility for licensing of builders. Is that correct?
I have powers under the Home Building Act, yes.
But we have established previously...
I don't administer that part of the Act. That's administered directly by the department. That's not an area that flows to me. I have powers there, but they were just general powers that provided to me before, in fact, I was benefited with powers that came under the RAB Act and subsequent legislation.
So conditions on building licences should be directed where?
We'll take it back to BRD and I will come back to you with an answer. So I'm going to take that question on notice, if I may.
You may want to ask Mr. Tansey.
Mr. Tansey, do you have anything to do with building conditions on building licences?
Look, not as a day-to-day piece of administration, but I've got the licence check in front of me now, so I can see the licence and I'm broadly familiar with the licensing regime.
So there were restrictions on the Privium licence between 2012 and 2014. Are you aware of those? Are you able to access those?
I can look up their licence history, yes. Yep, I can see that going back to various conditions over time.
That's right. So can you explain why those conditions would be put on the licence?
Well, I can see different conditions at different times. I'm sure the ones, or I assume, the ones you're interested in are for periods where they either, it was only for contracts not requiring what was then called home warranty insurance, and there was some limits for a period to the class of building they could construct.
So perhaps, Mr. Tansey, you can provide us with those conditions. Can you just talk us through those different conditions that have been on their licence, please?
Yep. So for a period between 31st of March 2014 and the end of June 2014, there's a condition stating only for contracts not requiring home warranty insurance.
Sorry, can you just say that time period for me again, please?
The 31st of March 2014 to the 30th of June 2014.
Okay.
There is a condition here...
Sorry, can you explain why that condition will be put on someone's licence?
I can guess. One reason would be they might not have had eligibility to provide or purchase home warranty insurance.
So can you explain what that means, Mr. Tansey?
There are any number of all kinds of licensed builders in New South Wales who don't do work that requires home warranty insurance, either because the nature of the work is below monetary thresholds, the type of work they do is not covered by the home warranty insurance scheme. There might be periods where they might want to do that work, but if they're not able to meet some of the tests to gain eligibility for the insurance, then they can't do the work.
Okay, and what's the eligibility for that insurance?
Look, I don't have mastery of that. I mean, again, that's an issue that now has been administered by CIRA, and before that, iCare for a decade.
So that eligibility is determined by CIRA or by Fair Trading?
No, it's determined by whoever is regulating the insurance at the time, which as at today is CIRA.
The long and the short of it is, if they can't get home building insurance, they can't do residential building work, and there's a limitation on their licence.
Correct. It's required to be covered by the insurance, and so the public register records that fact.
Okay, but then the assessment is done by CIRA, and the information is then provided to you as the licence, as the regulator.
Right. There has to be an interaction between the two regulators, because the licence, which is administered by Fair Trading, and the insurance, which is administered, as we said at the moment, by CIRA, have to go together to make somebody potentially wholly eligible. And if they're not eligible to do work that's covered by the scheme, then that's a condition on their licence and noted on the public register.
I wanted to ask about, it's been said publicly that there is a Fair Trading investigation into this. Do you know anything about this investigation?
No, I've not been involved in the investigation.
Mr. Chandler, do you know anything about
Really
the
not part of
investigation?
this portfolio. I just have to ask you respectfully that this is not part of the portfolio which I'm working in, but I can tell you that there were 16 people as of last Friday who had registered as a result of the invitation for people to register their names in regard to that collapse. But just could say, please, this is an inquiry dealing with Class 2 buildings. My remit has been clear since the day of my appointment, and I can just ask if, for the purposes of the most productive use of time, your call, but I'm happy to sit here and say it's not my remit for as long as you wish. But
could I just
Mr.
ask one question arising from this, Ms.
Sure.
Vissers? I suppose the issue is this. There's been a reform agenda for Class 2 buildings. You have the carriage of that, Mr. Chandler, and we will talk about that at length. We have here, though, up to 700 people who have incomplete homes. They're Class 1 buildings, standalone dwellings. That collapse, the indicators for that collapse were happening months ago with this builder, yet it seems there was nothing in place from fair trading to pick it up. Is there a significant gap in protections for this part of the industry, Mr. Tansey?
I'm going to take the point of order. And the point of order is this. As good as these witnesses are, they are public servants. Now, the rules of procedural fairness make very clear that public servants are not obliged really to answer questions that go to issues of policy.
Well, I'll rephrase the question.
I know the question is somewhat rhetorical,
but I'll rephrase the question.
But it's unfair on these witnesses to.
I'll rephrase the question. All right, I'll rephrase the question. If this was an apartment building, we may have had Mr. Chandler seeing the warning signs months and months ago with a failure to get finances in place. Significant warning signs were in place months and months ago, and if it was a Class 2 building, Mr. Chandler may have picked it up. What resources are there in fair trading to pick up the same kind of warning signs, which in this case could affect 700 homeowners in the Class 1 industry, Mr. Tansey?
Yep. So, I mean, there are practices in place between fair trading and CIRA on, coordination and collaboration on issues. We have regular meetings, okay? And there may well be greater knowledge in the agency than I personally have today about any indicators of concerns about the builder, previous inquiries or complaints we would have received from homeowners, any other dealing and investigation into it. To be frank, I hadn't thought that this might be the focus of the inquiry today. I had thought we would be talking about cladding and certification and engineer registration, so I haven't come as prepared as I might have liked to be if I'd known this was going to be the line of inquiry, but happy to take on notice greater questions about complaints or inquiries or indeed investigations underway.
Well, the media reports say that fair trading was aware from at least early November, so I suppose I'm going to ask you, Mr. Tansey, what are the resources in place in fair trading when those kind of early warning signs happen to respond and protect homeowners? What are the resources? Where do we look to in fair trading for this kind of protection?
All right, so complaints on, as you know, the broad remit of fair trading, complaints on any matters, complaints and inquiries will come through both our call centres and our complaint handling units, which can triage complaints according to the different areas. Complaints about problems with building can be referred off to either building investigators or the building inspectors within the organisation. We will sometimes proactively get intel from inspectors or investigators when they're out and about dealing with people about any concerns or early indicators of builders not performing. So they come through our front door, they can come straight through our operational people and can be turned into profiling of the activities.
Mr. Tansey, I don't think there's any issue that complaints were coming in. The question is, though, what resources and powers are there in fair trading to protect people in that? So what was the response? Everyone knows complaints went in. The question is, what happened in response?
Mr. Shibridge, I don't want to get into a place where through well-intentioned ignorance I give you
I'm not asking you to
information.
speculate.
So I'd really much prefer to take on notice questions about the complaints received, in particular how they were dealt with. I just don't want to give you
I appreciate it.
advice.
I don't want you to guess. We want
interest in
evidence.
trying to help.
Mr. Tansey. Ms. Hughes.
Can I just ask, Mr. Chandler, so what monitoring do you have of builders' licence in Class 2 buildings? If conditions were placed on a licence holder for a builder who was building in Class 2 buildings, what oversight do you have or what communication do you have within fair trading to red flag these builders with you?
Well, I'd report to you that the red flagging and attention has been substantially improving over the last year as the intelligence capabilities of the regulator have improved. So there are no red flags that I'm aware of at the moment, but the difference between a Class 2 delivery and a Class 1 delivery is that in Class 1 you make progress payments, whereas in Class 2 you don't have to settle until the project's finished. So the safety valve there is that if the builder didn't get to the end, then the consumers wouldn't be required to settle.
But Mr. Chandler, what we're actually talking about here is that there is a builder who has had licence restrictions over many, many years, and we now have...
Talking about Class 1, which he isn't in, hasn't got a line of
We'll
sight.
wait to the end of the question and then we'll...
There is a licence holder here who has had red flags on their licence over a course of years and has now collapsed. What is in place to ensure, would you normally be notified if these kinds of licence restrictions were on a builder in the Class 2 space?
Not normally, no.
Okay. So can you tell us, and I'm happy if you take it on notice, either Mr. Chandler or Mr. Tansey, how many building licence holders have conditions on their licence at the moment? No, they're regulated by fair trading. How many builders?
Well, I think that's a question to Mr. Tansey.
Yeah, I'll have to
Tansey.
take that on notice. You're talking about tens of thousands of licences and, yeah.
Can you provide us with the total number of licences and the amount and the number of them with conditions on them, please? Okay. Mr. Tansey, there are a number... I will provide some context for both of you. There is obviously only 16 people apparently who have made complaints to fair trading. It's estimated publicly that there are 145 at least homes in New South Wales that are currently under construction. But what's emerged overnight is that there are a large number of other people who have paid deposits and don't have access to home building compensation, that the builder hasn't taken out this insurance on their behalf. This is extremely concerning because it's likely that these people who paid their deposit have lost their money entirely. Would that happen in an apartment building? Would you lose your deposit in an apartment building if this happened?
Well, the deposit will be held in trust by, so you would get your deposit back for a Class 2 building. If the developer failed to perform, you're talking about now a developer versus a builder, you make a deposit with a developer and that's held in a trust account, except for a couple of people who ignored that rule until a few years ago, but a purchaser of an off-the-plan apartment puts their money in trust on deposit and that is held separate away from the developer until such time as the developer completes the building, at which point they get an occupation certificate and then they can call on the purchaser to settle. But so that's the cover that's there as the safety valve for deposit in Class 2 buildings. It's different to Class 1 where you make progress payments.
So the people who have possibly lost their deposit entirely would not have lost their deposit if it was in an apartment building. Is that what you're saying?
Well, if they'd have bought an off-the-plan apartment, the money would have been held in a trust, which was not available to the developer until the developer then was in a position to call on settlement where the funds join the settlement money at the end of the project. Very different delivery model for Class 1 and Class 2 buildings. Class 1 involves progress payments, so you make a deposit and then you make progress payments. Now, the risk there, of course, is that if the builder falls over along the way, then you're caught in the calamity that these people are at, and I think it's something that's work to do. I'm personally not enthralled with the situation that they're in, But in terms of Class 2, the circumstances are very different. They don't lose their deposit.
But if you're purchasing in Class 1, the deposit would be held by a real estate agent and held in a real estate agent's trust account.
If you buy land, then your deposit will be held by the real estate agent till you settle. But if you buy a house and land package, or you buy a house
separately,
that's a different exercise.
It's not a contract for sale, is it?
Yeah.
No.
Mr. Chandler, one of the things that you have been talking about to address the issues in Class 2 buildings is the rating system. And that's already been raised this morning. But can I ask you, given off the back of these kinds of collapses, which are not uncommon, would you consider expanding the rating system to Class 1 buildings to provide these homeowners with more protections?
Well, that's again...
That's
again a policy.
It's another minister, that's all. It's just, it's not my election to do that. Minister Anderson is responsible for Class 2 buildings, and...
But I also think the point Mr. Khan is taking is that really is a policy question, and we have here the members of the public service, members of the public service, and they're not in a position to provide the policy. There seems to be compelling reasons, Ms. Husos, but you can't ask these witnesses to back you in on that.
Mr. Tansey, perhaps you'll need to take these on notice. I'm interested in the scope of the investigation. Are you able to provide on notice the investigation into Privium Homes, when it was established, how many people are going to be working on the investigation, whether it will be headed by Fair Trading or by CIRA, what the scope of the investigation is, and what is the reporting date?
Yeah, I'm happy to take that on notice.
Thank you. Sorry?
Have you finished on this? Because I was going on to a different point.
I've got one more.
Okay.
In the letter to the homeowners, they were told that the letter from the administrators to the homeowners that some of the contracts have been transferred or in the process of being transferred to a different construction company. Is Fair Trading playing any role in supporting the homeowners to find new construction companies to complete their builds?
I'll have to take that on notice.
Okay, and if you can tell us how many of those have been assisted?
If I can, just in case it helps us later, emphasise the point again that when it comes to administering the claims of homeowners and some aspects of the orderly management of claims, that's going to be done by the insurance regulator, CIRA, not by Fair Trading. So there may just be an important kind of demarcation point there, but happy to take as much as we can on notice.
Okay, Dave.
Thanks, Mr. Tansey, for that. Commissioner, you're aware of the large planned community, I think, in Rosebery, constructed by Otto?
The Otto project.
The Otto project,
yeah.
Yes. It's described as, on its website, as a brilliant master planned community with a lot of very positive commentary on it. There have, however, been substantial interactions between your office and the developer there. What's the state of play?
Well, it's a pretty unfortunate situation there because this building was built by a company, and I'll just refer to my notes because I just need to make sure that I get the names of the entities right because it's quite a complex exercise. Icon Construction Australia New South Wales Proprietary Limited were the builder contracted by Capital associated with the Christian Life Centre to undertake that project. Icon Construction Australia New South Wales Proprietary Limited went into receivership at the end of last year. Now, this is a complex and messy exercise, Mr. Shoebridge, where these owners have been caught in a situation where Icon Construction Australia New South Wales sold its business essentially to the Kojima group of companies. And what they managed to do was to take the business and leave the responsibilities of the company behind it.
Basically, in some ways, asset stripping, leaving the liabilities behind and taking the actual business.
Correct.
Yeah.
And but there are many complexities around it because then the business that was purchased by Kojima went on to become the core business of a company known as Icon Co New South Wales Proprietary Limited. I have to keep referencing notes because the number of Icon Co's are quite a lengthy list.
Mr. Chandler, I spent some couple of hours trying to chase down this myself, so I failed. So please take us through.
So I managed to put this together as best I can. Now, what happened is that all the employees and the officers of what I call the old co were transferred to the new co, but the responsibilities of the old co were left behind with that. There are significant defects in Otto 2 which are publicly known, and I attempted to get a commitment from the directors of who I thought were the spokespersons for the new co-business, that they would undertake to fix those defects. Whether it was my naivety in asking those questions, but there was no clarity ever made as to which company was speaking on behalf of whom, but I dealt with a director, Mr. Julian Doyle. He was part of the Olco company, and he took up a directorship with the new company and held that directorship for nearly 5 years. During the course of that time, the new company that housed the business that was acquired undertook Opal Towers. It undertook projects at 1 to 31 Victoria Street, Roseville, at 23 to 41 Linfield Avenue, Linfield, and 659 to 669 Gardeners Road, Mascot. Now, I have been attempting to meet with the directors of Newco to ascertain where this company is going, because during the course of 2020, a new company called Icon SI Australia Proprietary Limited started to take on the new business that was acquired by the company. And there were no Australian directors left in Icon Co New South Wales Proprietary Limited at the end of last year. So I had a call from Mr. Doyle about November to say to me, I'm no longer a director of Icon Co New South Wales Proprietary Limited, and I have just had the old co placed into receivership. I was not very happy about that because it was simply wasn't the cards played the way that I thought they were being played, but that's the reality. So fortunately, we've been able to issue a Building Works rectification order to the developer Capital, and that has at least motivated now an advancement of, hopefully this week, an offer will go on the table to the owners of Otto 2 to at least try and address the significant defects in that building. I don't think that's going to make them whole. It's going to be a very disappointing situation, and I have a long way to go to get to the bottom of this. But during the course of it, Icon Co's legal representatives have weighed in to try and get me to agree to relinquish my powers to refer directors of that company to organisations like ATSIC if I find that they've not appropriated themselves properly. In fact, I have a copy of a deed that the lawyer for Icon sent me to say, would I please enter into a deed and pledge not to use my powers to refer these people, if I decided they needed to another agency.
Trying to bind the hands of a statutory official.
Absolutely. And I basically said, well, good luck with that. I'll see you in the Supreme Court if you wish to actually form an injunction. They've withdrawn on that matter. But, you know, since then, I've made it my business to go and look at these other projects that have been built by the people who were the vendors of the old company. And very similar defects are present in the buildings that I've named. And those buildings are also in litigation. So this company now has Opal Tower in litigation. It has the Victoria Street Roseville project in litigation, the Linfield project in litigation, and the Gardeners Road Mascot project in litigation. And if anybody had heard the interview the other night on Channel 9, you would hear that the owners at Opal Towers are some $5 million into the cost of litigation. The owners at Otto 2 are nearly $1 million into litigation. And my urging to this company has been, why don't you stop spending your money on litigation and go and fix the defects?
Well, this is a company that just has it engages in wrecking people's financial lives through these defect-ridden buildings. Are they currently in the process of constructing any current dwellings?
I understand that they're tendering for new work, and there was in fact a new project potentially announced in their name that they're the preferred contractor on. They're now contracting under Icon SI Australia Proprietary Limited at the moment, so they're not contracting any new projects in Icon Co New South Wales.
Mr. Chandler, is there a role for a kind of banning order to be considered? Because for me, I find it...
You asking this question.
For me, I find it... Well, I'll rephrase it. Do your powers currently allow you to issue what would in effect be a banning order and say, Icon Proprietary Limited, in whatever form it is, or including companies closely associated with it, shall not continue to engage in the construction sector in New South Wales?
Well, there's a process that we have to go through as a regulator, so as you know that we've got to apply natural justice. So we are currently in the process of conducting post-occupation certificate audits on these three projects. In the event that the defects are confirmed, and I've been out and had a look at these, and I have to tell you that I expect that there will be orders placed on the developers of those projects, because the RAB Act actually goes to the developer who engaged Icon. And as is the case for Otto 2, the developer Christian Life Centre has had to step up and take the responsibility for the defects that are present in that project. And unfortunately, they will also have to step up and face the consequences, because just across the road there is Otto 1, which has similar defects in it. And I just haven't got to that project because I wanted to deal with one and then deal with the other. I'm actually going to get a researcher to write up the customer experience of the Otto 2 project and publish it, because I think this needs to be on the public record as to just exactly what these owners have been through. But I did meet with the owners committee on Friday, and they were hopeful of advancing a resolution of the Otto 2 project defects with the developer in the next week. And they did express gratitude to the fact that had it not been for the RAB Act powers, they wouldn't be in that position. So I think everybody collectively in this room has had a little finger in that pie.
Mr. Tansey, in terms of the department's oversight of, let's pick Icon, for example, leaving this, pathway of financial ruin and wreckage behind it, what's the department's role in driving those kind of players out of the industry? Is it all with the building commissioner, or does the department have a separate role?
Look, as you well know, because we've talked about it extensively before in this room and others, for the last few years, we have all been a scrum behind Mr. Chandler here, and our focus has been his focus and vice versa. The direction of the reform agenda, particularly into the Class 2 segment and these kinds of issues.
Well, I suppose the concern I have in this, and I say at the outside, I tried to find my way through that tangle, and I couldn't, so I appreciate you finding your way through the tangle, Commissioner. But there should be some kind of preemptive protective power. The thought that this corporation is out there tendering for work right now and potentially putting another couple of hundred homeowners through the same ringer, I find untenable. Is there a kind of protective measure in place that you can call upon, Mr. Chandler?
When we get to the bottom of this, there will be a couple of things that we will probably make some recommendations about. I think the days of simply being able to buy the company out of a company and leave the shell behind should be something we need to look at closing down. I don't think that should be, I mean, they just simply closed off the statutory warranties by ring fencing the company and putting it into receivership. I think we should have a look at that. We're also making some inquiries to FIRB to have a look at what were the conditions on the sale of the business to Kojima. At this stage, FIRB haven't been overly forthcoming in the information we've sought, so we'll continue to press there.
The Foreign Investment Review Board?
Yeah, and then the next area that we will go, subject to us, if we see any particular inappropriate behaviour of the two directors who were both directors of the Icon Ulco and the Icon UCO, that's Mr Julian Doyle and Mr Nicholas Brown, if we find any inappropriate actions by either of those two gentlemen, then it would be my intention to refer them to the appropriate regulator.
Which brings me to a question, Mr Chandler. Are you in a position to table the deed that they sought to have you sign?
Yes, I'm happy to table that. I mean, I just think this is the moment I got this, I just looked at it and said, you are joking. This really should be on the front page of the Sydney Morning Herald.
Did it come with some correspondence?
Sorry?
Did it come with some correspondence?
It came with a covering letter outlining that unless I agreed to enter into this, that they would take the matter to the Supreme Court the following Tuesday at 5 o'clock.
Would you be in a position to table both those documents?
I'll take that on notice and provide that extra document. I just pull that together to provide to the committee. But, I mean, really, this is actually the first one of these that I've seen like this. I mean, there's other players out there who've left a trail of companies behind them, but, you know...
This is brazen.
You know, this Icon company that went broke, that was put into receivership last year, was previously known as Icon Southern Cross Proprietary Limited, Southern Cross Icon Proprietary Limited, Icon Southern Cross Proprietary Limited, and ultimately Icon Construction Australia Proprietary Limited. It had more names than the Scarlet Pimpernel.
They're not very creative either, are they?
Are these all single-purpose vehicles?
No, these are PTY Limiteds. These are entities that would not. No, these are not SPVs for the purposes of a development. These are just companies for the purposes of conducting an ordinary business.
Yeah, but they, in this case, a sort of a variation on phoenixing, where they actually sold the business and left the liabilities behind, rather than.
I mean,
so they took all the goodies from it.
You really need to read, everybody should read the receiver's report on this particular insolvency. I mean, what really got up the nose of the residents who are trying to get some money back to fix their defects was that there was a sum of approximately $200 for the staff fund that ranked ahead of their particular claim.
Yes, and yes, and you did mention this was the Opal Tower.
This is the builder of the Opal Towers.
Yeah.
And if you simply added up all of the litigation that is surrounding these 5 projects, it'd be a very large number.
But you see, Opal Tower was how many years ago now? 2 and a bit years ago?
December 19, wasn't it?
Yeah,
December
18.
18.
December 18. So the better part of 3 years ago, the main players associated with the construction of the Opal Tower are still out there.
Yep.
And indeed, they're leaving this trail of wreckage behind them. So I come back to this point, Mr. Chandler. I appreciate the work you do. I know how detailed it is. You've got Icon 1, 2, 3, 4, 5, 6, 7, 8 to chase through. But where is the protective powers to help consumers to stop this happening? Where does that lie?
Well, we've made it clear on a number of fronts that there should be caution taken, and so, for example, I've been briefing the banks over the last 6 months, not on this particular matter, but on pointing to them that organising a developer's loan requires them to have a better line of sight to the delivery of projects than perhaps they have in the past. It's in other cases, for example, well, pretty well universally, the banks require that all contracts for development finance have to be conducted under a design and construct contract. Now that's an arrangement of convenience for the banks, which I don't mind. I think that's an appropriate exercise, as long as the company that is being engaged to do a design and construct contract has the competencies to do them. Some do, some have lesser skills, and some have no skills. So I've been making it clear to the banks that since the RAB Act came in New South Wales, they should pay much more attention to the character, capability and financial standing of the contractor delivering the job, because if the job is delivered up at the point of occupation certificate and it's got substantial defects in it, then the consequences of that are that the project won't get its occupation certificate. So we now have quite a deal of attention being paid by banks. So I expect that by the time we've introduced the rating system, that banks, well, I know that one bank has advised me informally that they've moved to say that they will not lend to another project where the developer doesn't have a rating. I mean, why would you if there was such a piece of information available? So very shortly in New South Wales, we are going to have this capacity for consumers and financiers and insurers to look at the ratings of the developer and the builder before projects are backed.
And this is because their security essentially is under threat if either you step in or alternatively you don't give them a rating.
Well, in the case of, for example, the Acre project at Bellevue Hill, which was a project we went into at the end of last year, that was being financed by one of the major banks. We did an OC audit on that project and found substantial defects in that project, and we subsequently issued a prohibition order on that project saying that until these defects are fixed, then it's our intention for that project not to achieve an occupation certificate. Now, at the time, one of the major banks was the lender into that, and they explained to me that historically they looked at the quality of the lend being substantially the assets that were available to the bank in the event that the developer defaulted. They never really paid any attention to the quality of the builder and the developer's likelihood to turn up with a decent building. They were really looking at it through their lens. But I've got to say that over the last 6 to 9 months, the banks have moved to a position where they're now paying much more attention to this, because when we do have a project where there's a prohibition order, like the Acre one at Bellevue Hill, that could be another 6, 9 or 12 months before that project is going through. Now, the bank in this case was fortunate at the Acre, where the developer actually had enough cash to pay out the bank's loan and the bank left. But the project is still sitting there, stopped today. It's got a stop work order, it's got a prohibition order, and it's got a building works rectification order, and all of that has to be sorted out before that project turns into completion. Now, that message is getting out there loud and clear, and banks are paying attention.
But until the rating system's in place, until you stack up that part of the work, we've got players like Icon who feel sufficiently empowered that they threaten you with Supreme Court injunctions and Supreme Court proceedings, and you've got the backing of the state government behind you, well, we hope.
I assuredly do.
Yeah, good. But where does that put a single homeowner? I mean, they just must be getting run over in this process unless you intervene.
Well, Mr. Shoebridge, there's sort of many elements that, that my digging up over the last year or two has sort of thrown up areas where there is work to do. So the introduction of the Residential Apartment Buildings Act was the first step in tidying this up, and it is having a significant impact across the industry. It really is. The introduction of the Design and Building Practitioners Act is now standing up, and it is having an equally significant change. So I think what's happening is that we've got incremental things that have been done, but historically, consumers haven't had the benefit of an independent risk rating for the players. Now, governments are not people to provide that risk rating. That's not what governments do, and people who provide those ratings, like Equifax, are regulated players. So you would want that rating provided by a regulated player. Now, the 80 to 90% of good players in the industry are now moving to realise that, in fact, having a rating is the thing that sets them apart from people that will never have a rating and never should. I'm hoping by the end of next year we've really redefined that landscape such that that exposure for consumers stops. Now, there'll always be defects, but we're well into this reform exercise, but there'll always be defects. The really good thing about this, though, is that the people who cause them will be around to fix them.
Well, one of the concerns that's been raised with my office about the rating system, which is, as I understand it, it's a voluntary system that you're proposing at the moment, where the builders and developers put their hand up to be rating. Is that right?
Correct, yep.
Therefore, high-quality builders who feel they can get a 4 or 5 star rating will put their hand up and get rated. Their properties will sell at a premium. Those who feel like they will fail the rating system, or probably feel like they should fail the rating system because of their building quality, will sell their products at a lower price without the premium. And therefore, the risk is those people who can least afford to have a building with defects will be the ones who cop it, the ones who can't afford a premium property.
Well, I disagree with that view because, first of all, ratings are something that we've been working on, as you know, since day one, when I provided you a briefing and the other committee members a briefing way back, is that they needed to be designed by the industry for the industry. So Equifax have engaged banks, insurance companies, owners corporations, lawyers, contractors, developers. This is not something that's just sort of come off the wall. This has been...
I'm not pushing back against a rating system.
Yeah.
What I'm suggesting to you is, by having it as an opt-in system, you create 2 classes of buildings: those that are premium without defects.
I disagree with that.
And those for those who can't afford those buildings.
I disagree with that.
How do you prevent that?
Well, the first thing the first thing you should be doing, and which we will be doing, will be making it clear to consumers, first of all, you have a choice. Now, there is no elitism at all with the rating system. The rating system is designed specifically not to be elite. So, for example, a small development company that might do 20 or 50 apartments a year could enjoy the same rating as someone who's doing 1,000 apartments a year. What the rating system's looking for is the character, the competencies and the financial capacity of those organisations to work at the level at which they're working. So we've had lengthy conversations with the industry as to what does this industry look like in 3 or 4 years from now, when it's producing north of 25,000 apartments a year. And the industry advice back to me is that we need potentially 150 quality builders and 150 quality developers. We don't need the rest, but let's assume that we've got people who are stepping up and getting rated, who are right across the spectrum. And we're talking about people who provide economy type product as opposed to premium product. So what happens with these sorts of things is then they become a condition of lend. So then we have a situation where the banks are starting to step in and say, well, why would we finance a project where the developer didn't have a rating or the builder didn't have a rating? Now, as we move forward in the next year, the regulator's efforts now, as we discussed way back when I first started, was that we wanted to create a situation where the regulator could apply its best efforts where the effort is most impactful. So the more people that are at this end of the spectrum who've got rating relieve the regulator from a lot of its load, and we can now focus on the people that are at the bottom. My view is that there's potentially 10 developers, 10 builders, 10 certifiers and 10 engineers that probably represent 80% of the defects that I've seen. If we were focused on just them, then we're starting to extinguish the pipeline of stuff that's caused so much grief in the past. Now, the other thing about the ratings is that we're saying to developers, this is not just simply have a born-again moment, get your ratings and we forget the history. We're also saying, if you want to be rated and you want to have the regulator out of your face, then you've got to go back and fix some of your legacy projects. Now, I can't go into details at the moment on that, but you're aware that we've introduced a a tool which is a enforceable undertaking. You've seen the first of those applied at the Skyview project at Castle Hill. Expect to see more of the enforceable undertakings entered into as we get developers to realise you've got to go back and clean up some of your mistakes of the past.
Mr. Dowden?
So I just wanted to clarify, the rating system's actually a private system. Is that right? So how is it that your office is having such a directive role in the construction of the system?
We always set out to encourage the market to come up with a private sector-led rating system because now Equifax have been a first mover, but we've been talking to Moody's and Standards and Poor's, etc., to say, you know, there's room in this market for you to be in the play as well. We're agnostic as to who provides this, but we are absolutely resolved to encourage the private market to do this. Now, the reason why is that the next step in this exercise is the decennial liability insurance, which the Minister's recently announced. And the insurers will start to price the premium for that product based on the integrity or the rating of the contractor. Now, when we first put this ratings initiative to the market, of course, people were saying, oh, but what if I don't have a 5-star rating? What if I've only got a 4? Well, the first couple through have got a 4 and one of them got a 3. And we've had to say to them, look, if you had a 1 or 2, you'd have a problem, but a 3 is a good starting point. You can start to build your business because the ratings provide advice to the company about how they can improve their business. I mean, one of the companies, for example, had a trail of companies that were over 15 years old, SPVs that had finished, there were no problems on the project, but he was just leaving them hanging around because he thought it was a bad thing to close them down and clean them up. When in fact the rating said, look, having the shadow of those around is not a good thing, that's affecting your rating. But the other more important thing is that this particular business, they said, look, you outsource 80% of your work, but you don't do any credit ratings of your trade contractors. We see that as a business risk. So the builder says, wow, I hadn't thought about that. So he's now out getting credit ratings on his supply chain that does 80% of his business. So he will progressively graduate up to a 5-star.
Is it fair to say, though, that the rating system's actually there to serve the finance sector, not to actually serve the consumer? Its primary purpose is actually to give assurance to the finance sector.
It's always been a consumer-facing exercise.
Ultimately, isn't it going to just serve those interests primarily?
No, it's going to serve the consumer. It was always designed to serve the consumer.
But you're not actually designing the system. Equifax are designing
the
system.
We've been very much involved in we've been invited to participate in the design of the system from day one. It is very much a consumer-facing exercise, as you would. I'd be surprised, for example, if the owners' corporation network were anything other than very enthusiastic about the fact that this is truly a customer-facing product.
Does this have trade practices implications? Like, so if someone's got an unfair rating, it's clearly going to have an adverse impact on their business. How do they actually rectify that?
When you have a rating system provided by a regulated player, then APRA regulates that rated player. So if somebody is unhappy with their particular rating, so this is a regulated rating as opposed to, say, a TripAdvisor type rating where it's based on what someone thought 5 minutes ago. A regulated rating system is one that's accountable and has to be reported. Any complaints about a rating and the resolution of those ratings must be reported to APRA on an annual basis. This is a really rigorous, fair, regulated process. Government couldn't possibly do this, and I'm hoping now that other ratings agencies can see that there's a market for this product, we'll actually get some other players in and increase competition.
So if it's APRA regulated, does that mean that
of this style of rating? Sorry, my apologies. Is there any other example of this style of rating being applied in other industries or the like? This is not a criticism of it.
Look, not in the construction industry that I'm aware of. This is, and New South Wales actually leading everybody on all of this. Let me call it out. There's people looking over the fence right now saying, "Hey, you got a handle on this in New South Wales." And
even the Victorians.
I don't want to go talking about our colleagues interstate, but You watch in the next 2 or 3 years to see if this doesn't catch fire.
Sorry, have you finished, Anthony?
Oh, I was going to ask just in terms of the data. That's the source of who actually owns the data. Is that will be Equifax will actually own?
Yeah, look, that's a really good question. So let's just talk about exactly what data exists out there, right? So there's two types of data. There's what's called non-consensual data. Now, we are holders of large amounts of non-consensual data. The New South Wales regulator would be one of the holders of the largest assets of data in the country, but that's non-consensual data.
Can you just be clear about when you say we hold it? Who are you? The New South Wales government generally,
the
or
department? So the regulator. There is the investigations unit, which we have one of the very, very fine investigations teams. They serve a number of people who draw on this information, so someone applying for a liquor licence or whatever. So it provides services to other parts, but particularly to the work that we're doing. Now, with the ratings that that you can get from someone like Equifax or Moody's or whatever, I mean, very, very few companies make an executive appointment these days without actually getting someone like an Equifax to do a search on the individual and come back and say that they've got particular backgrounds or not.
Apart from Cricket Australia.
Or Shane Warne. But so when you move to seek a rating of the type we're talking about through ICERT, which is the product that's being developed by Equifax, it then steps into what's called consensual data. So that means you provide another layer of data for which the organisation consents to give, because there are limits to what non-consensual data can tell you. So the rater would say, well, here's a list of questions that we would like you to inform us on. So the party being rated provides that information by way of consent. Now, that's particular and peculiar only to the ratings agency for the purposes of the rating. So all of this is absolutely ethical, it's conducted properly, it's regulated. This is a real coup. If, we will pull this off, and New South Wales consumers will be far, far better. We've got the first of these developers. This is how far we've got. We will be launching this in about 2 weeks. The first of the developers now has already got their company rated, and they've got their current new 2 projects SPVs rated, because the thing that we were finding was that on the brochure for a project was, this is another project by the Dreamworld Group, but the company that was developing the project was XYZ SPV Proprietary Limited. Now, the consumer had no choice at all. They got excited about Dreamworld doing this fantastic project, but suddenly they get a contract with XYZ Proprietary Limited on it. We're requiring for this rating system that the developer publishes the rating of their SPV on the brochure for the sale of the apartment.
Say where, but actually you mean Equifax is insisting on this?
Well, Equifax are providing the rating, but we are calling out to the industry, the consumers, the financiers, the insurers, and saying, well, this is now available. You can elect to do transactions with your eyes shut or your eyes wide open. This is monumental. I don't know. I just can't. I could spend the rest of the afternoon sharing my enthusiasm with you about this. This is absolutely durable. It's going to be long-lasting, and it's going to be game-changing.
I mean,
can I just ask? So, sorry, you just were saying it's required to be published on the brochure. So it's a voluntary system for now.
We're saying to developers, Ms. Yusos, that they should publish this again voluntarily, because we will be calling out to consumers and saying, if you are dealing with a developer who is not publishing their rating on the brochure that you're buying, beware.
Oh, sorry. So it's a. Let's just be clear though. It's a voluntary system. I understand your excitement about it, and
I'm
but
sorry,
I'm just.
I should go and have a lie down in a Bex or something.
No. I just want to try
Maybe
and.
afterwards.
I just want to ask some specific questions
Please, yeah.
about it. So it's a voluntary system. You just rated the one developer so far, and there are two
No,
SPVs.
There are a number of boats already tied up at the docks at the end of the Derwent. There's a number of boats in the Derwent, and then there's 100 or so between Sydney and the edge of the Derwent. So there's a big crowd moving towards rating. So this is not something that is just on the drip now. This has got momentum.
Okay.
Nobody mentioned the Bass Strait.
Maybe we should just talk in specifics rather than analogies. So the system itself will be a voluntary system. Is
Yes.
that correct?
Yep.
And it will be voluntary about whether you disclose it or not.
Voluntary whether the developer discloses it or not.
Yes.
Yeah,
will that information be publicly available elsewhere?
Only their rating will be publicly available. That will be held on the Equifax website, so a consumer can look on the website and say, that developer's got 3, 4, 5-star rating.
Okay, it'll be on the Equifax website. Will it be on a New South Wales government website?
There's no need for us to host it on our website. It'll be publicly available information.
Okay.
Just quickly on this point, though, so you're saying that only the developer will be rated, so the SPV won't be.
No, I'm saying that the
rateable.
developer, we're pressing for all SPVs to be rated.
But will that be available on the Equifax website
Yes,
or not?
yeah.
Okay, it will.
Yeah,
Okay.
so-
sorry, that was just a clarification on what you were saying.
I've actually seen the artwork for the first couple of these, and it's just exactly what we imagine it would look like. It's got the developer's brand on top saying another one of our developments. This project is being developed by this particular SPV, and here is this SPV's rating. Now, the rating of the SPV, of course, is then linked carefully to the corporate entity, and the thing that this is really driving is the fact that the umbilical cord that exists between them now is going to be substantial as opposed to insubstantial. This is a huge game change.
It assumes a level of due diligence from the purchasers of apartments that, I mean, we've had the purchasers of the House Street development before this inquiry, and I think it seems that you're just assuming a level of due diligence that's perhaps not necessarily there in the market, and that there will still be exploitative operators out there that you're relying on this system to eliminate. That it seems they will still be there and able to prey on those
I don't think
who
so.
haven't exercised that due diligence.
I don't think so. This will be normalised in the market. I'd expect that anyone who's going to be offering a mortgage to a purchaser to say, you're buying an apartment off a non-rated developer. Are you really serious about that? Look, these things take a little bit of time to mature, but the moment they do, they change the game forever. You really have to, and I'm happy to spend more time with you and talk to you about detail on this, but probably more time than justified here. But this has been the product of 2 years of work. To see this now coming over the fence, the state of New South Wales should be well proud of this particular piece of achievement, and this is going to go much more beyond the state of New South Wales, and it's going to become the main plank that is going to give insurers the confidence to support a decennial liability insurance product. And at the same time, the other thing it's going to do is it's going to ensure that developers properly engage consultants to fully document their jobs and build compliant projects. That's what it's going to really drive.
So, Mr. Chandler, I take it from that you're saying that the ecosystem is going to change effectively. So the banks are going to say to somebody that they're lending a mortgage to, effectively saying, okay, is this a 5-star, 4-star, 3-star rated development? You're going to have lawyers and conveyancers going through looking at the Equifax website on these projects as well, that the whole market will change in that regard.
Correct. I mean, but I don't want to degrade the fact that someone who gets a 3-star rating is, as far as I'm concerned, good to go. It's a very good quality rating, a 3-star rating, and there's an opportunity for businesses to mature their rating over time. So there'll be some players that'll come out with a 5-star rating on day one, some will have a 4, some will have a 3. I don't think anyone will be running around town with a 1 or a 2, but 3's good to go as far as I'm concerned, and that's a huge step forward for this industry.
Well, could I suggest we may return to this if we have time, but there are a number of matters I think we have an obligation to raise that were raised in the evidence today.
Yeah.
Can we address some of those? Mr. Tansey and Mr. Chandler, I'll first go to you. Interior designers and the Design Institute of Australia raised with us concerns that there was no accreditation model for them. And whilst architects and other industry players had an accreditation model, that without an accreditation model, that they were being frozen out of interior design work in Class 2 buildings. Have they raised this with you?
Mr. Shoebridge, yes, they have. There's been discussions, as in fact there has been with all of the different stakeholders in building up the design, building practitioners regime. So yeah, I'm aware of that, and I did have the opportunity to listen into some of that testimony this morning.
It struck me that they had a very credible and reasonable case to present to allow for them to get an accreditation, an industry-based accreditation, and they had a model that would stack up. How advanced are the discussions about getting that happening? Because for me, when we passed that legislation, it wasn't to put a bunch of interior designers out of business. They weren't the focus of the legislation.
And if I well, they're not being put out of business because, of course, they can continue to do their work and have it signed off by an architect who's registered under the scheme. So there's nothing stopping them doing their work. And we are also giving some thought to probably a more moderate carve-out than they, I think, were advocating this morning and in our discussions with them. So, you know, for example, looking around some elements of commercial fit-out that might be suitable to take out. But I think there is some nuance to the argument, that, including how I saw them making it this morning. We don't see entirely eye to eye with them with the idea that all of their work is simpler or more straightforward, such that it doesn't have a significant impact on the building. And so our view is we're open to, you know, continue to have those discussions as we have been, say, with the architects, who I know you were talking about some elements of their feedback on the scheme now, but we're not at this stage minded to set up that specialist line of registration for interior designers, because we still think there are issues, and we're satisfied that they are perfectly capable of continuing to trade and do their work, but they need to do it
under the auspices of an architect.
to have it signed off and declared.
I'll just add a little bit to that. So.
Yeah.
Well, that seems if they're doing, if they're doing penetrations or removing walls, that seems to be reasonable. But if they're doing just simply interior design work, as more commonly understood, having to do that through the auspices of an architect seems to be an inappropriate restriction on their work in Class 2 buildings.
We are having conversations with the market on this, Property Council and others on it. I personally think there's a sensible workaround on this. I'd like to get that to a point where it's clearer, but my experience with construction and buildings coming to completion is, for example, if you use a shopping centre where you don't have a number of let shops at the time, but what you do is that the area that is set aside for a shop or multiple shops, you can bring that to a point where you can have the critical infrastructure of fire, safety and all of that all resolved, and perhaps we can take the view that then to fit that space out, which requires a DA, could possibly be accommodated. So look, I think let's just let this move without everybody getting too excited about it. We want a solution.
All right. And is there a time frame for that?
I would hope by middle of next year that would be able to be done. Look, they can continue to work, and I think what we need to do is to make sure that we end up with a well-considered response where we receive some considered representations rather than just simply the first couple of views from first people to the room. So, Mr. Shoebridge, I just think that we should have a proper consultation period on this.
All right.
And sorry, if I can add again too, I think the other thing is that, and this goes to the point of us being really alive to not wanting to unnecessarily restrict their work. It would only impact on their work if the work they're doing involves the building elements, as the Parliament gave them to us. So there would be a lot of scope for them being able to do work that doesn't require regulated designs or declarations unhampered, but it would be where they start to hit those key elements that their work would be touched on by the design and building practitioners regime.
So what are those key elements?
The structure, the waterproofing, the building enclosure, the fire services, and the key services in the building.
So I think they used the example this morning of, effectively in their work that they're moving walls around. I imagine there's a distinction between whether something's a supporting wall compared to whether it's just a fabricated wall.
If it's an intertenancy wall, if it's an interspatial wall, which was built with a fire rating with the intent of separating one use from another, then that wall would be caught by the Act. But if it was walls within that space, then not so.
I think there's a degree of ambiguity that they have, and I think that's why a registration system that made it clear what the boundaries were would be of significant benefit to the industry.
Look, we should do it sooner than later, but I think we'd want to go through a proper consultation process.
Yeah. And if waterproofing's the issue, remodelling the bathroom could potentially raise the whole issue. And I've never known an interior designer that didn't want to remodel a bathroom. So I think they have a valid case.
Well,
and
most
I think
shops don't have a bathroom, but so I think you're leading to waterproofing, are you?
I think that there's furious agreement there's a legitimate issue there. That
for shop fit out.
And also for doing 2 or 3 apartments in a residential building. They may come and just do a specialist job in 1 or 2 apartments, and that's where they're having trouble as well.
Well, sure, but I'd rather consider that space as what you call coal shell space. Just it's unfitted out space, because I think we're going to see the coal shell application move from just simply in retail to residential. I think there's a case, for example, of considering more coal shell opportunities, particularly for say disabled people and NDIS fit out, where why would you want an apartment fitted out for one use and then have to tear it all out for a subsequent use? So I think we just need to contemplate the broader idea of coal shell as we move forward to clarify this.
The architects, the Institute of Architects raised very real concerns, some with the structural parts of the Act, and I don't think we're in a position to debate that. But one of the issues they raised was with the requirement for architects to have 5 years of recent and relevant practical experience in Class 2 residential buildings before they could be registered. They point to the very detailed and ongoing registration, licensing, certification that architects have to go through, and they push back against that 5 years experience. Where are you in terms of conversations with the Institute of Architects?
We're nearly there, to be honest, in agreement with them. So we're actively looking at making a change, much as they were characterising it this morning, where we can have regard as an eligibility assessment to a range of work in other classes that are broadly relevant, and it'll be about getting the right balance between the numbers of years of experience in those other classes. But yeah, we're very close to just agreeing with them that how they can import that and eventually, essentially broaden the pathway through which architects can get into the scheme.
And that accepts the merits of the core part of the architect's argument, is they're one part of the industry that is highly credentialed, highly regulated and insured. They seem to be...
And hold its members to account.
And hold its members to account. Absolutely. Yes, we could talk about private certification, but they do seem to have they bring a very valid argument to the table. Do you agree with that?
Professional body
Yeah,
ethos.
yeah.
Look, and we agree with that. And I mean, it's probably material to the interior designers thing. So, as you all well know, I mean, this is a very new scheme. It feels painfully familiar, but it's still pretty fresh. And it is apologetically about bringing greater transparency and accountability to more players, but not just everybody. So I guess we're just trying to take a measured view about when the primary architecture is there, where we can tweak it around the edges. With the architects, we're pretty much there. With the interior
But that conversation
designers, not so
accepts that core merits, the core merits of the architect's argument, that they have long-standing, effective industry regulation. you accept that core argument coming from the architects, Mr. Tansey?
What about some of the other areas?
Very credible players.
Yes. Sorry, Ms. Cunt.
What about some of the other areas where we didn't seem...
Well,
actually, I'm seeing we've got representatives from...
I was just going to go to fire. Is that all right?
That's...
Yes. And I'm sorry, Mr. Curtin, to leave you there for so long. The submission we got from the National Fire Industry Association was quite compelling, I thought. One particular point that they wanted was to require a commissioning certificate for any new installations or major refits of fire protection systems. Where do you stand on that? And having it done from somebody with Cert 4 qualifications?
I guess our experience is that we see a lot of non-compliances, and we see maintenance issues across the sector on a day-to-day basis, and any activity and certification that can bring that to a level where we see compliant and maintained systems provide a safer environment for the community and for fire and rescue firefighters.
Well, do you support the idea that there should be a commissioning certificate? What they were saying, let's be clear, is they often find on the 12-month certification, they send someone in with the appropriate skills, Cert 4 skills at the 12-month level, and they find out that whatever the hell was signed off...
No, Cert 3, I think.
Sorry, Cert 3. Whatever the hell was signed off by the certifier at the construction point had a very modest degree of relationship with the approved plans and major variations between the approved plans and what was built. But if you pick that up 12 months down, you've already had a building in occupation for 12 months and it's much harder to fix it. That's why they thought, and it seemed to be a compelling argument, to have a commissioning certificate.
I guess the detail of that I'd have to take on notice and come back to you with a detailed response, but anything that's done to align the way the building's designed to be built and the fire safety systems are designed to make sure they're maintained appropriately is best case scenario for us.
Are you aware of concerns that were raised by the plumbers, the CPU, about 6 kilometres of fire protection systems?
Just before you get onto that, David, I've lost my my witness list, but the issue with regards to
Mr. Smith?
Yes, Mr. Smith. He only talked about it in terms of being, what was his description?
Teething problems?
Sorry?
The fire...
Yeah.
With the fire regulation system.
Yeah.
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 Fire accreditation system, sorry.
Well, no, it wasn't the accreditation. It was actually non-compliance with the design was being picked up, and he talked about it.
Rather the certification system, wasn't it?
I think
it wasn't being certified.
that was the point he said.
Yeah.
That the 12-month inspection
Yes.
picks up a whole bunch of non-compliance, but the non-compliance is from the moment of installation. Are you aware of non-compliance being picked up at the certification process?
No, not through that
Chandler
process.
might be. He seems
Mr. Chandler?
Yeah, look, we're seeing in the field non-compliances at the certification process. Now let me also make the comment that I've just run into a building that was certified by a local government as well, so it's sort of an issue that doesn't seem to be the domain of private certifiers. But we have been giving a huge amount of effort to fire safety, and in the next month we will issue a report on reforms to improve fire safety in new and existing buildings, which spans all of those issues that we've had Michael Lambert working on for the last 6 months. It's a very high quality piece of work, and hopefully it's going to drive some changes in a positive direction.
Is it your understanding that it addresses this commissioning certificate?
Yes, it does. It sets the best practice objectives that we're looking for. Again, let's get that report on the table, and happy to take any direct questions from you or other committee members as soon as that's on the table, because I haven't had a direct hand in this because it's been a big piece of work that the director of my office has been working, and Fire and Rescue have been working very closely with us on this. We're collaborating on a range of fronts now, and let's have a look at this piece of work, Mr. Shoebridge, and happy to take questions as soon as it's available.
Right. Did you say Christmas Eve for that one, Mr. Chandler?
Sorry?
Did you say Christmas Eve that was being delivered?
Oh, no, and it won't be a Friday either, so no, we'll try and get it out
Thursday,
on a useful day.
Might be another press
Thursday,
conference. You never
In
know.
fact, if you'd like, I'll deliver a copy personally to you.
Thank you, Mr. Chandler.
It would seem that if that commissioning
Can I add myself to the
certification issue
distribution
were
list?
You absolutely may. I would be delighted to bring a copy to you personally.
Oh, so that's sweet.
It would seem that if this commissioning certification issue was fixed, it would actually resolve a number of the issues that Mr. Drury raised. Not all, I'll make that, but certainly that seemed to be strong amongst his. And I think seems to be a legitimate point that it not only goes to value and quality of the building, actually goes to a significant safety issue, not only for residents, but for the fireys themselves. It doesn't seem unreasonable that we fix something as fundamental as that. I think you're probably in uproarious agreement, I think.
Well, I am. The thing that strikes me by your comment is that what I'm seeing with the implementation of the Design and Building Practitioners Act, that this stuff is getting a lot more clarity and locked in very much earlier in the project. So I've now sat in just as an observer on 3 audits of declared designs, for example, and the detail and making sure that people actually address the requirements are becoming far more locked in through this process under the Design and Building Practitioners Act. Again, it's going to take a year or two for everybody to get on the tram, but we're going to have very high quality buildings in New South Wales.
It may take longer than a year to get on the tram.
Sorry?
It may take longer than a year to get on the tram, from
18
what we
months,
understand.
18 months.
Don't mention the trams.
Can I
Sorry.
just ask you, Mr. Chandler, this work done by Mr. Lambert, does it investigate fire maintenance?
Yes.
So that was
Yeah, we
also
tried to do an end-to-end project, Ms. Hughes. So what struck me was that there were gaps all the way through, from the design all the way through to the maintenance. And I asked a working group of fire industry practitioners to come together and say, let's do a map of where all the gaps are, where are the training gaps, where are the accreditation gaps, make some recommendations that can be implemented quickly, but also put some discussion papers out there of things that need to be considered in a subsequent round. So let's get the document on the table. I'll deliver your copy personally.
I'll look forward to it. Mr. Chandler, so that was a specific recommendation from the Plumbers Union, was that the fire maintenance workers should be licensed as they are in Victoria and as they are elsewhere. You know, we do want to find the best possible standards. So that's the licensing the tradespeople across the course of the building, the construction of the building, and then holding them accountable for their work absolutely has to be a key part of the
And I think the next phase of that work is to look at, when the strata titles legislation is being reviewed, is to just what the duty of care of the people in the building are, the owners corporation and the strata managers, about how do you maintain this kit, because quite often good reliable kit's installed, but then it goes on the slide downhill in terms of maintenance. So I think the next big piece of work we're going to be looking at will be, beyond the new build, will be the maintenance backlog.
So as part of that work, are you looking at a building manual, requiring a building manual from the builder or from the developer to be handed to the Strata Committee?
That will be available as part of the role of the contractor now declaring their designs and handing their work in. Yeah, that'll all be available. Yeah.
So that will be part of the lodgement on the e-planning
manual,
portal? Okay. And
the documents in one discoverable place will be the first starting point.
I understand that. Do you have a time frame for that, Mr. Chairman?
Well, I hope that we'll have all of this stood up by this time next year.
Okay. And okay. Sorry, did you want to jump in? Yeah.
Mr. Curtin, the Plumbing Trades Union gave us some very unsettling evidence about 6 kilometres of the fire protection system in the City Metro line being installed by unlicensed workers, not plumbers, no certification at all. And that's the dowsing system, like the emergency fire suppression system in a tunnel. Are you aware of those concerns?
No, we haven't heard about that. Not until today.
Is it surprising that you hear about it the first time? 6 kilometres of core fire protection in a major public transport system that's being built at the moment. Is it surprising you haven't heard about it till today?
Probably not surprised we haven't heard about it. We would have someone have to bring it to our attention for us to know about it. We've got a team that works closely with infrastructure projects, mostly fire engineering design, and then in commissioning at the end of the project. We don't have an inspection team that goes through tunnels or other projects along the way.
Would it be your expectation that that major fire suppression infrastructure would be built by somebody with appropriate licensing and credentials, in this case plumbing?
We would certainly have an expectation that it meets the required performance solutions when it's commissioned. We would rely on that both for community safety and for firefighter safety when we need it. I would expect that a person who's certified would provide a better outcome than someone who's not certified.
Well, that sounds a very ambiguous position to have. If your only position is how it works at the end rather than who actually built it, that's your position? Is that your position, Mr. Cotton? You're only worried about the end product, not who built it?
One of the challenges for us is that unlike buildings above the ground where we have the National Construction Code and a lot of rigour around the regulatory system, it's a little bit less rigorous in subterranean infrastructure. We rely on contracts and arrangements with Transport for New South Wales and contractors for engineering reports. It's a far less regulated environment for us.
So when the Plumbing Trades Union told us that the contractor in these public-private partnerships basically said, we're not bound by the construction code, we can basically press on regardless, that probably reflects the law, is that right?
It probably does. Yeah, it's less regulated there. I wouldn't know in terms of the plumbing standards whether you have to have someone certified in that area.
Can I just ask Mr. Chandler? It just interests me because I'm not being rude when I ask this question. I'm not quite sure why, but I've met a number of engineers from actually above ground infrastructure projects who've designed and been responsible for the installation of, I'll call it, fire control systems. At least 3 of them have been English. And I noticed Mr. Smith today was English as well. Is England the source of a lot of our qualified engineers in this area?
Well,
And
it's
if so,
interesting
why?
that Engineers Australia don't have a chartered engineer fire. So it's one of the areas that we're working with Engineers Australia to backfill. So Western Sydney University's fast-tracking some qualifications, but the main qualifications in Australia can be got at Queensland University or across at Christchurch's University. That we haven't had a university dedicated to fire. So we're working with Engineers Australia to get that chartered fire engineer, just as we are trying to get a chartered facade engineer. So these are very, very well-developed career pathways in the UK, and also in the US. So we're seeing a pipeline of people coming from there. But if you find somebody that really knows their stuff, they've got a background in the UK.
Facade engineers is a good segue to cladding, but before we go there...
Just before that, I have to say, I very much respected what the Plumbing Union had to say, but there's more on a building side than the necessary trades. I've got to say, if you've got a fire engineer on that site, you've got a level of skill in these projects. I am concerned if it's suggested we've simply had some TA, I forget what the term was, TA and somebody else putting in 6 miles, and crane driver putting in 6 miles of piping. That actually is very unlikely to be a proper reflection of the facts.
Well, we might ask Ms. Kern if you could take on notice any information you have in that regard, because on the state of play at the moment, it is exactly as troubling as Mr. Khan suggested, and he's tried to fill the gaps quite heroically, but we'll see if that's true or not.
I'm not. Yeah. But it does seem to be there. It's more people than on site than a crane driver and a TA.
Mr. Diallo.
I had a question just that arose from a question that I asked the Owners Corporation Network about it arose in the discussion around providing training for body corporates for strata committees, and I wanted to, and perhaps Mr. Tenzi can take this on notice, about whether the strata legislation, Strata Scheme Management Act at the moment actually constrains the capacity of strata committees to pay for training, governance, that training that's necessary to support the governance functions of the strata committee. And an adjunct to that is whether the legislation actually constrains the expenditure of administration funds around supporting the work of the Owners Corporation Network. So with that systemic advocacy that is clearly necessary from an owner's perspective, in fact, the current statutory arrangements actually inhibit those kind of payments. So perhaps if you could take that on
happy
notice.
to take that on notice, and just for completeness, tell me that issue, that nest of issues, and I did hear some of that evidence this morning too around the training and skilling of people, and I think the kind of the vicious circle of it being a disincentive to people taking on the role. So those issues arose and have been considered at length in the Strata legislation review. So when that's tabled shortly, that we'll have another platform for discussing
Not this
all
week.
that as well.
Do you have a timetable for that?
I'm hoping in the next couple of weeks of sitting. It's due to be tabled by the end of this year. if memory
This
serves.
week is
So
the
it'll
last
be
week.
this
You've
week
got
or next.
tomorrow,
Won't be doing
I think,
it
Mr.
tomorrow.
Tansey.
Yeah.
Is it tomorrow?
I think tomorrow is the government business day for the end of the year.
I hope.
Just further to that, I just wanted to also ask about, Ms Stiles also spoke about the Strata register, and I just wonder whether you could provide some further details about what's happening with the Strata register. Is that a statutory process, or what's the basis for the Strata register being established, and what kind of time frame are we looking at for a Strata register?
So that's been out for 2 cycles of consultation, and the most recent cycle, which was on a draft paper and proposed set of information collection, only closed in the last couple of weeks. If we can get the drafting finished, we would hope to present a reg to introduce, bring that all in before the end of this year. So we've only got a couple of executive council committees to go, with a view that it starts in the middle of next year.
Ms. Yusuf.
Can I ask you, Mr. Chandler, for an update on how many properties are being remediated under Project Remediate?
There are 155 projects that have applied and have been accepted for Project Remediate, and there is a number of other projects that are still being considered. If you just give me a minute, let me pull up the...
Can you tell me how many applications?
Just let him. He said, give me a minute.
No, but
I'm just asking as he pulls up the information.
I should have had this open, I'm sorry.
If you can just say how many applications were received.
So, there are 290 buildings that have put their hand up for consideration. Quite a number of those buildings were considered previously and not considered by the cladding task force as being high risk. 155 buildings have been confirmed and have signed or indicated that they're going to proceed. 46 of the buildings that have been assessed so far have been considered not eligible, and the cladding task force is currently reviewing a further 89.
So are they not eligible on the basis that they're not high risk?
They're not high risk. No.
Okay. And how many have actually started? How many have actually started work?
And by work you mean physical construction?
Physically removing
Remediation,
some cladding.
well, sorry, under Project Remediate or just under Remediation?
No, how many, under Project Remediate, how many buildings have had some cladding removed from them?
We have taken cladding off buildings for testing and triaging for 7 or 8 buildings at the moment, and we should have a further 26 done in the next month. Now that's where we lift the cladding and we do a detailed look at underneath the building to inform the design process which follows.
Okay. So it's still in the testing phase, no?
No, we're not in the testing phase. We're in the scoping phase. Now, this is where a lot of buildings have lost their way in this cladding remediation. We've got one building in North Sydney, for example, that's decided to go its own way, which not a problem because it probably didn't have the chance to get involved into remediate early enough. So this is not a criticism of them, but their project has gone from $1 million, I understand, to $2 million simply because the scoping effort was inadequate. Now we're finding that's the biggest issue here, is that people have started these projects without an adequate level of scoping. So the very first thing we're doing in Remediate is to actually go and have a good look at the building with appropriate expertise to define the scope of work that's required.
No one would criticise Project Remediate as being too hasty, Commissioner.
Mr. Chandler.
Well, the people who I deal with that I'm pushing along sort of feel that they've been beaten up for haste. So you can see this coin from both sides.
I've never heard that complaint ever.
Well, I'll organise a meeting for you for someone who feels well and truly driven.
Mr. Chandler, no other global or Australian jurisdiction has recommended solid aluminium over composites. What was the reason that you decided to go with solid aluminium?
Well, you know that we gave you a briefing on this matter and you were well satisfied, so I'm just wondering where did this arise again? Because we know that there are product vendors out there that are continuing to haggle. Now, last week I had the very person who was in here this morning in a face-to-face briefing, and he left the room saying he was entirely happy with our approach. We made it very clear that solid aluminium is not flammable. It doesn't need any further testing. What we're trying to do at the moment is to do some reference testing on a couple of other compositions of aluminium to make sure that they are suitable if they're to come in. So it really is quite offensive for people who are just flogging their wares to come in and confuse the conversation by misinformation.
Mr. Chandler, I am asking questions off the back of evidence that this parliamentary inquiry
It is not evidence,
received.
it's marketing.
Well, it's evidence that was
It's
received
marketing.
under oath. It was evidence that was received under oath earlier today.
How many times are you going to recycle the same conversation?
Well, I think it's probably fair, Mr. Chandler, and look, you take your line of questioning, but in terms of what was presented to the committee today, if there's anything that you want to correct from what was presented to the committee, maybe this is a good opportunity.
Well, Mr. Kind of put the issue as I understand it very clearly. The issue is that it seems to me that the best test for a facade, a system-based facade, is the AS 5113 standard, which looks at the wall and the system in place. And the question is, will Project Remediate test all panel systems against AS 5113? And then we're doing apples with apples.
There is no need to test solid aluminium, and we're quite happy to provide you with a paper that we've concluded as to why that's the case. So I just don't know how many times we have to chase this rabbit round the hole.
Well, it rose in a briefing you gave to us, which, if you remember, there was the 5113 test, and it showed that solid aluminium failed the 5113 test. Now, we're going beyond Project Remediate here. We know the answer in Project Remediate. We know the answer in Project Remediate was to put barriers in place that expand. But outside of Project Remediate, thousands of buildings out there are having the aluminium facade test, and we saw the evidence that it failed the 5113.
Well, how about we complete the reference testing, and we'll make all that publicly available, and then we'll have the conversation. But, you know, I find it really quite offensive that you've got vendors of product coming in here and pushing their case when, in fact, they sit in a meeting with me, amongst others, and say, we are very happy with the fact you're not testing that, and we're happy to provide you product to test that.
But why not test all products?
There is no need to.
Under 5113, which is the system being tested,
There is
as opposed to
no need to.
1530, which is just the melt test. Why not? Seems to me the system should be tested, Mr. Chandler. And I don't understand the resistance to it.
The very highest quality solution, the safest solution will be applied to these buildings. There are many parts to the testing that's going on. How about you just look, the answer is I'm not doing anything different to what we said we're doing. With respect, we'll have the data that will support that.
I think we're both talking both within and without Project Remediate.
Exactly.
Mr. Tanzi, we understand there's a system in place for Project Remediate.
Thank you.
I'm on record as saying I think when you put those additional measures in place, that seems to get an adequate solution for Project Remediate. The question, though, is the thousands and thousands of other buildings that aren't part of Project Remediate, and we had Ms Coburn from the Australian Institute of Architects say it was her professional opinion that she wouldn't touch aluminium cladding because of all the risks associated with it. Yet it's compliant
I'm not
under
sure she's an expert.
Well, it's compliant under the National Construction Code. Mr. Tanzi, is fair trading doing something outside of Project Remediate?
Well, yeah, well, all other, so there's two other elements of this. So for residential buildings, so in New South Wales, residential buildings facing cladding rectification, we've issued guidance about making sure that people understand, first and foremost, that they're captured by the requirements of the Design and Building Practitioners Act, and that we will therefore have access or requirements for and access to declared designs and plans for those, and they will be the subject of audit. So we say that just to make sure that people understand that whether or not you're in Project Remediate, you'll be getting an elevated level of scrutiny around those designs.
When you started after the 1st of July.
Yeah, if you started after the 1st of July. And then...
Will that include satisfying AS 5113 for their systems? Does that include satisfying the wall test?
The entire rectification proposal that they're putting up. And then, I mean, outside of that, as we've discussed at length before, any rectifications being done has to satisfy the consent authority, which in most cases, but not all, will be the local council, that it meets the building codes and any other requirements that they want to put in place.
But we've seen from materials you produced, and you were quite transparent about in Project Remediate, that you can have a system of aluminium cladding without barriers behind that meets the National Construction Code and yet creates that chimney-like effect and a very dangerous fire spread. So I'm going to ask you again, Mr. Tanzi, what are you doing about the thousands of buildings that aren't in Project Remediate that are using that system?
All right, so I think this is the question about cavity barriers, by and large.
Well,
David, please.
Well, no, it's not. He's saying his question about it's about the aluminium cladding.
Fairly. Let him finish.
All right. So, as I said, we've got obviously intense scrutiny on those projects within Project Remediate for a range of reasons. We're then provided additional guidance out, and I think, if I'm right, in recent days or last couple of weeks, the Minister has written to every mayor of every council to make sure that from the top down to they're aware of the design and building practitioners related scrutiny of all of those projects, whether or not they're in Project Remediate. Things beyond that are going to be in the control of the local councils as the consent authorities, and are going to have to meet the varying requirements of the National Construction Code, which I know you're well aware of, depending on whether or not you go a performance solution or a DTS, to satisfy solution, will require cavity barriers on occasion, but not as the only measure. And as I think you're also aware, the next edition of the National Construction Code has been the subject of consultation and is being finalised literally this week through the technical committees. And within that consideration of improvements or enhancements to the code, New South Wales has specifically advocated in its administration submission to that process that cavity barriers be required in a greater range of circumstances than they have been in the past.
Perhaps you could give us some details upon what the precise submission is from New South Wales in that regard. But I might, if you could take that on notice, Mr. Tanzi. Mr. Curtin, Mr. Vice says, do you have a view about large facades of aluminium cladding with a gap between the cladding and the wall without cavity barriers? Do you have a fire safety view about that?
Yeah, our view is that compliance needs to be achieved with the National Construction Code, whether that's through the DTS process or the performance solutions. So we look at every case on its merits, and we don't specifically have a view on individual products on their own. We look at it through those performance solutions.
But the investigation from the Building Commission and the department was that those facades are compliant with the National Construction Code, but still may present a significant fire spread risk. Are you saying the beginning and the end of your inquiry is comply with the code, that's it?
For matters outside of Project Remediate, we review the matters as they come to us based on the National Construction Code. We've been involved in the cladding safety product panel, and I'm comfortable with the technical and the technical advice that we've provided into that panel to make sure we've got the safest possible products.
Ms. Usos has one question to request to be taken on notice, I think.
Mr. Chandler, if you can you said that there were 7 or 8 properties that were having testing and some panels removed of the cladding, and then another 26 to be done this month. Is that this month, as in November, will be completed?
Sorry, in the coming month. So, yeah, so it'll be done. Look, really getting on these sites with COVID has only just started to wind up. So we've done 7, and we've got another 26 log to do in the coming month.
Okay.
Now, this is not just testing the product. This is actually lifting up the panel and having a look at the other missing components. So on that project at Darlington the other week, for example, there was just aluminium. There was no moisture barrier. There was no fire barriers. There were no window heads. There was no drainage at the bottom of the facade wall. We want to make sure all of those things are identified so that when we design a solution, a multi-component solution for this replacement program, that all of those multi-components do their job and they're there.
Mr. Chandler, I'm not doubting the thoroughness of the approach for these particular buildings. I'm just wanting to get a sense of how many panels of flammable cladding have actually been removed. Are you able to give us that on notice?
We put the cladding back on for the time being. We wanted to lift it all up and have a look and see what's there. It's a matter of just bolting that down and then getting on with the design process so you can get on with ordering and replacing the material. So,
okay, so just to be clear, they haven't actually physically removed any of it. They're putting it back on the buildings
correct.
for now.
Yeah,
okay,
yeah.
thanks.
And the Minister's got a piece of it. I think he meant to share it with you.
He brought it to budget estimates. I don't know what he wanted me to do with it.
Yeah. Well, you took 3 pieces of cladding today.
I didn't
Might have
take
thought you
them.
were collecting. I don't know.
Courtney and I are each doing a collage in our offices.
Okay, great.
Could I thank you all for your attendance today? Ms. Chandler, I just read that effort of a deed. It's a hell of an industry you try and regulate. So good luck to you.
Hell of a solicitor, I've got to say, too.
And it's a hell of a proposal to get that undertaking from the building commissioner.
Audacious, would you call it?
I'd call it thuggish, actually, if you really want to know. That's actually the description I would call it. I would describe it as a thuggish
Covering letter would be
communication.
interesting as well.
So thank you for your evidence today. Thank you for your work. That concludes today's